Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Utah versus Kouri Richins. We are in day 14. They are starting at 1 o'clock their time, which would be 3 o'clock our time. And they're going to be going over jury instructions today. So we are going on 6 hours before they're supposed to start. And, 6 hours before they're scheduled to start. And we thought we would go over what's happened so far. So we're going to kind of do a recap. We've picked out some testimony for you guys to go through. So let's get started let's get started. All right. Actually, before we get started, Selena K has sent me some photos. Let me see if I can. This might be lame, but I'm going to try it. I'm just going to try and hold it up, and if it's too lame, then I'll download them and show you guys. All right, so here's. Let me see if I can sort this out. All right, so there's Selena. Gallery packed for trial. All right, so there's that one. All right. We've seen you in the court often, but let's see. Is that going to? There we go. There's Selena. Is that like salmon? Would you consider that salmon? Salmon colored outfit. Oh, and then Selena went to the Mirror Lake Diner. So this is where the sandwich was purchased at. Here's the menu. Let's see if that shows up. There we go. There's the menu. Right, and it was the eggs. What did she order? It was the eggs, right? Some kind of eggs. Was it eggs Benedict? No, what was it? Name your omelet. What did she order? She ordered something with eggs, ham. Let me see what did my notes show? Eggs. Really? That's not coming up? Bagel sandwich. Okay, so it was a bagel sandwich. Bacon, eggs, cheese, no mayo. So a bagel sandwich. Let's see if I can find the bagel sandwich. Bagel sandwich. Selena, did you find there it is. Bald Mountain bagel sandwich. There it is. Okay. All right, the Bald Mountain bagel sandwich. Let me see. Let it kick in. Hold on. Come on. You can do it. Come on. Hold on. There it is. Bald Mountain bagel sandwich. So the Bald Mountain bacon, eggs, pepper jack cheese, tomato, avocado on toasted bagel. So that's the bagel. That's the sandwich that Kouri ordered. Let's see, what else do we have? Selena, I'm not sure what you got, but it looks pretty yummy. So that's what Selena ordered. Wait for it to kick in. So that's what Selena ordered. That looks like a yummy omelet of some sort. And then this is pretty cool. So Mirror Lake. For all the tie-dye fans out there, that's pretty cool. And I guess that's it, right? Yeah, that's what we so thanks again to Selena. I just want to show this one more time. There's our Selena being interviewed. Here we go. Wait, hold on. Let it focus. Come on. Focus in. There we go. Oops. All right, come on. Focus. Trying to get to focus. It's focusing on me. There we go. All right, so cool. So thank you, Selena. Awesome. Those are fantastic pictures. Really appreciate it. So yay. Here's to you, Selena. Thank you for doing that. Very cool. All right. Who is with us today? Let's welcome in our chat. Let us welcome in our chat. Let's get ourselves over here. Who's with us today? Welcome in, everybody. Be sure to hit the like button on your way in. Show YouTube that you are a human being, and hit the like button if you don't mind. That helps the algorithms, and it helps show YouTube that you are a human and that we are here streaming and we are not bots. Shirley Roth, good morning to you. Alice, good to see you. Teresa, Never Police Videos, good to see you. Red Snap, Selena K, welcome in. Teresa, Iowa Backyard Cam, good to see you. Kimbers, good to see you. Nana, let's see. Beck, I got to figure out this name. Beck Shaver Charlotte. We'll go with Beck Shaver Charlotte. Welcome in. Nana, good morning. Happy Friday the 13th to you as well. Tammy, good morning. Downey Lynn, good to see you. Elaine, good morning. Good morning. Welcome in. Kimbers, Widespread Panic, good morning to you. Joy, it snowed in Atlantic City yesterday. Oof. That's nuts. It was chilly here. I woke up, it was like 60, I think, 55, 60. It was relatively chilly here. Tammy, happy Friday the 13th. Alice, good morning, good morning. Welcome in. Dove, good to see you. Wizard of Ezzy, welcome in. Angel, Lazy Boys, happy spooky day to you. Just want to make sure I get everybody coming in. Iowa Backyard. Mama C, good morning. Jill, not de Mama Klein, good morning to all. Now the follow-up question should be, what will the jury vote? Yes, what will the jury vote? Linda, good morning. Christine, good to see you. Brenda, Simon, good morning from South Texas. Good to see you. Barry, good morning to you. Kathy, good morning, good morning. Welcome in. Poppy Red Mustang, good to see you. Cindy, good morning. Pammy, good morning to you. Sherry, it was an egg sandwich. Yeah, it was a bagel. Well, we sorted that out already. Beach Mom, good morning to you. Green-Eyed Cat, good to see you. Lori, good morning, good morning. Welcome in. Kathy, I never paid more than $10 for a sandwich and never will. Yeah, 16, that's a lot. Bama Green Eyes, Angelique, good morning to you. Ari, good to see you. You would vote guilty? Wait, I just lost your post. Hey, Raj, Hector's mom, JP Rabbit. Anthony, good to see you. Dawn, good morning from Canada. Welcome in. JMS 34, where you are? That's cold. Radioactive, human here. Thank you for that. Iowa Backyard, being a human. Lazy Boys, you might be a robot. Jenny G, welcome in. Good to see you. Crazy Mary Joe, hello, hello. Clairview, good morning to you. Red Snap, you had to get your winter boots out. Alice, thank you for the 5 Trial TV Live gifted memberships. Ari, you got one. Awesome. Good job. Welcome in new members. And Ari, you just received a gifted membership. Fantastic. Thank you so much, Alice. That's much appreciated. All right, so let's hit the like button. Let's take a moment. Let's hit the like button. Oh, we hit 19,000 subscribers yesterday. Last night. So again, thank you for the support. Thank you for helping our community grow. And that allows us to keep bringing you guys this content. So appreciate your support, and welcome in. All right, let's get to it. All right, so today, while we wait for live trial, we're going to Aaron and I picked out some testimony that we wanted to watch. So we're going to start off with Kouri Richins Benson. Some of you were asking to watch her yesterday, so we're going to start off with her, and then we can either go to the medical examiner, or we could do Josh and Robert Crozier. We could do Todd Gabler. Chelsea, she's 3 hours as well. The medical examiner is 3 hours. So think about what you guys want to watch next. Ari, thank you for the $4.99. You would vote guilty on first degree and the forgery, not guilty on the attempted. Yeah, it was hard. We only have 4 fields. That's the problem with these polls. You only have 4 fields, so you can only. I feel limited with 4. I want like 6 or 7 or 8 fields. So. All right. So we're going to start off with Katie. We're going to rewatch Katie's testimony. So settle in, get comfortable.
Ms. Richens Benson, hi. If you'd step in front of Brittany, please.
Okay. Please raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the means and penalties of perjury? Thank you.
Feel free to move that chair wherever you're comfortable.
Okay.
You can also move the mic.
Okay,
There you go.
perfect.
Thank you.
Thank you.
Mr. Bloodworth, please proceed.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
What is your name?
Kouri Richins Benson.
And is your last name spelled Richins-Benson?
You got it.
Okay. I'm going to stand here because I would like you to address the jury. And I'm hoping that if I stand close to the jury, if you mistakenly shift to me, you're still addressing them.
Okay.
Do you know Eric Richens?
Yes, he was my brother.
Did you grow up with him?
Yes. Yes, we were only 2 years apart, so we were inseparable.
What was your relationship like as you grew up together?
So we did everything together. We went to school together. We worked on a ranch. So we have a family ranch that's been passed down for generations. We worked on the ranch together. We fished. We hiked. We did everything together.
How has that relationship continued into adulthood?
So my brother and I were very close. We talked constantly. We spent holidays together. We had our families together. So our kids are very close in age. We did lots of activities with our kids together. Like I said, we had them on the ranch all the time together. Talked on the phone almost daily.
What was Eric's personality like as an adult?
Eric was one of the most likable people. I'm sorry, guys. Okay.
There are tissues if you'd like.
Okay. So, he was one of... Sorry, I'm trying so hard. He was one of the most likable people you've ever met. So, Eric was the kind of person that loved everyone. It did not matter who you were, where you came from, where he met you. Everyone thought they were his best friend. If you talked to him, they all said, I'm Eric's best friend, because that's the way Eric made you feel. He was upbeat. He was positive. He literally would give a stranger he met on the side of the road his jacket, anything to help anyone out. That's the kind of person he was.
What did he like to do? How did he spend his time?
So, the number one thing that Eric loved was his kids. So he would do anything for his boys. He was the best dad you would ever see. He was a phenomenal uncle. if there were kids involved, he was there. He would show up. So whether it be soccer games, so he coached my nephew's soccer, and he was the dad that coached, that went and got all the signs that were special, so he'd get there before the soccer games, put all the signs up so the kids had their team name everywhere. He also was adamant about making sure they learned how to work. So my parents were very focused on teaching us how to work, to have that strong.
All right, so that audio is off. So I'm going to go over here and choose another. This is actually the one we stream, so this one seems to be more in sync. I don't know why that audio is off, because that's probably the
So
stream
false
we
or
use.
fraudulent pretenses, representation.
Excuse me, I'm not sure why that audio is off. So let's go over to the feed we actually streamed. So I don't know why that audio is off. It's weird. This audio will be in sync. All right, let's check this out. This audio should be in sync.
Feel free to move that chair wherever you're comfortable. You can also move the mic.
Okay,
There you go.
perfect.
Thank you.
Thank you.
Mr. Bloodworth, please proceed.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
What is your name?
Kouri Richens Benson.
And is your last name spelled Richins-Benson?
You got it.
Okay. I'm going to stand here because I would like you to address the jury. And I'm hoping that if I stand close to the jury, if you mistakenly shift to me, you're still addressing them. Do you know Eric Richins?
Yes, he was my brother.
Did you grow up with him?
Yes, we were only 2 years apart, so we were inseparable.
What was your relationship like as you grew up together?
So we did everything together. We went to school together. We worked on a ranch. So we have a family ranch that's been passed down for generations. We worked on the ranch together. We fished. We hiked. We did everything together.
How has that relationship continued into adulthood?
So my brother and I were very close. We talked constantly. We spent holidays together. We had our families together. So our kids are very close in age. We did lots of activities with our kids together. Like I said, we had them on the ranch all the time together. Talked on the phone almost daily.
What was Eric's personality like as an adult?
Eric was one of the most likable people. I'm sorry, guys. Okay.
There are tissues if you'd like.
Okay. So, he was one of... Sorry, I'm trying so hard not to cry. He was one of the most likable people you've ever met. So, Eric was the kind of person that loved everyone. It did not matter who you were, where you came from, where he met you. Everyone thought they were his best friend. If you talked to him, they all said, "I'm Eric's best friend," because that's the way Eric made you feel. He was upbeat. He was positive. He literally would give a stranger he met on the side of the road his jacket, anything to help anyone out. That's the kind of person he was.
What did he like to do? How did he spend his time?
So, the number one thing that Eric loved was his kids. So he would do anything for his boys. He was the best dad you would ever see. He was a phenomenal uncle. if there were kids involved, he was there. He would show up. So whether it be soccer games, so he coached my nephew's soccer, and he was the dad that coached, that went and got all the signs that were special, so he'd get there before the soccer games, put all the signs up so the kids had their team name everywhere. He also was adamant about making sure they learned how to work. So my parents were very focused on teaching us how to work, to have that strong work ethic. So he had his kids on the ranch, teaching them how to work. He loved the outdoors. He loved to play sports. Anything that revolved around his family, the outdoors, is what my brother loved.
Did he plan for his children's future?
Yes. So there's not a waking moment that my brother was not focused on his kids. So he had money set aside every single month to go into a fund so that by the time the kids got to college, they could pay for their college and hopefully have some left over for like a down payment on a house or something like that. He had every aspect planned. This is the kind of dad Eric was. So I told you we have a ranch. I love horses. My brother did too, but not quite as much as me. He liked ATVs a little bit better. So his oldest son, Carter, loved horses from the day he was born. He and I share that. So Eric tried to get Carter with me as much as possible on the horse because that's what Carter loved. I would ride the horse with my little nephew in front of me, and my brother would be to the side of me with an ATV with food, snacks, anything that Carter needed. He would have it right there so that Carter didn't have to get off the horse because he wanted Carter to be able to do whatever he wanted. And if Carter would fall asleep, which he would sometimes, Eric would take him into the side-by-side, hold him until he woke up, bring him right back up to me, put him back on the horse, and let him go the rest of the day.
Have you ever observed Eric sick or injured?
Yes. So my brother and I are very close. And so when he was an adult, he played sports all growing up. But when he was an adult, he liked to play adult softball. He did get hit a few times. He got hit by a ball, and these games would go to like midnight, 1 o'clock. He would call me at 1 o'clock in the morning if he got hit to tell me my leg hurts. I don't know if something happened, if it is broken a little bit, if it's just bruised, and I would answer the phone no matter what time it was and say, hey, do you need me to come get you? What can I do to help you? And he'd be like, oh, I think I can toughen it out. I'll call you in the morning and let you know. But honestly, it didn't matter if he was in another country. He called me from other countries to tell me he didn't feel well. So if his mental or physical well-being was ever in question, he would call me.
Other than allergy medication, have you ever seen Eric use an over-the-counter drug?
The only thing I've ever seen him use is Advil.
Have you ever seen Eric use prescription drugs?
No.
Have you ever seen Eric use illicit drugs?
No. Growing up, my mom was a drug and alcohol counselor. She taught us the dangers of those and really ingrained that in us.
Were you and Eric working on any future plans when he died?
Yes. So we were planning a trip to Disneyland that year to take our kids. He also has a child. His middle child, Ashton, is extraordinary in math. We were finding programs to get Ashton enrolled in that summer for coding so that we could kind of harness that math. He was only 7 at the time, but he's just outstanding. So we had just barely gone to the zoo together. We kind of just planned our lives together. We talked all the time.
Are you familiar with the home that Eric lived in when he died?
Yes, I owned it and I sold it to my brother.
Scott, if you can bring up 1-1, please, for Your Honor, for everybody but the jury. Do you recognize that photograph?
Yes.
Is that the home that you
Yes.
sold to Eric and he lived in?
Yes.
Is it an accurate depiction of that home?
Yes, it is.
Your Honor, the state moves to admit 1-1.
No objection.
1-1 is admitted. Bear with me. There you go.
Where, Ms. Richens Benson, is that home located?
That is in Francis, Utah.
And is it, it looks like it's on a cul-de-sac. Is it on a cul-de-sac?
Correct. It's on a cul-de-sac.
When did you sell him the home?
In the latter part of 2012.
Had you been to the home regularly between then and when Eric died?
Yes.
Do you know how many homes are on that cul-de-sac today?
So on that cul-de-sac, there's 7 homes with driveways that go into that road and cul-de-sac.
And do you know how many homes and roads were on, homes and driveways were on that cul-de-sac in 2019?
Yeah, all the homes were built out by 2016.
Thanks, Scott. Scott, can you bring up 4-1? Can you scroll through it, please? Ma'am, do you recognize that document?
Yes, this is my brother's prenuptial agreement with Kouri.
And how do you recognize it?
I saw it the day they signed it. So on the day of his wedding is when they both signed it, and I read through it with him on the day of his wedding.
Your Honor, state moves to admit 4-1.
No objection.
4-1's admitted.
I'm going to leave it up there just for a minute for the jury, but I'm going to come back to that with them later. I'm not going to
Okay.
discuss that with you, okay?
Okay.
Thanks, Scott. I would like to turn now to the morning that Eric died. Did there come a time in the early morning of March 4th, 2022, that you received a phone call about Eric?
Yes, it was early in the morning.
Who called you?
My dad did.
What did he say?
It's not easy. He was screaming and crying and said, "Eric's not breathing, Eric's not breathing."
Where were you when you received that call?
So, my daughter was sick. She was only 3 at the time, and she'd just thrown up. I had taken her out of her room and brought her into my room, and I had just set her on the bed, and my husband had gone into the room to check on my other daughter that was a little bit older to make sure she was okay. I just set her on the bed, and I had my phone with me. I set it on the bed, and I saw my dad calling, and I picked up and said, "Dad, how did you know I was up with my sick little girl?" And he started, whew. That's when he said, "Eric's not breathing, Eric's not breathing." And I screamed. I fell to the floor. My husband heard me and came running in, and I was screaming, "He's not breathing." My husband thought that it was my daughter since she had just thrown up. So he ran over to her and said, "She's okay, Katie, she's okay." And I said, "No, it's Eric." And so I picked up my daughter that was right there. My husband went and got my other baby out of bed, and we ran out of the house.
Did you go to Eric's house?
Yeah, we went straight to my brother's house.
Who was there when you arrived?
Sorry, guys. This was the worst day of my life. I'm sorry. When I got there was a bunch of emergency personnel, police officers, and Kouri and her mom, Lisa, were there.
Did you see the boys?
That was one of the first things I did, was try to find my nephews. They were in Ashton's room. I don't know how to orient you guys to the house. So as you walk in, Carter's room was to the right, and then you walk down a hall, and Ashton's room was the first room on the left, then it was Weston's room, then a bathroom, and then my brother's room. So the boys were located in Ashton's room. So there were police everywhere, there was EMS. I didn't know everything that was going on, but I didn't want the boys right there where everyone was. There's police right outside their door. So I went and got them and took them upstairs. So in my brother's house, you go up some stairs, and over the garage there's a bonus room. And they had everything in there. They had a TV, a Nintendo, all their toys in there. So I took them up there because I didn't want them by all the hustle and bustle of all the police and everything. So I took them up there, got them situated, then ran outside to my car to get my husband and my two daughters so that my husband could watch the boys and make sure that they were okay.
We'll talk more about the boys that day in a minute.
Okay.
Were you able to observe Kouri Richins that morning?
Yes, I did.
When you walked into the home, what were your immediate observations of her?
So like I had told you, we had gone on plenty of family vacations together. Kouri had been on the family vacations with us. I walked in, I kind of flung through the door, and I saw Kouri standing on the other side of the staircase. She just shook her head at me. Sorry guys, bear with me, I apologize. And I knew right then my brother was gone. And I fell to the floor. She stayed over there. I observed that she was not how she normally was when we would go on overnights. She was very well put together. She had a matching pajama-esque outfit on. Her hair was all done up. She wasn't crying like I was. She wasn't hysterical. Just stood there and shook her head no at me.
What, if anything, did you observe about Kouri Richins' interactions that morning with her boys?
There weren't any until later in the morning. So, like I told you, my husband stayed up with the boys. I went up and down. My sister came up and down. A few people came up and down to check on the boys. I did not see her go up and check on the boys. And I repeatedly asked her, when can we tell the boys? I think we need to tell the boys. I kept coming down saying, I think the boys need to know. It wasn't until they wheeled my brother's body out, and I stood by the stairs, at the top of the stairs, to make sure my nephews didn't come out to see, because we didn't want it to see, and my husband was in the room with them. So they wheeled my brother's body out. My husband did his best. My daughter was throwing up, and he was trying to block it from the boys so that they didn't see my brother being wheeled out. The boys did see my brother being wheeled out. My husband came out and told me that they were upset. And so we walked down and talked to Lisa, Kouri's mom, and Kouri again, and I said, the boys are really upset. They just saw Eric wheeled out. I think we need to tell them. And Lisa said, I guess we better. And Kouri said, yep, bring him down. So then we brought him down, and that's the first I saw her interact with him.
Were you there when Kouri Richins told her sons that their father had died?
Yes, so my husband and I brought the kids down. We're sitting on a couch, and in my brother's living room, they have a couch that kind of goes like this, like kind of curves around. So my husband was sitting on the edge with our daughters. I was sitting next to them. Weston, my brother's youngest, that was 5 at the time, was sitting in between me and Kouri. Kouri was on the other side, and then the other 2 boys were in front of us.
And what did she say?
She let them know that their dad would not be coming back, that he was gone.
Just like that?
Yes, to my recollection.
Did there come a time shortly after that when she spoke alone with her middle son, Ashton?
Yeah, so right after she told the kids, Ashton got upset and went to his room. So his room was that room that they had been in. I went and checked on Ashton multiple times, and he was, I remember him on his bed. He was on his bed with his covers pulled up, and I sat on the bed and I tried to console him, but he wanted his mom. I tried so hard to console him, but he wanted his mom. So I came out and told Kouri that Ashton was very upset and I thought she should go in. Took me a couple times of coming out to tell her, and I finally came out and I said, Kouri, I'm not his mom. I'm not his dad. He just lost his dad. He's very upset. I cannot console him. Can you please come in and talk to him? So she came into the room to talk to him. He got out of bed and ran to her. So they met kind of in the middle of the room. They held on to each other and then sat down on the floor, and I sat right next to him.
What did they discuss?
She was just consoling him, so just trying to get him to calm down. Right, that with Ashton, is that what you mean?
Yeah.
What did they discuss? She was just trying to console him.
Did they discuss Eric's Apple Watch?
They discussed Eric's Apple Watch later.
Okay, so we'll get to that.
Okay.
Sorry.
Oh, no, it's okay.
Did there come a time when Kouri Richins was consoling Ashton there and she was interrupted?
Yes. So Brianne Sorensen, which I believe was Ronnie, Kouri's brother's fiance at the time, I think they were engaged at the time, she came in to talk to Kouri. It was really interesting because Kouri was consoling, and then she immediately kind of stopped and focused on, they would call her Bree. And Bree started talking about the closing of the Midway Mansion.
Say, Your Honor.
Do we need to go into that, Mr. Bloodworth? I guess what I'm saying is anything further regarding that necessary to develop the upcoming testimony?
Your Honor, the state's next question will be, how did Kouri react?
Oh, okay. Yeah. So sustained. What Bree said is not admissible. Don't consider it.
Well, Your Honor, the content of the call, the content of the discussion.
Well, Kouri's side of it is not what they're objecting to. I think it's just that fact. Am I right, Ms. Nestor?
Yes, sir.
Yeah.
We're objecting to what Bree said.
Take it from there. I understand the contours here. Let's just wait for the next question.
Okay. How did Kouri react to what Bree said?
Kouri was very businesslike, very telling Bree exactly what to do, and I was dumbfounded. And I looked at Kouri and said, "You can't tell me you're going to close on that Midway mansion when my brother just died." And she looked at me matter of fact and said, "Yeah, absolutely. He has nothing to do with it. The money's already gone through. It's all my business. I'm going to."
What about the Apple Watch?
So the Apple Watch, Ashton, once he eventually came out of his room, he went and got my brother's Apple Watch. Kouri was standing by him. She took it from him and he said, "I want my dad's watch." So I watched her take the watch, delete the entire watch, everything off of it, and then give it back to Ashton.
On the morning that Eric died, did Kouri Richins say anything about the house that they were living in?
Yes, she told me, so the house, the 282 Willow Court that they were living in with their kids, she told me she was going to sell it.
Did anything about that strike you as odd?
Yes, I honestly could not function. I couldn't even figure out what was for dinner that night. I had just lost one of the most important people in my whole entire life. And she was planning on selling the house that he had just been wheeled out of, closing on a multi-million-dollar mansion. I could not wrap my head around it.
The point that Eric died, who did the house belong to?
When Eric died, the house belonged to Eric. Eric was the trustee of his trust. So the house was in a trust, and Eric was the trustee.
And then once he died, who became the trustee?
I became the trustee.
After Eric died, did Kouri Richins have the ability to sell the house?
No, she did not.
That morning, did Kouri Richins say anything about Eric's stonemasonry business?
Yes. She had a plan for how she was going to run his stonemasonry business. She was going to hire one of his best friends. His name is TJ. TJ worked for Eric's business partner's dad, and had grown up working with Eric and Eric's business partner Cody, and Cody's family in their family business, and he still worked with Cody's dad, Shannon. So she said that she was going to hire TJ to run Eric's portion of the business for her, and that he would take care of all of it.
So am I right that the morning of Eric's death, Kouri Richins told you her plans on purchasing the Midway mansion, selling the home she lived in, and running Eric Richins' business?
Correct.
Do you recall a family meeting that was held on March the 5th, 2022, the day after Eric died?
Yes, I do.
What was the purpose of that meeting?
It was to start preparing for the services for Eric.
And who participated in the meeting?
So myself, my husband, Clint, my sister was there, Amy, her husband, Andrew, my dad, Gene, his friend, Tisha, Kouri's brother, Ronald Darden, or Ronnie, as they call him, her half-brother, DJ, her, I believe Bree was there as well, his fiance, and then her mother, Lisa.
Did you know Eric's wishes regarding burial?
Yes, my brother wanted to be buried.
As opposed to cremation?
Yes, my family is very big on burial and not cremation.
Did, in the course of that family meeting, the topic of cremation arise?
Yes, so we had gone through and planned the whole funeral. My brother would be buried by my mom, where he would be buried at, who the pallbearers would be, everything to like who would talk, who would say prayers, stuff like that. And at the very end, when I thought we kind of had it all wrapped up, Lisa Darden, Kouri's mother, said, when are we going to talk about that Eric wanted to be cremated?
Did you observe Kouri react to her mother raising cremation?
Yes, I did. She looked shocked, like she was caught off guard at first. And then she went into it and said, oh yeah, he told me that he didn't want any bugs crawling on him after he was dead. It freaked him out, so we're cremating him. And I went on to ask, I said, Kouri, why did we just do a whole entire funeral based around the casket, the burial, the pallbearers, and now you're just bringing up cremation? And she played it off and said, oh, well, isn't that what you do when you cremate them? And to that point I said no. And then my dad started getting visibly upset because he knew his son wanted to be buried.
I need to take care of some business with handwriting samples now, okay?
Okay.
Your Honor, may I approach?
Of course.
I'm heading to witness 8-49. Ms. Richens Benson, are you familiar with that exhibit?
Yes, I am.
Generally, what is it?
So these are all handwriting samples from my brother, whether it be when he signed his name, for stuff at work, or for his will, any of that stuff.
Can you please just thumb through each of the tabs? I think, is there 14 of them?
16.
16.
Do I have to pay super close attention, or am I okay?
No, I just want to make sure you know what they are.
Okay.
You've seen them before?
Yeah, I have.
Okay, if you're comfortable that you've seen them before, there's no need to slip.
Yeah.
For K1, did you get those documents from the lender on the 282 Willow Creek Road property?
Correct.
And are they accurate copies of what you received from the lender?
Yes.
Did you then submit those to the Bennett Tueller law firm?
Correct.
On K2, did you receive those haircut receipts from Kouri Richins?
Yeah. So they are also receipts from like Wasatch Steel, different. I know there is a haircut one in here, but yeah,
Okay,
they're all
did you
different
receive
receipts.
those receipts
Yeah.
from Kouri Richins?
Yeah.
Did you provide them to Bennett Tueller?
Yes, I did.
Can you turn please to K3 or tab 3? Under that tab, did you receive some tax documents from Greg White, some payroll documents from Integrated Solutions, and a hunting license?
Yes, these are all my brother's documents.
And did you submit those under tab 3 to Bennett Tueller?
Yeah. Only one I'm not 100% sure about is the hunting license, if I submitted that or not. I can't remember that one.
Okay. On K4, did you receive the check there from Allison, right?
Correct.
And did you get The loan documents on K4 from the lender on the 282 Willow Creek Road property.
Yes.
Did you submit those documents to tab 4 to Bennett Tueller?
Yes.
Tab 5, did you retrieve that driver's license from the mortuary that Eric's body was taken to?
Yes.
And did you submit that to Bennett Tueller?
Yes.
For tab 7, skipping 6, going to 7, did you receive those various construction contracts from Kouri Richins?
Yes.
And then did you give them to Bennett Tueller?
Correct.
For K11, did you obtain those healthcare records from IHC? Was
Yes.
that Intermountain Health something?
Yeah, Intermountain Healthcare.
Got it.
IHC's their old branding.
Did you submit those to Bennett Tueller?
Yes, I did.
For K12, did you receive copies of those checks and C&E business records from Allison Wright?
Yes.
And did you give them to Bennett Tueller?
Yes, I did.
For K13, there's some materials from a Ford dealership. Did you receive those from your husband, Clint Benson?
Yes.
And did you submit those to Bennett Tueller?
Yes.
Finally, for K14, is that a document from Weller Recreation Center that you received from your father?
Yes.
And did you give that to Bennett Tueller?
Yes, I did.
And did you give everything to Bennett Tueller in the same identical condition that you received it in?
Yes.
Thank you. Ma'am, I don't have any further questions from you at the moment.
Okay.
The defense attorneys probably will, okay? Thank you.
Your Honor, excuse me. This is going to be a fairly lengthy cross. It's going to go past noon. I don't know if you want to break now or if you want me to just plow it and then we'll break in the middle.
You pressure me.
Yes, sir.
So, just want to welcome in all the new folks that are joining us. We are doing a rewatch of.
Okay. Please rise for the jury.
Just want to let you know we're doing a rewatch. Live trial is going to start at 3 Eastern, 1 o'clock local time. So I just want to say, so we're just doing a rewatch of before that starts. So welcome in. Be sure to hit the like button. We appreciate that. And let's continue on.
How to handle witness. Okay, let's have a discussion about how to handle witnesses that are on both the state's list and the defendant's list.
Yes.
Ms. Nestor, what is the defendant's request?
So here's our request. There are probably...
Your Honor, can I pause? Can we excuse the witness?
Yeah, that's fine with me. She can.
That would make sense, yeah. And is that so that she doesn't hear this discussion?
Correct.
Yeah. Do you mind stepping out into the lobby for a minute?
Yeah, should I leave this here?
You can take it.
Okay.
Yeah, it's your cup. Ms. Nestor, please proceed.
Thank you, Your Honor. So I knew this was coming because of conversations we've had with witnesses, but there are multiple witnesses that the state is going to call, including Ms. Richens Benson, who also have information that relates to our case. She's just one, there's lots more. Obviously, if the state is going to shut us down from asking any topic that he didn't cover in direct, then we're going to have to recall all of these people. And this trial is going to get a lot longer, inconvenience a lot more people.
Well, it's the exact same amount of time. Tell me why it would be longer. It
Because
just complicates the directed verdict motion.
because of the fact that all of these witnesses will be required to come back twice, get resworn. We're going to have to lay foundation again that's already been laid to refresh the memory of jurors. We're going to have to go back over topics that have already been talked about just to refresh the memory of the jurors. We're going to be using exhibits that are already here, keyed up, ready to go. This court has the ability to control what happens in this courtroom. If you want us to call all these people twice, we will, but it seems a ridiculous imposition of burden on not only the witnesses.
It's really interesting that the defense, Ms. Nestor here, is arguing that, how do you want to deal with witnesses, potential witnesses that we may call in our case in chief? And knowing what we know now, we know that the defense doesn't call anybody. So this whole argument is really interesting. And now that we know what we know, it's not even relevant. It's moot. So let's continue listening. Welcome in, everybody. Welcome in. Just so you know, we are rewatching some previous testimony before we wait for live trial to start at 3 o'clock today, 3 Eastern. That's 1 o'clock Mountain. So we're rewatching some testimonies. So far, we have Kouri Richens Benson on the stand, and we'll probably show the medical examiner next.
But the jurors to have to say we're going to hear from them now and in 2 weeks from now, there's perfectly within your power to say we're going to do everything this jury needs to do now. The state has the ability to come back on redirect and address anything that we bring up that they didn't bring up, but it seems a very inefficient way to run a trial, and it seems to be super hard on these witnesses to have to come back here twice and go through this 2 weeks apart. And especially, what happens if something happens to them? What happens if she gets sick or she leaves the country and I'm stuck and I didn't get a chance to redo her? Then we've got a real problem in terms of the trial and the record. So I mean, I've just never had a judge require me to do that unless it's just really unusual circumstances. So we're asking that every witness where we have information that the state decides not to go into, to let us do it now, not have to recall this witness, and then finally excuse her from her subpoena responsibilities.
You understand that to the extent the state raises relevance objections to your direct of this witness or another, I'm only going to have what's in the record so far. I won't have the whole picture to rule on that relevance objection.
I am not worried about anything we're going to talk with her about being decided to be relevant. Okay. I mean, it's clearly relevant. I'm just not worried about that.
All right.
Yeah, I mean, we're only talking to her about what happened with Eric, with this case, we're not going into anything outside of that.
Okay. Mr. Bloodworth.
Your Honor, the state prefers to present its case in an order that the state believes will provide a proper narrative to the jury without interruption. Sometimes a proper way to present a case is not most efficient way to present a case. And in an aggravated murder case, propriety has to take precedence over efficiency. So far, all these witnesses are local. I could see perhaps if there's an out-of-town witness, rather than inconvenience in the witness with an extended stay or repeated travel, we could make an exception. But as the rule, this trial is no different than any other trial where, pursuant to the rules, the scope of cross-examination is limited by the scope of direct. Thank you.
Ms. Nestor, we'll take this on a witness-by-witness basis. With respect to Ms. Richens Benson, I imagine she's going to be in the courtroom every single day. And if she's not, she's certainly subject to the subpoena power of the court. And has somebody subpoenaed her so she can't beg out of appearing?
I mean, Katie appeared today pursuant to the state's subpoena.
Okay. And that subpoena lists the entire trial, correct?
It does. I have not yet released her from it, as
Right.
we do some witnesses.
Right. And so as long as I make clear to her that pursuant to that subpoena, she can be recalled at the order of the court, any danger that you were describing, Ms. Nestor, is mitigated.
It also means she can't stay in the trial for the rest. She's going to have to be excused under the exclusionary rule.
Is it Katie or Amy that's
Amy.
the designated victim rep?
Amy,
Your Honor, the state had designated 2 victim reps, and it was Katie and Amy.
we object.
I understand you objecting to the 2.
We do. We object to 2. We don't object to Amy.
Right.
Right.
The state has to make a choice. If you'd like to proceed as you suggest, you're entitled to do so. That's fine, especially because Katie is subject to the subpoena power of the court. We can make sure that she comes back. But the statute talks in terms of 1 victim rep. The exclusionary rule says what it says. So the decision before the state is, do you want to, for this witness, allow direct to occur today so that there's no basis upon which to exclude Katie going forward, or proceed with the presentation of the testimony as the state sees fit, understanding that may require exclusion of Katie. And I apologize for using first names. There's a lot of Richens. It's just easier. No informality is intended. Exclusion of Katie until her direct is completed in the defense case.
Your Honor, how about this? Was the court about to take a lunch break with the jury?
Well, is food here?
No.
Okay, so it'll be a bit. So I want to keep using time. So I thought we could use another, it would have been an hour now, 45 minutes.
Sure. Your Honor, can we use that time for examination within the scope of direct? And then we take a lunch break. It will allow me to consult with Eric's family regarding
Exclusion.
the exclusion. It will also allow me, Your Honor, to refresh my memory. We had at the time, the state had appointed 2 victim representatives. Despite the language of the statute, we had briefed case law which expanded that language, and I just need to look back at that.
Yeah, I'm happy to be educated. But Ms. Nestor, may we proceed stepwise in that fashion?
Yes, sir.
Okay, so just so I'm clear, we'll invite Katie back in, we'll invite the jury back in, we will complete cross-examination of Ms. Richens Benson. We'll take a lunch break, we'll sort out whether you want to proceed. Let's see, isn't the trust going?
I go too far.
No,
Benson?
I just wanted to get fast forward to Katie's. We heard them, wrangling in the background there. So I want to get further on to Katie's testimony. So here we go. Again, we're rewatching Katie's testimony from day 1 while we wait for live court to start at 3:00 Eastern today.
Folks, have a seat. Thank you. Thank you for your patience. We'll proceed with cross-examination of Ms. Richens Benson. Then we'll take a lunch break. Thank you for your patience. Ms. Nestor, take it away.
May it please the court. Good morning.
Good morning.
We've never officially been introduced, but I know we've seen each other a whole lot. But again, my name's Kathy Nestor, and I'm one of Kouri's attorneys. So I want to talk to you about, I want to go back a couple of years before Eric passed. You mentioned in your direct testimony that you are the trustee of a trust that Eric created. Is that right?
Correct.
And may I approach the witness, Your Honor?
Of course.
I'm handing you a document that's been marked as IMP KRB1.
Okay.
Take just a second and look at that document and tell me if you recognize it. I certainly don't expect you to read the whole thing, but just tell me if you know what that is.
Sorry, I just want to make sure.
Sure, no worries. Take your time. You ready?
Yeah.
So do you recognize that document?
Yes.
What is that document?
It's the Eric Richens Living Trust.
And is that the trust that you were referring to in your direct examination?
When
Mr. Bloodworth was questioning you?
With the house. Yes. This is the trust.
And that's the document that makes you the trustee if Eric should pass away.
Correct.
All right. Your Honor, at this point, I'd like to introduce this as Defense Exhibit 3001. On the impeachment, we're going to start it with the number 3.
Mr. Bloodworth.
Your Honor, no objections to the admission of the document. The state, of course, is going to admit it, had planned to admit it through the witness that prepared it. The state's just pausing on the nomenclature. We've referenced this document in other briefings by other exhibit numbers, which...
We can resolve that going forward. We can come up with a common vernacular at some point.
Right.
Okay.
Okay, but as to admission, no objection.
So just so the record is clear, if anybody ever has to read this, the Eric Richens Living Trust, dated November 3rd, 2020, is admitted.
All right, and that's going to be Exhibit 3001, Your Honor.
For the time being.
Yes.
We'll see if we come
Change
up
it.
with a different vernacular going forward.
That's fine. Okay, can you turn for me to Section 1.03 of the trust?
And Ms. Nestor, will you let me know when you're ready to publish whatever you want to publish to the
I will,
jury?
thank you.
Thank you.
Do you see that? Does that list the objectives of the trust? Just to refresh your memory, let me know when you're finished reviewing it.
Oh, they're just... Okay, sorry, what was
That
your
refresh
question
your
again?
memory a little
Yeah.
bit. So is it fair to say that Eric's objective, as put in writing in the very beginning of this big old trust document, was to provide for both my wife and our children during any time I am incapacitated and after my death?
That's what's in there. Yes.
So
Your
it's
Honor, I'm sorry. Can we publish this to the jury?
Sure.
We're seeing it on our screens, but the jury's not.
Yeah, she didn't ask me
Can
to.
you
That's fine.
publish?
Would you like to?
Yes, sir. Thank
Okay.
you. That would be helpful. Thank you, sir.
Yep.
All right. And you agree that it was your understanding that this trust would provide for both Kouri and the boys. Is that right?
It would provide for the beneficiaries, and those 4 are the beneficiaries.
And Kouri was a beneficiary of this trust.
She was a beneficiary of the trust.
And that's what Eric wanted.
I think the document
Your
speaks
Honor,
for itself.
objection.
Yeah.
I'll withdraw, Your Honor.
Okay.
Okay. So basically there was as trustee, what is your understanding of your role as trustee? What is your role?
It's to administer the trust.
And what does that mean to you?
So to carry out my brother's wishes.
And with respect to the reality of that, there's a trust that holds assets. Is that your understanding? It holds his assets, whatever they are.
Correct.
And that includes cash and money and items, right?
Yes.
And you're supposed to see over that money and those assets
Correct, as the trustee.
and protect them, right?
Correct.
And distribute them to the beneficiaries as needed throughout their lifetime.
Based on what the trust says.
And that's your understanding of kind of your job, right?
Correct.
And as trustee, you get paid.
No.
You aren't taking a fee.
So my brother did put in the trust that I could be paid and I could reimburse myself for the time spent. I have never once been paid for the time that I spent. So I chose not to.
That's very generous of you, and that's because you want those boys to get everything they can, I'm sure.
I want all the beneficiaries to get everything they're entitled to.
Okay, thank you. So let's say 2 months after Eric died, Kouri wanted to buy a car. She could do that, but she would have to ask you first, right? As the trustee.
Can you reframe that? So with money from the trust,
Yes.
she wants to buy the car?
Right.
Yeah, there's a lot of litigation. So she did a lawsuit 3 weeks after my brother passed to try to set aside the trust.
Okay.
So there's a lot of litigation. So I would work with my attorneys to figure out what was proper.
Let me ask it this way. What is your understanding of what, if there was no litigation, what you, as the trustee of the trust, were meant to do if one of the beneficiaries needed some money, if one of the boys wanted to go to private school, if Kouri wanted to buy a car? What was the process from your understanding?
So the trust was actually just split into 2 separate trusts. One for his 3 boys, who are the primary beneficiaries, and then another trust for Kouri. And you'll have to forgive me, I don't have the whole thing memorized.
Oh, of course not.
But it said in there what the money could be used for.
All right. So if Kouri wanted to spend some money out of the trust that was authorized in your opinion under the trust, it would be your job to say, yes, here is the money, and give her a check, right?
Correct.
And one of the things the trust authorized was care and maintenance of their home. Is that right?
So that the home is a trust asset.
Okay. So if the house needed repair, the trust could pay for that?
Correct.
If the trust could pay for the mortgage payments?
Correct.
The trust could pay for insurance on the house?
Correct.
So in the year after Eric died, how much money did Kouri ask you for to pay for anything related to the house, to her, to anything?
Pause for 1 second.
Okay.
Your Honor, objection in reference to the discussion we just had.
Exceeds the scope.
Yes.
Sustained.
Okay. Did the trust pay any mortgage payments on the home after Eric died?
Ms. Nestor, it's the same objection.
Okay.
Sustained.
Has the trust reimbursed family members for costs paid to a private investigator?
Pause for 1 second. Go ahead.
Same objection scope, Your Honor.
We're well outside the scope of direct, Ms. Nestor. Sustained.
Right. Can I approach?
Sure.
Just 1 minute. I'm trying to comply with your ruling. Just give me 1 second, because I think there's another topic that I'm going to have to save for a direct. Yeah, I think so. All right. All right, I want to talk to you about the day of Eric's death. You mentioned, I believe you mentioned that when you got there, Kouri looked put together.
Correct.
She was in pajamas. Is that right?
Like a matching sweatsuit.
She was in a matching sweatsuit.
Like sweatsuit, pajamas. I don't know the technical,
Okay.
what they were sold as.
And you said her hair was fixed?
It was pulled up.
It was pulled up in a messy bun? Is that what you recall?
But yeah, it was pulled up, neatly done.
Her hair was neatly done, that's what you recall?
Yeah, looked similar to today, just on top of her head.
And you also said that you went to the ground and she just stood there and did not comfort you in any way?
Not that I recall.
Okay, Katie, can you please, just for the witness only, Your Honor, we'd like to play a clip. This is State's Exhibit 1-4.
Pause 1 second. Does this have sound? It won't now.
Doesn't have sound, I don't think.
Okay.
So only for her to review.
Well, hold on a second. It's real hard for me to do only the witness.
Oh, I mean the witness and counsel.
Okay.
Sorry.
Mr. Bloodworth.
It's S1-4.
Donna, can you?
Of course.
So I just want to let you guys know, the folks that are coming in asking,
And folks, thank you.
sorry. For people that are coming in new, live court will be happening at 3 today, 3 Eastern, 1 o'clock local time, which is Mountain Time. And they're just going to go over jury instructions. So the jury is out until Monday. So the jury's going to come back on Monday. And today, both parties are going to hammer out jury instructions. They're going to go over the charges. They're going to deal with the verdict form, jury instructions, all that stuff. So that's going to start at 3 o'clock today, which is another 5 hours or so. So in the meantime, we're showing past testimony to just kind of keep us in the groove, keep us in the mood, if you will, and to see now that we've gone through the trial, we can go back and we can see how the defense was saying. I love the fact that they're talking about, hey, we're going to call her up on direct, we're going to do all this stuff, and now we know that they rested. So I find that interesting. But live court's going to be on in about 5 hours, so 3 o'clock Eastern, and then without the jury, just both sides and the judge, they're going to hammer out jury instructions, and then Monday they're going to come back and they're going to do closings, jury instructions, and most likely they'll start deliberating, especially if they start at 8:30. I would fully expect that they're going to start deliberating on Monday. So anyway, that's kind of a high level schedule, scheduling outline, if you will. So for now, we're showing Kouri Richens Benson, and then we'll get to the medical examiner after this.
We're going to pull up their amended one that they just served like 2 days ago.
No problem. Table. Scott, you let me know when you're ready to go.
It's just, it starts a little bit further back. Okay. All right, just 1 second.
Children are blurred. Something we need to do throughout the case. They are still photographs that are on the wall depicted in an exercise of caution. We just want to make sure we blur those before we publish them. This is going out to the world. It's not just the people in here.
The captions where they cover what we're trying to say. What's that? Captions?
Could you approach for a moment? A lunch break. This is like watching paint dry. That's not fair to you. So, let's give you a lunch break.
Or just let me do it now. I mean, that's their decision, but that is a prejudice, and that's very real.
Okay. Anything further?
No.
All right. Under Utah Code 7738-9, subsection 2, the court shall designate a representative or representatives of the victim. The legislature, in crafting that language, contemplated situations in which more than one victim representative would be appropriate. An aggravated murder case is certainly among the situations in which the family of a decedent might want to spread that burden and duty across two family members. The court finds that the state's request to designate Ms. Kouri Richens Benson as a co-victim representative under Utah Code 7738-9 is supported by the language of the statute and a good faith request. Moreover, the defendant's arguments regarding prejudice are not persuasive for two reasons. One, Ms. Richens Benson has never been listed by the defendant as a trial witness that they intended to call in their defense case. And more practically, the court finds that she likely already knows all of the admissible and inadmissible evidence in this case, and there is no additional or marginal prejudice by allowing her to be in the courtroom during the testimony of other witnesses. The state's request to designate Ms. Kouri Richens Benson as a victim representative under Utah Code 7738-9 is granted. On that basis, the court does not have the authority to exclude her under the exclusionary rule. Mr. Bloodworth, anything else?
No, Your Honor. Thank you.
Okay. Are we ready for the jury and the witness, Ms. Nestor?
Just one moment.
Yeah.
Did we swap it? Everything's okay.
We want to take a look at it before.
I think we're good. I think we've all agreed on it.
Let's just take a quick look.
Do you want to show it real quick, Katie?
And is it a clip or just a still?
It's a clip.
Okay. Is that the clip? Okay. Very good. Let's invite Ms. Richens Benson back in. Very good. Ms. Nestor?
Yes, Your Honor.
Let's do it. Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good afternoon, Ms. Richens Benson. So when we took a break, I had confirmed with you that it's your recollection that Kouri had a sweatsuit, a matching sweatsuit, and fixed hair, and that she did not comfort you when you fell to the ground. Is that correct?
To my recollection.
Okay, I'm going to ask you to watch a clip from that morning that was taken off of an officer's body cam and see if you can confirm that that's in fact you and Kouri that morning. Katie, can you play it? Is that you in the clip?
Yes, that's me.
Okay. Your Honor, at this point I'd move to admit as exhibit maybe 3001 for now. The clip.
3002.
I'm sorry. 3002?
Yeah.
3002, that's correct.
Mr. Bloodworth.
Your Honor, no objection to admission. We'll figure out nomenclature later.
Sounds good.
And just for the purpose of the jury, just a short explanation that we will supplement this with a blurred version, but for now there's just a black box over where the children's photos are since it's being played publicly. But that'll, if it goes back to the jury room, that box will be removed and the pictures will just be blurred.
You can play the clip.
Thanks, Kate. All right, so as you're watching this clip, there's an officer there, but that's Kouri right there, right? And she's squatting down to hug you. Is that right? Katie, could you play that again?
I'm sorry, this is hard with two Katies.
There are two Katies. I'm sorry. I'll call you Ms. Richens Benson. How about that?
Thank you.
Okay. Okay, so that's Kouri. Freeze it right there, Katie Nestor. Okay, and that hair right there, that's what you're saying she had fixed? Just her hair up and messy like that?
Yeah, as you can see, mine was down and messy and didn't have contacts in anything.
Sure. So both of you had messy hair, and she's also clearly wearing pajamas. Does that refresh your memory that she was not in a sweatsuit, she was in pajamas?
I'm not a fashionista, so to me that's a sweatsuit or pajamas, just to be honest.
Okay, and then keep playing, Kate, Ms. Nestor. And that's her squatting down to comfort you while you're on the ground, and that's y'all hugging, right?
Correct.
So your memory about that was clearly wrong.
To be fair, it was 4 years ago.
Okay. And everything you're testifying about here about that morning was 4 years ago, is that right?
Correct.
Okay. You can take that down, Katie. Thank you. Other Katie. And shortly after this scene where Kouri hugs you, and obviously everyone's completely understandably upset, was there a time where you went out into the driveway and spoke with an investigating officer that morning?
I went and spoke to an investigator in their car out front of the house.
Okay. Maybe not in the driveway. Might have been in front of the house.
Correct.
Your Honor, objections.
Your Honor, she's testified about her memory of that morning. This happened that morning.
I'll give you a limited latitude here.
Thank you. And who was the officer that you spoke to?
Detective Woody, I believe.
All right. And that was just to help, because there's so many officers that are going to testify in front of this jury. It's a female officer, right?
Correct.
Okay. And when you talked to Officer Woody, or I think she was a detective then, did you tell her that you believed Kouri was involved in your brother's death?
No.
Did you tell the officer that you were suspicious that Kouri may have been involved in your brother's death?
Pause there.
Okay.
Well, I'm going to allow her to answer that question, then we'll have a conversation. Sure. Go ahead. You can answer that. I'm sorry.
I let her know that Kouri had stolen money from my brother, and I thought she needed to know that.
And what else did you think she needed to know at that moment?
I left at that moment to go back in the house.
You didn't tell her anything else?
My recollection is that I told her that Kouri had taken money from my brother, quite a lot of money, and that there was tension.
And what did you tell the officer was the reason for the tension?
May I have a quick conversation with you?
Yes, Your Honor.
My apologies, counsel. Interruption, folks. Ms. Nestor, please proceed.
Thank you, Your Honor. And now I forgot where I was, so let me think about it again. We were talking about what you asked the police, what you said to the police officer when you were outside. And this is before that police officer has ever entered the house, right? This is your first time to see this officer.
I'm not sure.
Okay. And you felt it was important that this officer know that your sister-in-law had a motive? What was your reason for telling the officer that information?
I had an overwhelming feeling come over me that I should let someone know.
Why? What was your overwhelming feeling?
That I should let someone know.
Because you believed it was suspicious? The death?
Honestly, at that time, I had no idea what was going on. I just had an overwhelming feeling. I had just barely talked to my brother. He was fantastic. When I had talked to him just a couple hours before, I had an overwhelming feeling I should tell someone about this, so I did.
Because you thought Kouri was behind it?
I did not say that.
Did you tell the officer that Kouri had a reason to be upset with Eric because she had found out about your being a trustee over the assets before he passed?
No, not to my recollection.
You didn't mention being the trustee of a trust to this officer? I
knew that I was the trustee of the trust.
Did you share that with the officer?
Maybe. There's a potential.
So you can't remember?
Just give me a second.
Sure. Take your time.
I mean, I did know that I was the trustee, so I definitely could have shared that with her.
And did you share with the officer that Kouri had been upset with your brother about that before he passed?
No,
So if an
that's
officer,
my recollection.
if an officer says you said that, that would be wrong? Or you're just not sure?
The questions are a little difficult. They're really vague. So not to my knowledge.
Okay. You mentioned that Kouri's son asked if he could have his dad's watch. Is that right?
Correct.
And you mentioned that Kouri just reset the watch and gave it to him.
Correct.
So Kouri didn't go through the watch trying to pick certain things out to delete, right?
I just watched her swipe it and give it to him. Or delete it and give it to him.
If she hadn't swiped it, and I'm not an Apple Watch person, so maybe you know this better than I do, but that would have meant her son could read everything her husband had ever put on his iPhone, right?
I'm not an Apple Watch person either, so I can't answer that for
Is
you.
it your understanding the watches match the phone, basically?
Mine doesn't always, so, but again, I'm not an Apple person, so I can't tell you.
Do you agree there could be a lot of reasons why a mother would not want a young child to have access to everything his adult father had saved on his phone?
In a hypothetical, yes, I guess.
Okay. You also mentioned that Kouri told you that morning that she was going to sell the house.
Correct. She
And
did.
this is the house her husband had just died in.
Correct.
And she was pretty traumatized about her husband just dying in the house.
That I don't know. You'd have to ask her.
In their bedroom. Right?
What's the question? Sorry.
Do you think there's a lot of reasons why a widow would not want to continue to live in the bedroom where her husband died in front of her?
Honestly, I can see some people would and some people wouldn't.
Okay. You also mentioned just now, and also when you were on direct with Mr. Bloodworth, that you never knew your brother to use anything other than Advil. Is that right?
When he asked what I had seen him take, correct.
Okay. Are you aware that your brother did use other substances?
After his death, from his medical records that I got, it said that he occasionally took it for back pain.
Took what?
THC,
Okay. Which is marijuana?
marijuana.
So when he was alive, he didn't share with you that he used marijuana, did he?
Not directly, no.
And you talked about your mom, which I think is great, was a drug and alcohol counselor.
Correct.
And that it was important to her that your family not be engaged with the use of drugs when she was alive.
No, I said prescription medication.
Okay. So your brother knew that it was important to your family. Sobriety was an important thing to your family.
I'll be honest with you, my mom was not against marijuana use.
Okay. But you said you were?
I said prescription medication earlier.
Okay. But for whatever reason, your brother didn't share with you during his lifetime that he used marijuana.
No.
And I know you were here during the opening statement, excuse me, Your Honor. You saw this slide of all those gummies that were seized from Eric's. You didn't know that was in his house? He didn't share.
I knew that Kouri had some in there. He had shared that with me.
But he didn't tell you he did?
No.
Okay. And you also, did you know that your brother drank alcohol?
I knew that he socially drank, but he was responsible.
And he chose not to do that in front of you. Is that fair?
Correct.
And it's also fair and totally understandable that your brother's not going to talk about his sex life with you.
He actually did.
Oh, did he?
Yes.
Did your brother share with you that he was taking testosterone?
Yes, he did.
And you knew that?
Yes. And
Did, I'll strike that. Did you go through your brother's phone ever?
no.
The morning after he passed, Was there a period of time where you saw your sister Amy with his phone?
She did have his phone.
And how long did she have his phone in her possession?
Honestly, I wasn't watching Amy very close, so I can't tell you.
Okay. Did you ever have his phone that day?
No.
Your Honor, stay within the scope. Objection.
Same morning, Your Honor.
Let's keep moving. The objection is overruled. Let's to that last question.
That morning after Eric died, did you ever, well, let me ask it this way. When you arrived at the house, had the police cordoned off any portion of the house and said you could not enter it?
There was someone at the hall, and they said that you weren't supposed to go back down the hall.
Once they removed your brother's body from the scene, and I know that was traumatic, and I'm sorry. Once they removed his body, were you allowed to go anywhere in the house you wanted?
Yeah.
And did you see the police searching the kitchen?
Yes.
All right. What
Just
did you?
the garbage in the kitchen, that was all.
That was the only thing you saw them search for, was the garbage.
Yeah. I wasn't around them all the time, so I don't know what else they did.
Okay, that's fair. At any point that morning, did you hear Kouri being interviewed by police?
No.
So you weren't present when they questioned her about what happened that night?
No.
Did Eric share with you that he had used hydrocodone in the past, like in that pill bottle that we saw on the screen?
So Eric and I had talked about that. So that pill bottle on the screen, it was old. It was 2016, right?
Right.
Because Eric had a procedure, but Eric did not want to use much of it. So actually, Eric and I had several conversations. When his back hurt and everything, I actually set him up with an acupuncturist and everything so that he didn't have to use any. So
Let me stop
It
you
was-
right there. Just 1 minute.
Okay.
Let's just break it down.
Okay.
So you knew that he had used hydrocodone in the past for pain?
He did not like to, but if it was extreme,
He did use it?
yeah. But he would never like take the whole finish
And-
prescription.
And, well, as far as you knew. Mm-hmm. And you knew that he had back pain?
Correct.
And you knew it because you're the person that he would go to when he was in pain.
Correct.
And you helped him try to find an acupuncturist for his pain?
Yeah, he went to an acupuncturist.
How often did he do that?
I set up the appointments. They actually helped really quickly. So he went to a couple appointments to I can't give you the exact amount, but.
And when... Okay, I'll strike that. You also talked about the prenuptial agreement
Correct.
that you saw Kouri sign at their wedding. Is that right?
I saw it before she signed it.
Right. And is it true that in the prenuptial agreement that Kouri knew that if something happened to Eric, she would not recover? She wasn't entitled. She surrendered. Let me ask it this way: were you aware that as part of the prenuptial agreement, she was surrendering any claim on his business of C&E?
Your Honor,
Pause for one.
objection. The prenup's into evidence. It says what it says. I don't think that's an accurate characterization.
I can rephrase.
The question is about what Ms.
She
Richens
that's-
Benson understood.
That's what I was
And
going to
so
say.
you will be able to point out later whether her understanding matches the text or not.
So was it your understanding that she was surrendering any claim to his business at C&E in the prenuptial agreement?
Only if they divorced. If he died, then she would get the business while they were still married.
Okay. But if he died, once you became trustee, you were aware that his business would actually go into the trust, not to her, correct?
The business is a trust asset. His partnership is in the trust.
Okay. And that was done before he passed.
Correct.
And again, you don't recall telling the officer that Kouri was upset about that prior to the officer coming in the house?
No.
Okay. The morning that you were there, was there any period of time where you were in the garage?
Yes, I went into the garage.
And what was your purpose for going into the garage?
A medical examiner or some medical person, had asked me, do you know if Eric took any kind of pill today, an allergy pill, anything? And I said, I'll go check his truck. I know he takes allergy pills, but I'll go check his truck. So I went to the garage to check his truck.
And when you were checking his truck, was there anyone back there with you?
Lisa Darden, her mom, and Bree, I think it's Swerenson, followed me.
Okay. And when you were in the truck, how long were you in his truck?
Not long at all.
Okay. When you got there, was Amy in the truck?
No.
At some point, did you see Amy in the truck?
No, not to my recollection.
Okay. All right. You also mentioned that Kouri mentioned to you when she said that she was going to sell the house. I believe Mr. Bloodworth asked, could she have sold the house? And you said the answer was no. Is that right?
Correct.
And the reason the answer is no is because why?
Because the house was not Kouri's asset. It was in Eric's trust. Her name was not on the deed, anything like that.
But she was his spouse under the law, right? Right?
She was his spouse under the law, yeah.
And she had a marital interest in the house, right?
Now that's all in civil court. I can't.
Sustained.
Yes, you know, cause for legal.
Yeah.
Sustained.
Okay. All right, now I want to talk about before the body was removed. Were you present, or did you have an understanding about where they were going to take the body?
No.
Did you hear a conversation, or were you a part of a conversation that discussed that there was going to be an autopsy?
I know I heard that day that they were taking him for an autopsy.
Okay. So before he even left the house, there was discussion that he was going to be autopsied. I think that's a verb. I'm not sure.
I can't tell you if it was before or after.
But there was a discussion in the house about it. You all knew it.
That they would take him for an autopsy? Yeah.
Yes. Okay.
Yeah.
And then the conversation that you testified about, where there was a discussion about cremation or burial with Kouri's mom.
Correct.
At that point, the autopsy was over, right?
I don't know when the autopsy was over.
When was that conversation?
That conversation was on the 5th.
So 2 days after he passed. And where was the body at that time, to your knowledge?
Yes, that's you got to answer the last question.
I'm so sorry. I thought you were finished. I apologize.
Okay. Well,
The question
can you
was
ask?
on the 5th.
Yeah, it was on the 5th when we talked about the burial.
So 2 days after they'd removed, or 1 day, I'm sorry.
1 day.
After they'd removed his body from the house.
Correct.
So when you were having that conversation, where was your understanding of where the body was?
It would have been in one of two places, either at the medical examiner's office or at the mortuary.
So, bear with me then. At the point that his remains were finally interred, either through cremation or burial, that autopsy already would have happened, correct?
Honestly, I remember talking to the mortuary. They were watching to see when it was done. They said that it could take a couple days because it was later. So I can't tell you if it was done or not. I can't remember.
Let me ask you this way. They weren't going to let you bury him or cremate him until they'd finished that autopsy and released the body to the family, correct?
I mean, I would assume so, but I've never dealt with this with the medical examiner's office, so.
And once you all had that conversation with Lisa and Kouri about whether he wanted to be buried or cremated, did Kouri agree to bury him?
It went back and forth for a little while.
And then did Kouri agree to bury him?
Yeah, we buried him.
That's right. The handwriting samples that Mr. Bloodworth asked you to identify, is it fair to say that you organized an effort to gather a bunch of signatures of Eric's to compare with the signature, another signature, to see if you believe Kouri forged his signature on something?
Yeah, it was for the civil lawsuit that we were going through, and yes, it was to see if that was his signature or not, because he had told me he did not sign it.
And you personally took responsibility for that effort of gathering those signatures, correct?
So my duty as personal representative is to look into any claim that the estate may have. So yes, I did.
And you sent that information to the prosecution team in this case?
I did not personally send it, no.
Okay. You did hire an expert to look at it, right?
Yeah,
And that
yes,
was-
I just told you that's my fiduciary duty as a representative of my brother, so over his estate, to look into any claims that the estate has.
And who was the expert that you hired to look at those handwriting samples?
His last name's Throckmorton.
And it's Matthew Throckmorton?
I only ever met him once. I think his first name's Matthew, yeah.
And you guys paid him a fee to do that?
I actually didn't pay him. My law firm did, but then it went on the bill, so I didn't directly pay him.
May I approach, Your Honor?
Yes.
May I approach, Your Honor?
Yes.
All right. Handing you a document that's been marked INP KRB3.
Okay.
Do you recognize that document?
I actually do not. I have not seen this before.
Okay. Okay, I'll take it back. Thank you so much. Did you pay other experts in connection with this investigation?
I did.
Who were the other experts you hired? Was Brooke Carrington one of them?
Your Honor, objection, point of clarification. When she says this investigation, the criminal investigation or the civil investigation?
Provide a little more foundation, please.
Yes, Your Honor, I'm happy to. Did the trust hire a woman named Brooke Carrington to do a financial investigation on Kouri Richins?
It's really tricky. It would actually be the estate that did, not the trust that did.
Okay.
So Brooke Carrington worked for the estate.
And were you also in charge of the estate?
Correct. I am a personal representative for my brother.
And you personally paid Brooke Carrington?
Correct.
Okay. May I approach, Your Honor?
Yes.
All right, I'm handing you another document asking you if you've seen this before.
Yes.
KRB2. KRB2. What is that document?
So Brooke was a financial forensic accountant for us, looking into any claims that the estate would potentially have. So I paid her for her work on that.
And what is that amount that you paid Brooke Carrington?
$14,625.
And is that your signature on that check?
Yes.
Your Honor, I move to admit that as Exhibit 3003, Defense 3003.
No objection, Your Honor.
Defense 3003 is admitted.
Can we publish that to the jury, please?
Ready to go, Kitty? One moment. There you go.
Okay. What's the date on that check?
6/21 of 23.
All right. And are you aware if that was after Kouri had been charged with this crime?
Let me think of dates really quick. Yes, it was after, because once Kouri had been charged, Brooke quit working for us, so she sent a bill and I paid the bill once.
And why did she quit working for you?
She started working for the state and we hired a different forensic accountant to work for the estate.
And who provided her name to the state as a potential expert?
I'm not sure.
That wasn't you?
I actually never even talked to any of the prosecution or anything before that, so no, it was not me. I did not even know who they were.
I'm sorry, you said you hadn't talked to the prosecution prior to June of 2023?
Prior to her being arrested.
Let me clarify to make sure that I don't impeach you for something you're not meaning to say.
Oh, okay.
When you say the prosecution, you mean the actual people sitting at the table, not
Yeah.
their investigators.
Oh, yeah. Yeah, them.
Because
Yeah.
you had talked a lot to the investigators prior to Kouri being arrested.
I had talked to investigators. I had never talked to these guys.
Totally fair. I just didn't want to come after
Sorry,
you.
I did.
Nope.
The difference. Thank you.
I want it to be right. So to go back to that, you had talked a lot to the investigators that were investigating this case on the criminal side prior to Kouri being arrested.
I had talked to them.
And as a matter of fact, on March 21st of 2022, so before there was an official finding of Eric's cause of death, isn't it fair that you sent an email to the chief detective, the same one you talked to in the driveway or outside the house, with the timeline of everything suspicious that Kouri had done in the last multiple years?
I can't remember the exact dates.
Okay, let me approach. May I approach, Your Honor?
Oh, I'm sorry. Yes. Counsel, I trust you folks. You can have leave to approach the witness as needed.
Thank you, Your Honor. Okay, I'm showing you a document that's been marked as KR6. Just take a second, as much as you need, and tell me if you recognize that document. Okay. And attached to that email is what you called a timeline, is that right?
Correct.
How many pages is that timeline you provided to Detective
know.
Woody?
Nine, if I'm counting right.
Okay. And what was your purpose for sending that timeline to Detective Woody?
Because I'm not a detective. Eric's death was suspicious, so I wanted to get it to the professionals.
And everything in there is about Kouri, right?
No, not everything.
Did you identify anyone else you thought might have been involved in Eric's death in this timeline?
It talks about...
Don't read it because it's not in evidence, but you can just generally talk about the topics.
I know it talks about Lisa in there. I saw as I was flipping through it, talks about Ronnie's fiance or girlfriend, Bree. Talks about a lot of different people.
All right, and that timeline goes back years probably. Is that fair? Does it start way before he died?
Yeah, 2016.
So you go all the way back to 2016 in the information you gave the investigators.
Mm-hmm.
Is that right?
Correct.
Okay. And then do you remember shortly after that you did some investigation into Kouri's business online and forwarded that to an investigator? Do you remember doing that?
I did not personally do the investigation, but if you show it to me, I can definitely tell you.
Okay. All right. May I approach her? I forgot. Sorry. It's habit. That's federal court. continue, it's been marked for identification as KRB 11. See if that refreshes your memory a little bit. Is that your email address?
Correct, it is.
So that's you forwarding to the investigator background information on Kouri's businesses?
Correct.
All right. And then, do you also remember forwarding on March 28th to the same investigator reporting that Kouri had asked for her wedding ring back from the medical examiner and you thought that was suspicious? Do you remember doing that?
Can you show me the email
Sure.
again?
Showing you KRB 12 and see if that refreshes your memory a little bit.
Thanks. Not her wedding ring, my brother's.
I'm sorry, the ring that he wore.
Correct.
On his finger. And she was asking for it back, right?
Correct.
And you thought the detective should maybe test the ring, or you thought that was suspicious and you reported that?
Yeah.
Okay. Also in there you talk about ring cameras. Did you share ring camera information with the investigators?
I did not have the ring camera information.
Okay. Do you remember in May of 2022 suggesting with the officers, the investigating officer, that Kouri may have tried to kill your brother on Valentine's Day with
Yes.
a sandwich?
Yeah.
Okay.
Because my brother talked to me about it.
Okay. As far as you know, had that information ever been imparted to them before you gave that to them?
I would have no way of knowing that.
Okay, fair. Did you also do some online sleuthing into her mom's Venmo and Susan Kohler's Venmo?
I did not personally.
Did you forward that information to the investigators to use in their
Can I see the
Sure.
email, please?
Yep. Showing you KRB 14 with an email dated April 25th. Does that look like your email address?
Correct.
Okay. So the answer is yes, you did that?
Yeah.
All right.
Your Honor, objection. It misstates the email. There was no sleuthing into Susan Kohler's Venmo. It was just into Lisa Darden's.
I'm sorry, it does mention Susan in there. You want to see it again?
Do you want to just show the jury what it says instead of just talking about it?
Sure. I move to admit the exhibit. And Katie, can you pull that up?
Any objection, Mr. Blebber?
No objection.
Okay. Give me the number one more time, Ms. Nestor.
It would be 3004.
Okay. So this will be D3004. This is, for the record, an April 25, 2022 email from an email address in bold print indicated as Richens Benson. We'll publish it now.
Can you blow that up, please, so Jerry can see it? You see that there you were looking into two different people's Venmo accounts, Susan Kohler and Lisa Darden?
Yeah, those are the two people that are on there.
And you also investigated the background of Susan Kohler and shared that with the prosecutor?
I did not personally.
But you forwarded it?
Correct.
Okay. At some point, didn't you also get access to Kouri's banking records?
Not for a long time down the road.
Okay. May I approach, Your Honor? Gosh, I'm going to quit doing that, I swear.
What's that?
My brain is wired that way. I'm showing you a letter that's marked for identification as KRB 16. a letter dated November 7th of 2022, which was a few months after Eric died. Can you just read that for a minute and tell me if you remember that letter?
Honestly, I've never seen this before.
Okay, totally fair.
Do you want me to keep reading the whole thing?
If you can't identify it.
Okay.
I thought you might have read it. Do you remember being asked how you obtained Kouri's private bank records without her permission? Did anyone ever confront you about that?
I think we're talking about two different things. The only bank records or banking that we have received is through the litigation for the civil lawsuit, when the trust was granted a constructive trust. And so that's the only thing.
So in your role as trustee, you went about to get her private banking records?
No, it's all litigation, and it's really hard for me to go through it. I mean, my lawyer's here; he can speak to it a lot better than I can.
Definitely don't want you to have to become one of us, so don't worry about it. You also had multiple interviews with the Summit County investigators. They came to your house once and interviewed you. Is that right?
Correct.
And you also interviewed with Detective Woody, I think, here or in this area, in this complex somewhere.
Correct.
And you also had multiple phone conversations with the prosecution. All this before Kouri was arrested. Is that right? I mean, we just looked at a bunch of emails.
We have to be more precise. Precision matters in this business.
Is it fair to? I'll withdraw.
Is different. The prosecution may mean different things.
I'll rephrase it, Your Honor. I'm happy to.
Thank you.
It was a little confusing, so let me try that again. Is it fair to say you had regular communication with the investigators in the criminal case almost immediately after your brother's death, even before they got into the house and after?
I did talk to the detectives, yes.
Okay. Okay, just a minute. Were there occasions where you sent potential witness names and contact information to the investigators on the criminal side?
That was in the email you sent. There were some names.
Okay. Do you remember... Oh, I'll strike that. Because you were the trustee of the home, you guys were in charge of, well, let me rephrase it this way. How long did Kouri stay in the house after her husband died?
Till her arrest, I believe, on May 8th of 2023.
So for that year, Kouri remained in the home with her boys, is that right?
Correct.
Right. After that, you became in charge of maintaining the home once Kouri was arrested, is that right?
I did before as well, too. I fixed water leaks, paid off the mortgage, stuff like that.
Right. And you fixed a water leak in that house on Willow Court?
Correct.
When was that?
It was in February. It was when it was January or February. There was a ton of snow on the ground, so I had to pay people to shovel all the snow to get down to it.
Okay, and that was Kouri and Eric's home?
Correct.
Okay.
Well, at the trust house.
Got it. I understand. During that time, were there times where law enforcement needed access to the house to search it?
Are you talking after?
After Kouri's arrest, sorry.
Yes.
All right. About how many times did you guys have to provide access to law enforcement to search that house?
I don't know off the top of my head.
If I were to say around 10, 11 times, does that sound completely out of bounds, or does that sound about right?
So, I put my husband over all of that, so I'm not going to have the best knowledge of that.
So that would be your husband?
Correct.
Right. But the private investigator that you guys hired answered to you, right? Not your husband?
He was hired by the estate.
So he communicated with you directly.
Both me and my husband.
Did you give him unfettered access to the house?
No.
How many times would you say that investigator was in that house?
That's going to be better to ask my husband as well, too. My husband went with him every time.
Totally fair. Did you guys have the video equipment set up inside the house?
Like cameras to
Yes.
monitor? Yeah, yeah.
When did you guys put that in there?
I apologize, but that is also better to ask my husband. He was over all of that.
All right. Court's indulgence for just a moment, Your Honor. Just a moment, Your Honor. I'm so sorry. Just one more moment. So, do you remember when you retained Todd Gabler to investigate Kouri Richins?
The exact date, I can't remember. I think it was at the beginning of April
So-
of 2022. Could have been in March. I don't
Within a
have the
couple
exact
of
date
weeks.
with me.
I'm sorry, I didn't mean to interrupt you.
Oh, sorry. No, yeah.
Within a couple of weeks of Eric's death.
Yeah.
Okay.
Correct.
At some point, did you guys plan a celebration of life for Eric beyond the funeral, like a celebration of life?
No. Did I? No.
Yes.
No.
You weren't involved in that?
No. We had the funeral.
Okay. And just one moment, I need to check one date. Hold on.
11th.
So,
I'm really sorry if I'm wrong, but I think it was the. Let's see. I have to see a calendar. I think it's March 11th.
so
I think-
within a week or so of his death, probably, give or take.
Yeah. It was quick after.
And wasn't there a celebration of life on April 1st? Do you remember that? Were you involved in that at all?
No.
Okay.
No.
Totally fair. Ms. Richens Benson, that is all we have. I'm sorry for your loss, and thank you for answering our questions.
Thank you.
Mr. Bloodworth, any redirect within the scope of cross?
Yes, Your Honor, thank you.
Please.
Ms. Richens Benson, you just discussed with.
That was my fault. Just trying to get ahead of the game, Scott. I don't know what caused that, but let's avoid that in the future. Keep going, Mr. Bloodworth.
Okay, Ms. Richens Benson, you just testified in response to the defense questioning about a civil lawsuit.
Correct.
Did the civil lawsuits begin on March the 28th, 2022, about 3 weeks after Eric's death?
That is when it was filed. It was threatened very quickly after Eric's death.
And who filed the lawsuit?
Kouri did.
Against who?
Against me as trustee of the trust.
And to defend against that lawsuit on behalf of the trust.
Correct.
You employed Mr. Throckmorton, or your lawyers employed Mr. Throckmorton and Ms. Carrington.
Correct.
And then Kouri Richins was arrested on May 8th, 2023.
Correct.
After May 8th, 2023, did the estate or the trust employ Mr. Throckmorton or Ms. Carrington?
No.
The defense counsel asked you about a timeline where you presented certain information to the investigators, right? The detectives.
Correct.
And they referenced that information related to some financial information?
Correct.
Did that include your reporting that Eric went to get money from his bank and found an empty bank account?
Correct.
Did you also report that Kouri signed his signature on a $250,000 home equity loan against his house without his knowledge?
Correct, and that's what I told the detective that day.
And did you also tell them that Eric found multiple credit cards pulled in his name that he had nothing to do with?
Correct.
And that he talked to a divorce attorney?
At this point,
Correct.
we're going to renew our 401, 403, 404B. I'm also stating for the record that I think he's now kicked the door wide open. I want to recross on all the things I would have had in my direct because it all deals with this stuff.
You're going to have a longer conversation about the last piece. Your
Okay.
401 and 402 objections are overruled.
And 404B. All the financial stuff that we've litigated already. I think I have to do it when he tries to put the evidence in.
I know, but please approach for a minute.
Thank you.
Mr. Bloodworth, your next question, please.
All right, just want to thank everybody for joining us. Please hit the like button if you don't mind. Live court starts at 3. I have it pinned there at the bottom, posted on the bottom of the screen in white text there. Live court starts at 3. That would be Eastern, 1 o'clock local time, which is Mountain Time. And so in the meantime, we're watching or rewatching previous testimony. We're starting out with Kouri Richens Benson first. This is Eric's sister. And then decide what you guys want to watch next, because this should be over in about a half hour or so. So we have the medical examiner. She's about 3 hours, so that'll get us right to about 3 o'clock. We have Josh Grossman, who is the paramour. He's 2.5 hours. We have Robert Crozier. He's a little bit over an hour. We have Todd Gabler. He's an hour and a half, and then Chelsea is 3 hours. So kind of get in your mind what you guys want to watch next. I'm leaning towards the medical examiner, but you guys tell me what you guys want to watch. The choices are medical examiner, Josh Grossman, who's Kouri's paramour, Robert Crozier, who sold the fent and the substances to Carmen, Todd Gabler, who is the private investigator, and then Chelsea is the best friend that gave Kouri $45,000 as a down payment and then got kicked out of her home like a year later. So kind of think about what you guys want to watch next. And Kouri did say she got pregnant when she was a sophomore in college, which would have been about 2009. I don't know. They got married in 2013. So I don't know when they met. I don't know if she got pregnant from another gentleman or if that was Eric that got her pregnant. That I don't know. I'm not sure when they met. So, all right, let's continue on.
Did you also provide the police with information on Eric meeting with a divorce attorney, Christina Miller,
Yes, correct.
and Eric meeting with a trust and estates attorney, Crystal Bowman Carter?
Yes, I did.
Did you provide the police with information about a separate house rented in Oakley, Utah?
Yes.
Did you provide the police with information about a change in life insurance beneficiaries?
Yes, I did.
provide the police with information on friends of the defendants and Eric's that they should potentially interview?
Correct.
Did you provide the police with information about a discussion involving the trust and control of the house 2 days after Eric died?
Correct. You're referring to the altercation on that, right?
I am.
Okay, yeah.
And then did you provide some information to the police regarding, I think you mentioned earlier, like a demand notice as it relates to the civil lawsuit?
Yes.
Thank you. Nothing further, Your Honor.
Okay. Ms. Nestor, why don't you perform any recross that you think is within the scope of that redirect? We'll take a break, have an additional conversation.
Thank you, Your Honor. I'll be happy to. I need to grab that back from the
No problem.
email. Okay, so just to put in perspective what just happened, all those things Mr. Bloodworth talked about that you told the police about, we're talking about March 21st, before y'all even know how Eric died, right?
Correct.
And he talked to you about a HELOC, is that right?
Correct.
And what's a HELOC? Tell us what that is, what it stands for. Do you know what it stands for?
I do not know what it stands for.
That's
I'm
okay.
sorry.
What do you know it to be?
Like a home equity loan?
That's what it stands for.
Okay.
Home equity line of credit. Does that sound familiar? Okay. So tell me, as far as the HELOC goes, it's your belief that Kouri got one of those on the house without Eric's knowing about it, right?
Correct. Eric told me.
Okay. And one of the documents that you executed as trustee, when you became trustee of the trust, was something called a durable power of attorney. Do you remember that?
That I executed?
I'm using fancy lawyer words, I'm sorry. A document you had to sign. Where the trust gives you power of attorney over all of Eric's assets. Does that sound familiar?
Yeah, I was his power of attorney.
Right.
Yeah. I
And
don't
that
think it
was-
was durable. I think it was power of attorney.
Just leave that word out. It doesn't even matter. All right. So you had a power of attorney, and that was before Eric died, right?
That I had a power of attorney before Eric died?
To be trustee, if he ever did die. Do you remember?
I would have to ask my lawyer that too.
No
I am
worries.
sorry because I know all of it's very different, and
No worries. I don't want to turn you into a lawyer up there.
Okay.
This is actually really important.
Okay.
So there was a time where you had to revoke all prior power of attorneys that were granted by Eric in order for you to have the final power of attorney, right? Do you remember that?
Is that on like the letter's testimony? Or you'd have to show it to me.
I
I'm
will.
sorry.
Let me pull it up. Katie, do you have the revocation? Yeah, just a minute. Let me look at what the number is. It's KRB 5 or 6. This one, it's probably. Do you see it? Yes. The revocation? Okay, can you pull that up on the screen? Only for, Your Honor, we only want to show this to the witness and counsel
Understood.
for right now.
That document witness in front of the witness and counsel.
Do you see the document?
Yeah, so that's something my brother signed to revoke any power of attorneys after he found out that she used his. That's not something I've signed.
That's
I'm sorry, objection. The copy I'm looking at is not signed by anybody.
Yeah, and this one's
that's
not
okay.
signed.
We're-
Yeah.
I can follow up on what you just said because it sounds like you know what I'm talking about.
Do you have an objection?
I just want to make sure we're looking at the same document. She said signed, and I'm not seeing
Oh,
any-
okay.
Two are looking at the same document.
Yeah,
Whether it's the same document.
it's not signed, Brad. That was my bad.
Pause for one moment for me, Katie. Whether Ms. Nestor's referring to a different document, I don't know.
Understood.
I think I can clear all this up, and I don't really care too much about the document itself. I'm trying to refresh your memory. It sounds like it's refreshed. So you remember that Eric had to revoke power of attorneys that Kouri had previously had.
Yes, Eric did revoke it.
And you remember what that means is she had a previous power of attorney from Eric. Is that right?
She did have a previous power of attorney, but he did not know that she used it and
Okay.
took out the money.
But the power of attorney she had, and he was upset about it and wanted to revoke it so she couldn't do it again. Is that fair?
No, to be fair, he said he never signed that one, so there's a lot of litigation on if that's actually proper or not, because he said he did not sign that one. But she did have the
Your
signature
Honor,
on
hold
it.
on just a minute.
Yeah.
Your Honor, we did not ask her to say what Eric said specifically. I would ask that we strike that, or at least tell the jury it's for purposes of why she did what she did and not to take it for truth of the matter.
So let's be careful here. There have been times when Ms. Richens Benson has given an explanation for why she did or didn't do a thing, and that may have included her recollection of what Eric Richens told her. Those comments so far are inadmissible hearsay that cannot be considered for their truth as to whether Eric actually did those things or not, or thought those things or not. Rather, they can only be considered as context for why Ms. Richens Benson, as the listener, the hearer of those comments, did or didn't do whatever she did or didn't do next.
Thank you, Your Honor. I appreciate that clarification. So to go back, it's your understanding, I just want to I'm not going to beat a dead horse here, but I'm hearing you say that you knew that there was a previous power of attorney that had been given to Kouri, whether Eric signed it, didn't sign it, that there was a dispute about that, and at some point before he died, he said, I'm going to revoke all previous power of attorneys, including that one.
Yes.
That's what I needed. Thank you very much. Also, Mr. Bloodworth just asked you about Eric seeing a divorce attorney. Do you remember when that was?
The dates and everything, it was in 2020.
So
It was before he did his will.
about 2 years before he passed, he saw a divorce attorney, right?
A year and a half.
And is it true that you or your husband are the person who set that meeting up with the divorce attorney?
Correct?
Which one of you?
My husband.
And did you just know this person, so you're like, hey, use this lady, or why were you involved in that?
I wasn't. I just said it was my husband, so you'd have to ask him on that.
Totally
Sorry.
fair. Also, Your Honor, because, may I approach just to be safe?
Yeah.
When you were previously being questioned by me, I asked you a question and we decided we weren't going to go into that, but we are going to go into it now, so I'm going to ask it very specific, okay? Did Kouri ever ask the trust to pay her any money in the year after Eric's death, separate from the litigation? Did she ask you to make any disbursements to her or the boys in the year after Eric died as trustee?
Not that I can remember.
That's all I have, Your Honor. And we will fully release this witness. She can remain in the courtroom for the remainder of the trial.
Okay. Mr. Bloodworth, any additional questions for Ms. Richens Benson?
No, Your Honor, thank you.
You're welcome to step down.
Okay,
Thank you. Watch your step, please.
I'm okay to just go sit?
Yes.
All right, you guys. Just want to let you know, for those folks that are coming in new, live court's going to be on today, Friday, at 3 o'clock Eastern, 1 o'clock Mountain, which is their local time. So in the meantime, we're filling in the time and refreshing our memory. So we're going through we're going through previous testimony. So I appreciate you guys joining us. Court is going to be live today at 3. Both parties and the judge are going to be going over jury instructions and the verdict form. The jury is not coming back until Monday. So the jury's coming back on Monday to hear closing arguments, and the jury instructions and the verdict form, which is what the parties, defense, state, and the judge are going to be going over today at 3. So again, live court will happen at 3, and if you look, see the bottom right of the screen, I put live court starts at 3 Eastern. So I put it there so that if you have any questions, if anybody comes in and asks why, is this live or not, you can direct them to that to the text there at the bottom right of the screen. So in the meantime, we're rewatching past testimony to kind of refresh our minds, get us back into, now it's kind of like hindsight, right? We went through the trial already. Both sides have rested. So now we're kind of going back and we're looking at what the testimony was now that we know what we know, going through the trial. So before we get to the next testimony, I have a poll going. Who would you like to watch next? We have the medical examiner at 33%, Josh Grossman 22%, Robert Crozier 17%, Todd Gabler 27%. So right now it looks like the medical examiner is going to win, and she's on the stand for about 3 hours as well. So that should get us to our 3 o'clock starting time for live court. But before we get to all of that, Selena Kay, who has been at the trial, she's been in the courtroom watching the trial, and she has called in a couple times. We are very grateful and thankful that Selena has called in, and I want to show you this picture that she said Greeners made for her. Wait, hold on, let me find it. Where is it? Why can't I find it? Huh. Hold on a sec. Hold on a sec. I just had it. All right. Give me one moment. Let me, I don't want to just hold up my phone because I did that before. So I want to show you. Okay. Let me see here. Here we go. Okay, here we go. All right, so here is our very own Selena Kay, who went to the Mirror Lake Diner and ordered some food. So there's Selena in her Mirror Lake Diner shirt. I think that's great. So that's Selena Kay in her Mirror Lake Diner shirt. So pretty fun, right? So again, thank you, Selena, for being in the courtroom and calling in. All right, I'm going to go ahead and I'm going to end this poll. And it looks like the medical examiner has one out. So let's go ahead and let's see. Let's show the medical examiner next. And I also want to thank you guys for voting when you came in that if you were on the jury, how would you vote? So guilty on all charges. 63% of you said guilty on all charges. 22% of you said guilty on just the aggravated and attempted deletions. 7% of you said guilty on the forgery and fraud and not guilty on all. 8% of you said not guilty on all. So 63% of you said, and over 2,000 votes. So really appreciate your voting there. So 63% of you said guilty on all charges. 8% of you said guilty, not guilty on all. 22% said just the aggravated and attempted. And then 7% said just on the forgery and fraud. So appreciate you guys being with us. And let me pull down Selena there and let me find our medical examiner. Let's see here. And again, we want to thank Top Mark Media, Recovery Addict.
Do you solemnly swear?
Scott, if you guys know who he is, Recovery Addict, he has Top Mark Media, and he's been streaming this trial, and we've been using Scott's feed. So again, huge shout out to Recovery Addict, Top Mark Media. All right, so this is the medical examiner. She testified on, I think it was day 3. Where was she? Hold on a sec. That's Colin Gray. Let me get to my Kouri notes. Yeah, day 2. So she testified on day 2. So this is, I'll pin it as well, Dr. Pamela Sue Ulmer, and she is retired. So she was, all right, so this is rewatch. So this is the state witness. All right, state's witness number 10. All right, state's witness number 10. Medical examiner Pamela Sue Ulmer. She is retired, but she did the autopsy.
Swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury. Thank you. Please have a seat.
Do you mind bending the mic down just a little bit? Thank you. Mr. Burmester.
Thank you, Your Honor. Can you please state your full name and spell your last name for the record?
Pamela Sue Ulmer, U-L-M-E-R.
Ms. Ulmer, are you employed?
No, I'm retired.
In 2022, were you employed?
Yes, I was a medical examiner at the Utah Office of the Medical Examiner.
There's a term forensic pathologist. Is that what the capacity you were serving in?
That's correct.
What is a forensic pathologist?
So a pathologist is a medical doctor who has gone through all of the medical training and then done residency in pathology. For a forensic pathologist, we do additional training in forensic pathology specifically, and then we sit for boards and take all of our board certifications for both pathology and forensic pathology.
I see. So when you receive a body, just generally speaking, into the OME, what is the procedure? What happens?
So basically, I'll start at the scene because an investigator will be at the scene, and then the body at that point will get sealed in a body bag that has a seal identification number on it, goes through the zipper pull so that it can't be tampered with while it's being transferred from the scene to the office. Once it gets to the office, then it's brought in and documented by a morgue clerk who's going to put various information into the computer, identifying information and stuff. We used to actually open the body bag at that time and take an identification photo, and then the body would go into the cooler. But I believe we changed our policy though, so that at the time that this event was going on, the body bag was still sealed when it went into the cooler, and it wasn't unsealed until we would start the autopsy examination.
I see. So did you perform an autopsy on the body of a person named Eric Richens on March 5th of 2022?
I did.
Do you recall about what time that began?
I don't have any paperwork with me, but it was around 7:30 in the morning.
I see. You very briefly went into your education. Could you give us a brief description of your education to become a forensic pathologist?
Sure. So medical training is a 4-year degree. I specifically went to an osteopathic school, but whether it's an osteopathic or an allopathic school, it's the same type of training. So I did my medical school at Des Moines University in Iowa. Then I went on to do my pathology residency training at Creighton University in Omaha, Nebraska. So that's typically either a 3-year or 4-year program, depending on what you're doing. For me, because I was going into forensic pathology, I opted to do 3 years of pathology and then 2 years of forensic pathology training to take care of all of my residency and fellowship training.
I see. So after all your training, where did you go next?
So I did my fellowship. The first year of my fellowship was at King County Medical Examiner's Office in Seattle. And then at that point, I still had 1 more year of training that I needed to do, but I got hired on at the Medical Examiner's Office in Salt Lake City. And so we coordinated so that my first year at the office would also count as my 2nd year of forensic pathology training.
I see. Did you stay on then after that year?
I did.
Okay. How long did you serve then, the Utah Medical Examiner?
So I started my employment there in July of 2009, and I retired January 1st of 2023.
That 2009 is including that year of
training, yes.
Yes, okay. Are you, or at the time, were you certified by any certifying board?
Yes, so I was certified in anatomic, clinical, and forensic pathology by the Board of Pathology.
Were you a member of any professional organizations?
Over the years, I've been a member of a variety of pathology-related and forensic pathology organizations, including the National Association of Medical Examiners, as well as the American Society of Clinical Pathology.
Have you ever testified as an expert in forensic pathology?
Multiple times.
Okay. Do you have a ballpark figure for how many times?
You know, I don't have my case log anymore, so a lot of it was preliminary hearings for various cases, and then as well as doing like other types of cases. So maybe about between 75 and 100 times for all of my testifying.
When you do an autopsy, first of all, what is an autopsy, I guess?
So it's an external and internal examination of the body. So we're basically looking for why the person died. We do an external examination describing any unique features of the body. In a forensic autopsy, we also describe like the clothing, any identifying features like the color of the eyes, any tattoos, anything like that, because we need to know who the person is as well as why they died. So all of those items get documented. Additionally, any like scars or anything like that to show any prior medical procedures or injuries. Any injuries that they might have sustained, whether it's bruising or a gunshot wound or anything like that. And then once all of the external items are documented, then we start on the internal examination. So we'll do a Y-shaped incision on the chest. Skin gets reflected as well as the fat and muscle. And then we can see the rib cage. The rib cage will get removed. Then we're looking at all of the organs in the chest and abdomen. So those all get examined in the body, and then they're removed and weighed to see if they look normal and whether they're of normal weight or within range of normal weight. And then we do the same thing with the head. We'll make an incision across the top of the head, reflect the scalp, and cut the skull off so that we can look at the brain in place and then remove the brain and look at it out on the table and weigh it. Everything is sliced so that we can make sure there's no natural disease on the inside that would explain why they're dead. Like if a person had a stroke, we might see that in their brain. If they had a heart attack, we might see a blood clot in their heart, or there might be muscle deterioration. So a lot of different things that we can examine and document to explain why the person is dead. We also draw different blood samples, urine sample, gastric contents. We're looking at all of that so that A, we can see what it looks like, and B, so then we can retain it for toxicology purposes.
I see. So you go through, it sounds like you go through these methodically, like system by bodily system.
Yes.
Okay, is that the standard in your field?
It is.
You mentioned also that you'd take samples, blood, gastric, etc. Do you always analyze those, or is that just by case by case?
Some items are case by case. We'll routinely do toxicology analysis on blood and vitreous fluid. So that allows us to screen for common things, and then we can determine whether an expanded panel is needed or other testing. Since this case was during the COVID era, pretty much everybody was getting swabs so that COVID PCR could be done. And then there's other microbiological cultures that might be performed on a case-by-case basis, as well as other types of laboratory testing for, say, like potassium level or something like that. So it depends on why we think the person might have died to answer those questions.
Do those samples get sent out to other labs, or are they examined internally at the medical examiner's office?
They get sent out to other laboratories.
I see. You talk now about generally the procedure. Is that what you followed in this case?
Yes.
Okay. With identification, you mentioned right off the bat is an important thing. Is that what you did in this case?
Yes. So obviously at the scene, because he was at his residence, his wife was able to identify him. But we also look at photographic identification, meaning driver's license, and we can compare that to the individual to make sure that they look like their photo. So that's, if it's a case where there's additional identification needed, because maybe we don't know who they are and they don't have any identification with them, then we can do fingerprint analysis, or we have to go further, we can do DNA analysis.
But you didn't have to in this case?
No.
So do you have a worksheet or something that you use as you go along and write information, such as the time, the seal number, and all those things?
Yes, there's an autopsy worksheet.
Okay. Can I show to the witness State's Exhibit 10-4? Do you see that up there?
Yes.
Do you recognize it?
So it's a body diagram
Okay.
showing notes that I made during the autopsy.
Okay, and is it a true and accurate copy of that worksheet?
Yes.
State would offer State's Exhibit 10-4.
Counsel. No objection.
10-4 is admitted.
Would ask to publish that.
There you are.
Okay, there's one thing I wanted to have you identify. Have you written down the tag number from the seal?
Yes, I have.
And what's that number?
It's 0002713.
Okay. Let's move on then to the external exam. What did you notice or anything? We can take 10. I don't think that 10-4 is necessary.
So basically, he had evidence that he had received CPR. He had an endotracheal tube in his mouth. He had needles in both shoulders in order for IV fluid to be submitted. He also had defibrillator pads that were on him. There was really no evidence of injury. EKG pads were also present, and I'm not sure.
Okay. Well, was there blood present externally on his face?
There was.
Can you explain that?
So, in cases of potential drug overdose, it is not unusual for opiate overdoses specifically to have pulmonary edema. So you've got foaming of the mouth coming from the lungs. And then in addition to that, then when you're receiving CPR and you have that intrathoracic pressure that every time a compression is made, that's contributing to the lung injury. And so it's not unusual to have blood seeping out with that fluid from just the vasculature of the lungs. But in addition, when somebody gets intubated, there's a risk that they might get mouth injury or they might get other injury just when the tube is being inserted. And so with that, every time you're doing a compression, you've got potentially blood-tinged fluid that's spurting out.
I see. Did you see any evidence of injury that contributed to death during your external examination?
No.
Okay. Let's move on then to your internal examination. What is the first thing that you look at?
Well, the first thing I looked at were the ribs. He had rib fractures on the left side, on the front. I believe it was ribs 4 and 5 were fractured, which was most likely from CPR.
I see.
And then you remove the chest plate and you're looking at the heart and lungs.
Well, let's take a look then. Let's go down system by system. Did you lay those out system by system in a report that you subsequently produced?
I did.
Okay. Cardiovascular system. There's a mention here of 50% occlusion. Could you tell the jury a little bit about what that means?
So it just means that he had the beginning stages of coronary artery disease, so that the lumen of the vessels in his heart were thickened. It's usually not thought to be significant until they're at least 75% occluded or more. And this is a common finding in adult males in general, and then adult women as they also age. There was no indication of any kind of coronary artery thrombus to indicate that he had a blood clot form in his heart and cause a heart attack. And so there was no damage to the heart muscle. The heart was within normal range for weight.
Okay. So that was not a cause of death?
No.
Okay. Respiratory system, you noted trachea, bronchi, foam present.
Correct.
I think you've said that was probably from CPR.
So it's probably originated from his fentanyl overdose.
I see. Okay.
CPR can also cause pulmonary edema, but since he had no return of circulation during this CPR process, the majority of that fluid and that foam probably originated from the drug overdose, but CPR can still contribute to it.
I see. Okay. Pleural surface small tan white nodules.
Yes.
What does that mean?
So on the surface of his lungs, he had these little tiny white nodules all over, which are little granulomas. I looked at them. So in addition to removing all of the organs, I also did histologic examination on the main organs, which means I took a little piece of tissue so that it could then be cut very thinly and then stained and looked at under the microscope.
And did you look under the microscope at these?
I did.
Okay.
And so you can visually see them on the lungs just looking at them grossly. They were very obvious. And they're just little small granulomas that were coating the surface of the lungs.
I see. Is there some significance in this case about those?
There is, because his history, his work employment history, he was a stonemason. And so all of that dust that's created when you're cutting either brick or blocks, you can inhale it if you're not wearing a respirator or a mask. And then that goes into your lungs, and your body tries to protect itself by sequestering that stuff off, and so then these little granulomas form.
I see. Did that contribute to his death?
I don't believe it did. He had the granulomas present. He also had a small amount of pleural fluid present associated with these, but it wasn't significant enough. There wasn't like scar tissue that it was in his lungs that was preventing him from breathing or anything like that. So I felt like it did not contribute to his death.
I see. Did you note anything about his liver and biliary system? Biliary?
From my recollection, the liver was normal. There was no surprises there.
Okay. What did you note, if anything, about the digestive system?
Again, I don't have any notes in front of me, but he had about 700 milliliters of pink fluid that also had like food particles in it that were partially digested. Some of that was retained and saved for toxicology purposes.
Did you have a discussion with Brianna Peterson from NMS about the volume that you measured from the gastric?
I may have. I don't recollect it.
I see. Do you have any idea about the pink coloration? Was that from anything that you're aware of, or?
No.
Is it? Okay. Urogenital system.
Okay.
Was there anything? Did you note?
Kidneys looked fine. Bladder looked fine. The genitalia all looked normal within limits. So.
Reticuloendothelial system.
So that's referring to more like your organs, like the spleen or lymph nodes, things that have to do with immune response. And he did have. So when you have those types of granulomas in the lungs, it's not unusual for the lymph nodes surrounding the lungs to also have the same kind of stuff in them and also have granuloma formation. And I did see that when I did histology on those lymph nodes in that area.
I see.
Otherwise, the spleen and everything looked normal.
Okay. Endocrine system? Was there anything that you documented?
No.
Excuse me. And musculoskeletal system, anything?
Other than the rib fractures, was all normal.
I see. Now you mentioned you sent some samples out to histology. Did you receive those things back and look under the microscope yourself later?
I did. For part of them I did. Part of them were examined, I guess, at the state lab. So let me clarify. So we did microbiology testing of the lungs, which you just collect a swab. And so each lung was swabbed and sent to the lab. We had that tested for bacterial infection as well as fungal infection and then TB infection. And that was significant because we had all of these granulomas in the lungs, as well as he'd recently had a history of having COVID. And so just to confirm that there was no active infection going on that I could document that was causing those granulomas, like TB, for example, or any kind of fungal infection, all to explain what was going on in the lungs. And the only thing that I saw, again, was the granulomas that were due to his work history. In addition, I did special stains to confirm that there were no fungal elements present and that there were no significant changes to the lung tissue, as well as the heart and the liver and the kidneys. I did see the granulomas in the lungs and those lymph nodes.
So absolutely no fungal infection in the lungs?
No. And to clarify, that was not by culture, that was only by looking at the stain.
Okay.
So,
did you, we'll get to that, I guess, in just a minute. I guess with histology, you also sent out liver samples, epiglottis, or was this just part of your internal exam? Maybe I mixed that up.
I think I did submit a section of the epiglottis, and I'm not sure whether that was specifically because he had a history of allergies that was reported, and just to confirm that there was no evidence of anaphylaxis.
And was there?
The tissue was denuded, but I did not see any evidence of histamine release granules that were in the tissue itself, so I can't. It did not appear that anaphylaxis was an issue.
Okay. Did you send out samples or send out samples to the health department for disease and fungal cultures?
So I did for the bacterial cultures, I did for the TB stain or the Mycobacterium stain, and I don't have the autopsy report in front of me, so I can't answer a lot of this stuff.
Would it be helpful to look at your report?
It would be, yes.
They approach the witness.
Of course.
Does that look familiar to you?
Yes, this is the report that was generated by myself after the autopsy examination was performed on Mr. Richens.
Can you find the portion of your report where you're talking about disease, the samples that you sent to the public health lab?
So for the public health lab, we did an auramine O stain, which is a special stain that they do looking for acid-fast bacteria, and that's to help rule out tuberculosis, which again would be something that would cause that type of granuloma pattern on the lungs. And that was negative as reported by them because they observed it. I did not look at that particular slide. In addition, we did bacterial cultures, again, on the right and left lung. Those grew up multiple organisms, and when I see that, usually what it means is it's just normal flora from the respiratory tree, and then as you are dead, these organisms just continue to grow inside your body, and so you will see more of them show up with these postmortem cultures. If the person was dead from a specific bacterial infection, say like streptococcal pneumonia or something like that, you should predominantly just see the streptococcal bacteria and not all of this other stuff quite as broadly. So that just looked like postmortem change. And then we did a blood bacterial culture, which also, it came back no growth, and so there was no evidence of any kind of sepsis. The COVID swab for SARS-CoV-2, which is the organism name, that was negative. Positive. So he did test positive for COVID. And my understanding is that he had been sick with COVID-like symptoms, more of like a cold, recently prior to his death. But at the time of autopsy, he did not show any evidence of like pneumonia that we would normally see for someone who's dying from COVID.
Your Honor, there's a good little portion left. I wanted to know, based on time, if this was, could we break and return to Dr. Ulmer, or would it be?
Any objection, Mr. Ramos?
No, that everybody would like that.
Okay. I need you to sit tight for just a moment, if you don't mind. Folks, let's take a lunch break. We have lunch for you. It's 12:10. Why don't we come back at 12:45? Is that agreeable, counsel?
Here's to the state.
Judge, if I may, get up just a little. Sorry, Judge.
It's okay.
All right, welcome in everybody. I just want to remind you that live court starts at 3 o'clock Eastern, 1 o'clock local time, and we are rewatching Pamela Sue Ulmer's testimony from day 2. She is the medical examiner. She is retired, and we have about just under 3 hours to go until live trial starts. I just want to welcome you guys in. Thank you for joining us. Please hit the like button if you haven't already. And we will continue on with Pamela Sue Ulmer's testimony. Retired medical examiner Kouri Richins.
Anything on the record before we invite the jury back in?
No, Your Honor. Thank you.
You're still under oath. Okay, sounds good. Have some water. Okay. We're ready for the jury.
Thank you, Your Honor. Dr. Ulmer, when we last left off, we were talking about the results from the Public Health Department.
Yes.
Neighboring the Public Health Department is the tox lab. My understanding is there was you had sent a vitreous sample to the tox lab for testing there.
It was routine to send vitreous samples to the state toxicology lab for volatile testing, which would mean looking for various alcohols, like alcohol that you would ingest, like ethyl alcohol or methanol or other alcohols that could be determined whether that would participate in the cause of death or not.
And vitreous fluid is from the eyes?
That's correct.
Okay. So in this case, did you get a result back from them?
If I can get that report back, that would be helpful. But my recollection was that the vitreous fluid was negative for any type of volatiles. Thank you. Yes, it's none detected for ethanol, acetone, isopropanol, or methanol.
Okay. Is there something important about vitreous versus blood with regards to alcohol that you're aware of?
Well, it's multiple things, actually. For one thing, it's kind of a sequestered area. You don't have direct blood flow to that area, so things just kind of pass through the membranes as opposed to having direct blood flow. And so it's kind of protected and it's delayed. And so like if you're comparing like a blood alcohol to the vitreous alcohol, the blood alcohol will be different than the vitreous alcohol depending on whether the alcohol is going up or going down in the intoxication time frame.
I see.
And then also because it's protected, you're less likely to have bacterial contamination of the vitreous fluid because some bacteria produce alcohols during decomposition, so you have more of this sequestered environment.
Okay, so a more perfect record, so to speak.
Yes.
Okay. So did you, you also sent out samples to NMS labs?
That's correct.
And what is NMS labs to your knowledge?
I'm sorry?
What is NMS labs to your knowledge? I mean,
They're a reference laboratory that does toxicology testing. So they do clinical toxicology as well as forensic toxicology, and we were using them at that time for any of our more complicated cases.
I see. Okay, and so you send it, and this lab is located in a different state or something?
That's correct. I believe it's in Pennsylvania.
I see. Did you get a result from them?
I did.
And what information did you get?
So the primary information was that there was a fentanyl level of 15 and a norfentanyl level of 3.3, and those are both in nanograms per mil. Additional information that was not confirmed but still indicated presence was naloxone, caffeine, and 4-ANPP.
Okay, so, and that's from the blood samples that were sent?
Correct. I'm sorry, because we did 2 different stages of testing.
Okay.
So this was all of the blood testing, and then after I got this testing back and we decided we needed more information, then we also had testing performed on gastric contents. And the purpose of that was to, A, determine if there were any other drugs present in the stomach contents that weren't necessarily showing up in the blood test, and then B, to give an idea of where the fentanyl might be coming from, because the question would be, was it orally ingested or was it injected, or, you know, trying to narrow that down a little bit.
Okay.
And so that was part of the rationale for doing the gastric testing.
Let's stick to the blood for a minute. First of all, where did you draw the blood?
So initially they probably would have attempted to do a femoral stick, but because when you die and you start going through all of these changes that your body goes through after you're dead, the blood clots. And so I'm not sure if this was specifically what happened for this case, but they probably tried to draw femoral blood, and because it's a smaller gauge needle, because they're just going down through the skin, they were probably unsuccessful in getting any of the blood to come up into the needle or any significant amount.
When you say they, who is they?
The autopsy techs assisting on the case with the autopsy, so that we have folks who are trained to assist with the autopsies, and so they will a lot of times do the toxicology sample collection.
Okay, so it's a team.
It's a
You and these other personnel.
That's correct. Our office is way too busy to just have the doc go boom, 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 and do everything. So.
I see. And so, did whoever drew the blood from that team, where did they end up getting it from?
So they ended up having to go inside when we opened the body up, and they entered in through the inferior vena cava. And then you direct it down towards the femoral artery, because the syringe that you're using when you're collecting these samples, when you're going into the body, not through the skin, but once you're inside and actually doing it, is a huge syringe with a big long needle. So the needle itself is probably 5 to 6 inches long.
I see. So, I'm not sure, femoral artery, I gather, is the legs?
You're going for so it's
By your femur.
But usually when you're collecting it, when you're going through the skin, you're going in the groin area.
I see.
And so you kind of go femoral, inguinal region, and so in this particular case, we weren't necessarily getting specifically femoral blood, but we weren't getting blood specifically from the inferior vena cava either. It was in that region.
Okay, so what is the inferior vena cava?
So in the body, you have arteries and veins. The arteries, generally, you're taking blood from the lungs that's oxygenated, and the heart distributes it out to the different portions of your body.
Okay.
And then the veins bring the deoxygenated blood back. And so the best source for collecting toxicology samples is peripheral blood, which is further away.
Okay.
And so when you're talking about the inferior vena cava, the leg veins come back and they connect in the middle, and this is the inferior vena cava that then eventually moves the blood back up to the heart. And so that's the process of bringing the peripheral blood then back up. And so it's still essentially peripheral blood, but you're getting closer to the major organs.
Okay, we'll talk about any problems with that in just a minute. So this quantity, you said there was, I think you said 15 nanograms per milliliter of fentanyl?
That's correct.
Okay. As a medical examiner, is that, explain what the importance of that number is.
So what you're doing is you're taking the information that you have and you're looking and comparing it to what would be expected in someone who's not taking the drug at all. You expect not to find any. Someone who's taking it as a prescribed medication, so you expect it to be within therapeutic range. And then once you start seeing above that, then you have the potential to go into a level that would be toxic, and if it's high enough, then potentially cause death.
Okay. And in this case, the number 15 nanograms in the blood, given its location.
So with the information available to me at the time of the autopsy, the decedent did not have a history of any kind of illicit drug use or prescription medication abuse. So the fentanyl level should have been 0. There should not have been any fentanyl or norfentanyl present. The fact that I have fentanyl present tells me that fentanyl was obviously ingested at some point recent. And then if you try to manipulate from the information that's available in the toxicology report as well as other toxicology references, then there's kind of estimated therapeutic range versus toxic range versus
15 nanograms per milliliter, is that a toxic range?
in someone who is not prescribed this medication and taking it routinely, it is toxic.
And what is norfentanyl?
Norfentanyl is a metabolite of fentanyl. So you're ingesting the fentanyl drug, and then it's being absorbed and going through the liver, and then you are having it broken down into other pieces, and norfentanyl is one of those metabolites.
Okay. And, okay, when it breaks down, like is it the body's way of getting rid of this toxin? I mean, it's breaking it down so it can get rid of it?
It could be breaking it down to be getting rid of it, or it could be breaking it down into a component that actually does the work.
I see.
So the drug that you ingest may not be the drug that's active. It might break down into other components that are active, or there might be other variables that play into it that I'm not describing very well because it's been too long since I've done this.
At some point in your, at some point in this process, did you request a Doppel report? You know, the report of any prescriptions?
That was a routine process that we did on cases, just to review and see if there were things that we should be paying attention to. And in this particular case, I believe that we reviewed at least 1 year's worth of medical history, and we might have gone back even a little bit further once we saw the fentanyl present. But I don't have any further information other than just the fact that there was nothing that was seen except for some testosterone, I believe, was the only thing that we saw that was in Doppel. So they don't see all medications. I think they just predominantly see things that are classified.
Schedule 1,
right,
2, 3,
right.
4. Your Honor, I'd like to just show the court and the counsel State's Exhibit 1-27.
One moment, please. I'll fix that, I promise. Thanks, Ken.
No. Oh, yeah. No, 3006 is the Doppel, or no, the, and,
Why?
can you put it up on the, that one, yeah. Yes. I'm just asking, is it 3006? Yeah, okay. Okay.
Mr. Burmester, the witness is currently looking at states 1-27.
Your Honor, the state would proffer that 1-27 is a self-authenticating document, and we would offer states 127.
Is there any objection? What's that? Is this a one-page document?
It should be 2 pages, Your Honor.
Scott, can I see the second page? I don't know that Mr. Baramos saw the second page. And you should take a look at the second page.
Oh,
before.
sorry, Judge.
Yeah.
I see the first page. May we approach it?
Of course.
All right, welcome in everybody that's coming in new. We are rewatching some previous testimony until live court starts at 3 Eastern. So this is Pamela Sue, Ulster? Sorry. What is her name? What's her last name? Ulmer, I think. Pamela Sue Ulmer. The medical examiner. Pamela Sue Ulmer. She's retired medical examiner. So live court starts at
Next question.
3. So be sure to hit the like button. Appreciate it, guys.
Mr. Burmester, your next exhibit or next question, please.
Yes. The, excuse me. So, did the medical examiner's office receive prescription medication bottles and or prescriptions with the body?
Yes, they did.
And so did you or your team make note of those?
Yes. There was information in the investigator's report, and then there's also a separate form that shows the inventory that would have been done by a different investigator.
Okay. Can I take a look at State's or Defense Exhibit 3006, please? I think that's been offered and admitted and published.
Yeah.
So,
It hasn't been published yet, but.
oh, it hasn't?
No objection.
Okay. Would ask that it be published.
Okay, one moment. There you go.
Okay. So there appears to be 5 substances. Can you, I guess they're not substances. These are taken from labels of bottles?
Yes, these are medications.
Okay. Can you, starting from the top, going down to the bottom, can we talk about those?
So there's an injectable form of testosterone, doxycycline, hydrocodone/acetaminophen, and then disulfiram and naltrexone.
Okay, so let's what is the doxycycline?
It's an antibiotic. It's a
All right, so these are the prescriptions that were found in Eric, right? So there's the testosterone, there's the so these are all the things that were found. No THC, but these are prescriptions. All right, these are prescriptions. Not that fent would have been found because it wasn't prescribed to him, but I don't know these. The only one I really know is the hydro, because that's what everybody talks about, of course, testosterone. I don't know about these others. If you guys know what the deal is with them, but thank you so much, Karen. Really appreciate that. Thank you for your Canadian $10. Thank you. Really appreciate that. And hey, butterfly, how are you? Hello from the bushes. So what's these are all prescriptions. So I'm assuming these are all okay, right? These are all okay. But again, no THC was found, and of course they found fent 15 times what would have normally taken out somebody. So there you go.
Broad spectrum antibiotic.
And according to the label, when was that prescribed?
That was prescribed July 3rd of 2019.
Okay. By Dr. Peterson?
Correct.
Okay, then the next one is hydrocodone.
It was prescribed June 29th of 2016 by Dr. Charles Lind.
Okay. And hydrocodone, do you know what that is? Or
It's a pain medication. It's another opiate pain medication.
okay. Then we've got disulfiram.
Sulfiram was prescribed December 9th of 2019 by Dr. Andrew Peterson.
And does it have multiple uses?
It does. As a prescribed drug, it's commonly used for alcohol prevention. So another common name for it is antabuse.
I see.
And then as an off-label use, it's used for chronic symptoms of Lyme disease.
I see. And naltrexone.
Naltrexone was prescribed August 24th of 2020 by Dr. Hunderman. Again, it's also used for helping to prevent people from drinking, and then it's also used for opiate reduction. So,
And does it have an off-label use?
it's also used for chronic symptoms or complications from Lyme disease.
And this last one was prescribed in when?
2020. It's August 24th of 2020.
And
Okay, so did I misspeak? These were prescriptions found with. Okay, so these weren't found in Eric's body. These were found around the home, and they transported with his body in the body bag, I guess, right? Is that I guess that's what you guys are saying. And I know they did that. I know they collected stuff and they put stuff in the body bag with Eric. So this was found, I guess, around the home that they transported with him versus being found in him, right? Is that I guess that's how it worked. Even though, yeah, it says reported prescriptions found with. So I guess this is what was transported with him in with Eric, not found within him. So if I misspoke, I misunderstood that. I thought this was what was found inside of him. This is just what was around the house, I guess. Okay. In the home, not in the body. Okay, gotcha. All right, thanks, guys. Okay, cool. All right, let's continue on. Thank you.
how many were prescribed according to the label?
90 pills were prescribed. There were still 88 pills that were remaining.
Okay. Now, this is probably a super dumb question, but take hydrocodone, for example. If it's old and beyond its expiration date, does it spoil, like food spoils and becomes more toxic, or not?
Not that I'm aware of. Generally what happens is that these medications tend to get less useful. They get weaker, if anything, but pretty much for a lot of them, they're stable for a really long time.
Okay. let's move on. You said that at some point you asked to have NMS lab examine the gastric contents.
I did.
And you published a second report?
Yes.
This is the... in case you have to, if you can't remember, oh, you've got the gastric in the main one?
I hope, well, the supplemental is attached with the original, so I've got it.
So what was tested for out of the gastric contents?
So again, it was for a complex toxicology panel that does, a wide range of drugs. And in this particular, so in the gastric contents, and I just have to be careful when I'm looking at this because they've combined both items into one report. So there was some ethanol present. That was 279 milligrams per deciliter.
Okay, let's talk about that for just a second. Does that mean there was 279 milligrams per deciliter of vodka or beer in his stomach when they tested it?
Well, it's not that simple because you have to take the volume of the gastric contents and then determine a bunch of information. So in essence, yes, per the aliquot that was measured, this is my understanding of it, that's the amount that was present in that test.
Now you mentioned before about decomposition. Is that a potential problem for this gastric sample?
It is, because you'll have bacterial contamination in the stomach, and so that could potentially create a false positive.
Is there a way to determine what is alcoholic beverage versus decomposition alcohol?
No.
Okay. What else did you receive back?
So there was a presumptive positive for acetaminophen. There was a presumptive positive for caffeine. Quetiapine, which is an antipsychotic medication, was present at 16,000 nanograms per mil. The ethanol level was confirmed. Again, fentanyl was present at 20,000 nanograms per mil. And the norfentanyl was present at 52 nanograms per mil. And acetylfentanyl was present at 29 nanograms per mil.
As a medical examiner, do those numbers mean something in particular to you?
They mean call the toxicologist.
Okay.
Basically, as a medical examiner, I can say that we know that he reportedly had a drink at bedtime, so that might explain that presence of ethanol, or it could be decomposition, either one. We know that he was not reported to be taking any medication, so then I have no explanation for the quetiapine or the norfentanyl or fentanyl or the acetylfentanyl.
You've already said if for someone who is not using fentanyl that the 15 nanograms per milliliter in the blood was potentially toxic.
Correct.
How about the 20,000 nanograms per milliliter in the stomach contents?
I can honestly say, since I haven't talked to a toxicologist in over 3 years, that I would defer to them because it sounds like a lot, but without having reference ranges to go by or someone to consult, I would not jump on that bandwagon by myself.
Quetiapine, did you find any evidence that he had been prescribed quetiapine, either through Doppel or through the medicines that you looked at?
No, and I didn't see any mention of it in the medical records that I had reviewed at that time, so.
Okay. Well, that's a good point. When you made your report, were you able to come to an opinion, a conclusion?
Yes.
About cause and manner of death?
Yes.
And at that time, what was it that you were relying on to render this opinion?
So I was relying on information that was provided by family members on, how he'd been feeling or how he'd been acting. I was relying on information that was acquired by our death investigator. I was relying on information provided by law enforcement. And then I was also reviewing medical records from the physicians that I knew of that I could get records from.
Okay. In addition to your own observations of autopsy.
Right, and then in addition to, reviewing Doppel and seeing what his history was.
Okay, so what was your opinion of the cause of death?
My opinion of the cause of death was drug intoxication by fentanyl.
In addition to the NMS labs, was there other evidence that you looked at, specifically, say for example, pulmonary edema, that corroborated the information that NMS labs provided?
Yes, he had heavy lungs and foamy edema. Like I said before, some of that could have been contributed to the CPR, but it was still quite an abundant amount that was present. So I would have a hard time excluding that wasn't also caused by the drug intoxication.
That's primarily occurs due to opioids?
Yes.
And
it can happen with other medications too that cause respiratory depression,
but there weren't any other intoxicants or medications other than fentanyl
that were prescribed or that were contributing
that we know of. There was quetiapine found, fentanyl found.
Quetiapine can cause some sedation, but in this instance where we didn't initially see it in the blood, I don't know what to make of that since it was only seen in the gastric.
Okay. What opinion did you come to with regards to manner of death?
Could not be determined.
Okay, now let's talk about that determination is guided by a statutory scheme, is that true?
Yes, we have classifications that it's divided into, and basically it's for statistical purposes. It's not really designed for other purposes per se, and so we're limited to natural, accident, homicide. I'm just blanking here.
Suicide?
Suicide, and then undetermined as well. And so because this investigation was still ongoing when I retired, I felt that could not be determined was the best solution for me to finish my report before I retired.
Okay. So were there some, since the investigation's ongoing, you didn't have access to certain things?
Correct.
Did you have access to the forensic examination of electronic devices?
No,
Did you have access to financial documents investigation?
no.
Okay. At some point, do you release your report to family? Or,
Yes, unless there's some reason not to.
Okay.
Yes.
Yeah.
They need it for insurance purposes and just other documentary reasons.
okay, so on, can we take a look at State's Exhibit 124, please?
The witness has it.
Do you recognize this?
No. Oh, it's scrolling through, so
Oh,
it's a records request form.
okay. There's some notations on it about ready for pickup and
You may need to zoom in, Mr. Burmester.
This record is from the Office of Medical Examiner, is it not?
Yes, but it's not something I would normally be looking at, so.
I see. Okay. We can, let's move on. During the course following the death of Eric Richins, until the records were released, did you have an occasion to talk to Kouri Richins?
Yes, multiple times.
Okay. And how did that, mechanically, how did that operate?
She would call and leave a message with the front office staff. The front office would leave a message on my desk, a written actual message form.
Can we see State's Exhibit 122, please?
And then I would call her back.
Okay. Is
Do you want her to see 122?
122?
My apologies, one moment. Witness can see it.
Okay.
Are those the slips that you received from your reception?
Yes.
Okay. And then, is it the policy of the OME to document when you talk to people, such as when you call?
Yes,
Kouri
we have a
Richins?
log form that we fill out.
Okay. I see State's Exhibit 123, please. Do you recognize that document?
Yes, it would have been information that I typed in from a conversation.
Okay, on March 17th and then later, April 21st of 2022?
Correct.
Do you have an independent recollection of those conversations today?
Not explicitly, no.
Okay. So, did Kouri Richins provide you certain information in those conversations?
Yeah, she provided me a lot of health-related information, indicated that he'd had Lyme disease 2 years ago, and that he was still having problems with neuropathy, so therefore he was getting treated for that. And that's apparently a chronic problem that you can have with Lyme if it's not treated right away with antibiotics. Also indicating that he wasn't feeling well currently or right before his death, that he was not feeling well in general and his chest hurt.
Did you explain to her about the granulomas that you observed?
Yes, and so the not feeling well and chest hurt could have been part of the problem with just recovering from COVID, as well as this granulomatous lung disease that he'd had from his chronic work exposure.
Okay. Did she offer up any other information to you?
That his mom had died from a fungal infection 3 years prior.
Okay.
And so, we did fungal stains just to make sure that his lungs weren't showing any indication of fungal pneumonia. And then just the fact that, he was a stonemason, and that's where he was getting this exposure to what I was seeing in these granulomas. So that was helpful to me because, he's cutting stone, so.
So you mentioned that you did this stain. That's part of the histology. You went back and looked for or was that the?
That was for the fungal organisms, yeah.
And did you exclude that?
Yes.
Okay. On April 21st, you had another conversation with Kouri Richins?
Yes, I did, and I believe that I indicated that the case was still ongoing. I asked if he ever had any history of drug use, and she said, other than just using some THC gummies, he had no history of drug use. So that was helpful.
Never used drugs is what your note says?
Correct.
Did she talk to you about those two substances on your list, the last one,
Yeah.
ETOH tests?
Yeah, the medications that are used for helping people not to drink. Is that what you're talking about?
Yes.
Yeah, basically he was being prescribed those medications to try and help with his chronic Lyme symptoms.
I see. Did she say he hadn't used those for a while?
Yes, that he hadn't taken any of it for 4 months.
I have one moment, Your Honor.
Yes.
Is there
Are we admitting 122 or 123?
The state would offer State's Exhibit 123.
Any objection, counsel?
123.
Yeah, that's...
So, yeah, no objection.
Okay. 1-23 is admitted.
No
Mr.
further.
Ramos is witness? Okay, very good. Did water? Okay, very good.
Thank you.
Did you introduce 122 as well, or just 123?
Just 123. We can, I have no problem doing 123.
Yeah, can we do 122 as well?
Okay, very good. States 1-22 is also admitted.
Good afternoon, doctor.
Hi.
How's retirement? Besides today.
It's good.
Good.
I recommend it.
I'll get there one day. We talked about a lot, and I'm trying to kind of drink out of a fire hose, so I'll try to follow some semblance of a good timeline. But I want to talk about what you just left off on. You indicated chronic Lyme. Could you explain what that is?
So with Lyme disease, you can get kind of an antibody response that then also affects your body as it's trying to ward off the Lyme infection. And so you can end up with like chronic fatigue syndrome or peripheral neuropathy or things like that. Things that maybe more recently people would associate with long COVID. So,
Okay. Is it painful? Bless you.
I guess it can be.
Yeah, you guess.
Yeah, I mean, peripheral neuropathy is definitely can be painful. So some people will just have tingly pinpoint feelings. Other people, maybe they just can't feel anything. So it varies from person to person. So.
And did you gather more information about Eric's Lyme disease and the pain that he was feeling?
No, I have not had the opportunity to review any of his medical records that I reviewed 3+ years ago. So my current recollection is limited to reviewing the information that I have available to me.
That's fair. Did you confirm that he actually had Lyme disease?
No, but it was in his medical record, I do believe.
Okay. Would you have been able to, having what you had at the time, you doing the autopsy, the records you had, would you have been able to confirm that?
I don't know how long the antibodies stick around, so I can't answer that effectively.
So possibly.
Possibly, but I don't know.
Okay. You indicated that one of the, and I can't remember which one, so if you can't remember, we'll pull up the medication that was listed. You mentioned opioid reduction for one of them. Do you recall that?
That's the naltrexone.
Naltrexone. And that was found in his system, correct?
No,
one was
naloxone
not.
was found in his system. That would have been given by when they were doing CPR, so that would have been given by EMS.
So the naltrexone, that's the one he had a prescription for?
Correct.
Tell me about opioid reduction. What do you mean by that?
So for people who are chronic abusers, whether it's using too much of their prescription medication or using illegal narcotics, and when they want to stop, then they might need something else to help them stop.
Okay. And do you recall how many were left?
Of the naltrexone?
Correct. Would it be helpful to pull it up?
Yes, it would be very helpful.
Just publish it just to
I want to say it was like
the doctor.
88 out of 90. So 90 were prescribed and there were still 88 present.
And how do you know, with the information you have, do you know how often they were, or Mr. Richens was told to take it?
If I were to go back and review the scene photos and look at the bottle, then yes.
But not with what you have?
Not with what I have, no. But this prescription was from 2020.
And do you know if those who are prescribed naloxone, is it something that you need to take daily, or does it vary just whenever you feel the urge, I guess?
I'm sure it's supposed to be taken on a certain time frame, but I don't know what that time frame is.
No problem. Mr. Burmester was talking to you about the blood alcohol level, or rather the presence of alcohol. I'd like to talk about that now.
Mm-hmm.
So you mentioned that initially there was no presence found in the initial testing, but then there was an expanded panel done, and it was at that point that it was found.
Well, it was found in a different sample.
Correct. The gastric.
So the initial testing was done on the vitreous fluid, which was negative.
And was it found in the blood?
No.
So in the vitreous and the blood, no alcohol found, correct?
Correct.
But then when with the expanded one, it was the gastric, is that correct?
Correct.
Now, does that tell you in your profession, and you had mentioned earlier that maybe it's a toxicologist world, so let me know if that's the case here, that does it tell you, those two things that you have, or I guess three, blood, vitreous, right, and then gastric, Does it tell you kind of chicken before the egg, which one was ingested first? Can you tell me that?
I can tell you that there was no measurable intoxicant related to alcohol that was in his blood or vitreous.
And with your knowledge, if it's in your gastric, does that indicate timing-wise whether that was first and then it goes to the blood?
If it's from ingestion, I would say possibly. If it's from bacterial decomposition, then it doesn't tell us much.
Okay. And did you do any additional tests or studies to try to determine that in this case?
No.
Okay. Was that asked of you?
No.
Okay. At any point, was it asked to determine whether or not the fentanyl was taken along with alcohol?
These are questions that I would not be able to answer because I don't think that they are answerable.
Okay. Actually, I'll go back to that. Let's go to the, was it 122, the calls, the messages, Katie? Can you just show that to just the witness, Judge? And page 2, please. Do you recall that?
Not specifically, but I mean, it's a typical note that we would get.
And this is one that was addressed to you?
Correct.
At the very bottom, there's a signature. Is that yours?
Yes, it says the call was returned on March 17th of 2022.
Perfect. Could we go to the case notes, Katie, for that same day, please?
$123, sorry. It's over here.
123, you can do it.
She has it as well.
Sorry, I didn't know. Is what's in front of you, is that for the March 17th that you returned that call?
Yes.
Okay. Now, on the case, is it called the case log, case notes? What would that?
Same thing.
Same thing. Is that automated?
Is it automated?
In terms of the, let me be more specific. Is
No,
it
I have to type it in.
But in terms of the time and date?
No,
It's not automated.
I don't believe so.
Okay.
I don't know for a fact.
Okay. Could we just do a? Yeah. Could we not call it out? Yeah, just like that. So there you have a full view of what I see as case notes, case log, correct?
Right.
Okay, and so you can see that on the top, it has a date, time, doctor, and I guess who's calling. Do you see that?
Mm-hmm.
Do you know, I know you're retired, whether you would have inputted that information, not the contents of it?
I believe I certainly would have entered the date and time. So yes, I think I would have entered that.
Okay. And
Because generally I would try and enter these as soon as I was done with the phone call. It didn't always happen in that fashion because I'll usually make paper notes and then, because you can't remember everything and you're not recording the phone call, so.
correct. So when you get to the point where you are inputting it, correct me if I'm wrong, the purpose of inputting that information is that whoever's working on that case can have the information that you have.
As far as the investigators and stuff?
Sure.
Sure, but mostly it's just a documentation of what happened.
That day.
Yeah.
Okay. And it seems like whenever calls were made to you, you did a pretty good job of summarizing what was discussed.
Yes, it was more for my recollection maybe than anybody else's.
Correct. And with that, kind of like you said, you were trying, or you indicated I imagine your team, correct?
Yes.
Does that include anybody outside of the Office of Medical Examiner?
No.
Okay. So people at the Office of Medical Examiner working on this case, notes for you to try to determine what the manner or cause of death is going to be in this case, fair?
Correct.
And as people are calling you to get information, you're uploading all the contents of those calls, correct?
Yes.
And you do that with every call?
You try to do it, but sometimes you might be someplace, you might be in a situation where you can't, like if, for example, when I was in the process of retiring, I might not be working from the office, I might be working from someplace else, and it just may not be feasible to do it because I might be making phone calls on my personal phone, for example.
Sure.
So.
And so in this case, you did get a note that Ms. Richens called on March 17th, and then you did speak with her that day, correct?
Yes.
And then you put that information in there.
Yes.
And in that discussion, you talked about the lungs and how Eric's mother had died previously, correct?
Yes.
And I want to get the timing right. Mr. Burmester asked you about the fungal testing that you had done. Was that before or after this call?
I'm sure it was before, because since I already knew they were granulomatous lungs, I wanted to look at what might be causing that problem.
Okay, and when did you get the results back from fungal?
Well, when did I get the slides back?
Yeah, when did you determine that the fungal...
I can't say for sure when I reviewed the slides.
So it could have been before or after this call?
Well, I wouldn't have been able to review them until they were back.
Right.
So I don't know the timeline on that.
Okay.
It would have required special stains, which I think I did order up front. But I'm not sure that I have that information in front of me.
You discussed the NMS labs and how you had sent out, or your team had sent out for further testing. The expanded lab, is that, or the expanded panel?
Yes.
Okay. Can we pull that up? Is that up on your screen?
Yes.
Okay. And you saw a couple of these during Mr. Burmester's direct examination, correct?
Yes. One for the blood toxicology and then one for the gastric toxicology, yes.
Okay. And now we're just clicking through all of these fairly fast. I just want, do you remember how many pages you received back from NMS Labs?
What I see is what's in the autopsy report.
Okay, so and let's pause there, Katie. So with the NMS Labs, the only document that you received was just that one? The one that's in your...
The one that's in the original report, and then the one that's in the supplemental report.
Okay, and those are the only ones you received from NMS?
That's what I received, yes.
Okay. If you could highlight, Katie, for the doctor, the page number at the bottom for the last page. Can you see that, doctor?
Yep.
And how many pages is that?
999.
Now, you had mentioned earlier toxicologist. As she was clicking through all of these, I think there's graphs and everything. Is that something that's more suited for a toxicologist to be able to interpret what's in those documents?
For this extent, yes, yes.
Okay. So I won't ask you any questions on that.
Okay. I've never seen one of these before. That's
good. Would have been an awkward cross-examination. No, we talked about that. I'd like to talk to you about I think it was before the lunch break, you talked about the anaphylaxis, kind of like a reaction. Do you remember that?
Yes.
Could you talk to me a little bit more about that? I want to make sure I understand that.
So he had a history of allergies, just a broad history.
Right.
And I don't really know how much information I had, and I don't know whether I was more concerned about the COVID or about the allergies when I put that section in of the epiglottis. But for people who have chronic allergies and who are known to carry EpiPens around, then that's always something that you're concerned about.
Okay, and so what is it that you found exactly?
I found nothing of interest. It was just normal inflammation, and I didn't find any histamine response that would be of concern with anaphylaxis. So you have cells that release the histamine, and that's what causes you to have the throat swelling or whatever response you have when you have these severe allergy reactions. So.
And the allergy reactions, they could be for plants or trees?
Yeah, I mean, the one that we classically see is for peanuts.
Peanuts. Medication?
Could be. There's really only a couple of things that I've actually seen it for in the office. Peanuts is one of them, and maybe another thing would be like for like an antibiotic.
Like penicillin?
Yeah.
What about opioid drugs?
No, I've never seen that.
You've never seen it? Does it exist?
I don't know, but it possibly could. I mean, there's always going to be somebody who's allergic to stuff, but I've never seen it, so I can't answer intelligently about it.
That's fine. If somebody were to have been, I'm allergic to, well, I shouldn't say this, it's fine. If somebody's allergic to a medication, and you, it would come up, right? And so that medication or that nut allergy, you would think that you would see it every time that individual ingested whatever that was.
No.
So a nut allergy could happen once and not again.
Could happen. Usually what happens is it doesn't happen, and then all of a sudden it happens. I mean, it's going to vary, and this is, again, getting a little bit out of my realm,
That's
but
fine.
You may have a mild response to it, but you never know when you might have a maximum response to it. But the range of drugs or whatever that would cause that type of reaction are beyond my purview, and so.
So you can't say sitting here today that, fentanyl causes an allergic reaction in anybody?
I cannot. I'm not saying it doesn't. I'm just saying I can't say it does.
If it had, you would have seen it here?
I don't know what type of allergic reaction it would cause. Not all things that cause. So most of the medications that your doctor says you're allergic to, it's just that it didn't work for you. Like they'll switch you from your one high blood pressure medication because now you've got a cough.
Okay.
And so they're saying, well, we need to put you on a different one. And it may not be that you're allergic to that medication. It may just be that that medication either A, isn't working for you, or you have a side effect to it that's undesirable. And so when you have all of these things that you're listed in your medical record that says allergies, it may not really be an allergy. It's just where they document that stuff.
Understood. The food particle that was, you indicated that you saved it. Is that correct? Food particles?
The gastric contents?
And the gastric contents, correct.
We saved a portion of it.
Okay. And did you locate any THC gummies in there?
Nope.
Okay. Did you look for them? Should have asked that first.
I'm sure they would have melted by then.
That's fair enough.
And there was no measurable THC in the toxicology analysis either. I don't know that I would have had to order that specifically. I can't remember.
Okay, fair. Can we pull up the... Can you see that, doctor?
Yes,
The time of death, that is, you are referring to the time that it was called, correct?
that's correct.
Okay. Now, when Mr. Richens actually passed, do you know?
No.
Okay. So the time of death is just the time it was called.
That's correct. We have limited information that we can go by, last known alive time, and when CPR was performed, once they stopped performing it. And if there's no obvious information in between, there's maybe some soft factors that we can use to kind of narrow it down. But typically, I'm going to go by last known alive time and when his time of death was called by EMS or in the emergency room or wherever.
Okay. Could we go to the second page?
Another possible explanation would be time found. So those are the three kind of guidelines.
Okay. And now, with what you have there in front of you, I want you to just review that real quick. Do you recognize both pages of the document in front of you?
Yes, this is the form that when you request a death certificate, this is what it looks like.
Okay. And is that the final one? We could.
Yes.
Okay. Move to admit. Is it 3?
It should be 6.
300. No, 7. 3007.
Do you want to use defendant's exhibit for the time?
Oh, yeah, sure.
Yes.
Mr. Burmester, defendant's 1088.
We do not object.
Okay, defendant's 1088 is admitted. Are we publishing to the jury?
Yes, Judge. Second page of that highlight. Or
Will you
that
show
call
the
out.
first page before we get there? Just so they understand what they're looking at. Thank you.
So this is a certificate of death here, correct?
Correct.
And now the information that's contained in it, this was, I don't know, like for a better word, you signed off on it.
Yeah, we do a preliminary death certificate initially. Just you have to have a death certificate of some form in order to initiate a lot of things that occur after death for, you know, the funeral home and whatnot. So we'll do a preliminary one that's basically just says pending.
Okay.
And then once we determine what the cause and manner of death are, then we amend it.
Okay. Let's go to the second page if we could do a call out. And so this is the pending on that first line, correct?
Yes.
Now, the amendment, it seems to just track the same day. I imagine that's not obviously how it went. Maybe this was internal. Could you just help explain that? Is that just when the amendment was?
That's the amendment when that was done, yes.
Okay. Now, initially, the immediate cause of death was pending, as you said, and then it changed to drug intoxication, fentanyl.
Correct.
Now, that was the cause of death, and now the manner of death was pending to not determined.
Correct.
Okay. Now, that never changed, correct? The manner of death, as I'm reading through it.
What do you mean it never changed? It changed from pending to not determined.
Sorry, since then, I
Oh,
apologize.
no, it hasn't changed.
Okay, so that's remained the same.
Correct.
Okay. Now, we can take that off, Judge. You indicated that as you're working specifically on this case, you are gathering information from everywhere.
Correct.
So from NMS labs, correct?
Yes.
Getting fungal slides or testing done,
Yes.
speaking with law enforcement,
Yes.
and using their reports
Yes.
from your OME investigator, correct?
Yes.
From calls that you've received from Ms. Richens,
Yes.
from calls you received from other members of the Richens family,
Yes.
and those are all documented as we saw in the case log, correct? Correct.
Correct.
Now, did you have meetings with Summit County Sheriff's Office?
Yes. I mean, I certainly had phone calls with them. I don't know whether I had in-person meetings or not. I can't remember.
Okay. And during those calls, what did you learn, or meetings?
I don't know off the top of my head.
Okay. Were you told that law enforcement believed that it was a poisoning? If you don't remember, that's fine.
Yeah, I mean, I don't, yeah. I'm sure that I had some logs in there that indicated some of the conversations, but
But you don't remember now?
I don't, yeah, I mean, I can't remember individual conversations. That's why I make notes.
Right. Now, regardless, with all that universe, right, of information, you can also ask for follow-up, correct?
As far as what?
Anything. So let's say Ms. Richens indicated something to you, you can have a conversation with her.
Yeah.
Try to get a little bit more. Correct?
Yes,
And when you're speaking with, did you speak with Detective Woody?
I did.
And so with speaking with Detective Woody was giving you information, correct?
Yes.
And you could also have a conversation with Detective Woody and say, well, could you follow up on X, Y, or Z? Correct?
I usually don't. Yeah, I mean, I guess I could. I'm not sure where you're going with this.
I'm just trying to see that all of this you indicated, you were gathering all this information so that you could ultimately make a determination as to the manner of death, correct?
Yes.
Okay. And so you indicated that you had, make sure I get this right, natural cause of death?
Yes.
Suicide was one of them?
Yes.
Homicide?
Yes.
Not determined?
An accident.
An accident. So, for example, the accident with the information you have here, if you were to have been given information, hypothetical, that Mr. Richens took a pill, not knowing what it was, that could have assisted you in determining whether it was an accident.
Correct.
Okay. And that is why it's important to get all the information, all the details to you so you can make that determination.
Correct.
Okay. And ultimately, when was it? I think it was June, but correct me if I'm wrong. When was it that you made that final determination of undetermined or not determined? Do you recall the date? Or would you like to see the death certificate, or?
The death certificate said June 22nd.
So that would have been it?
I would imagine.
Okay. So after you have all the information, you've gotten everything back from NMS Labs, you've spoken with everybody, the world of that information, the answer you came up with was not determined.
That's correct.
Okay. And I know you've been retired. When did you retire?
January 1st, 2023.
So, about 6 months before, right? In that time, did you see in your line of work overdose deaths
All the time.
from fentanyl?
All the time.
Accidental?
All the time.
Not determined?
I probably saw some of those as well.
And then, I imagine suicide?
Yep.
Would you say that during your time that has increased? That number that you saw?
During that era, yes.
And what era would that be? 2020 to 2022?
Yeah, roughly.
Okay.
2018 to 22.
Were you familiar with the one pill, one kills? One pill kills, I mean?
Not that phrase, but
Okay.
certainly the concept.
And were you trained on that in while you were, or before you retired, as to the increase in fentanyl overdose?
I saw it. I didn't have to be trained on it, yes, but I mean, sure.
Okay. My point is that you've seen a lot of, unfortunately, a lot of fentanyl overdoses recently, or before you retired.
Yes.
Okay. Promise you I'm almost done. Okay. Let me check with my colleagues. In your case log, the case notes, specifically that March 17th call with Kouri, there's no reason for any of us to believe that that call did not happen, correct? No, I know it's funny.
Correct.
Yeah, because you did have that call on that day, correct?
Yes.
And you did speak with Ms. Richens on that day, correct?
Yes.
And you did discuss lungs and what was in that day, correct?
Whatever it said.
And as well as you knew, at least at that point, or timeline's off, but at least that you looked into that fungal situation, and you were aware of Eric's mother's passing from something related to fungal infection, correct?
From the information that she provided, yes.
Okay. No further questions. Thank you so much, Doctor. Enjoy retirement.
Mr. Burmester.
So, to be clear, the fungal infection information was not you providing it to her, but rather she provided it to you. The fungal.
From that
Phone call.
information, yes.
Yeah.
But the testing that I performed was just routine testing for the type of case that it was with the granulomatous lungs.
I see. And so could we get that I didn't get the dates right, I guess, on the death certificate. Did we look at that last page again? I thought it was already published, and yes.
I mean, so the jury can see it right now? Or?
Yes.
Yeah, okay. What part do you want us to zoom in on?
The second page. Now, do you create this document? You, the OME, the Office of Medical
Vital
Examiner?
records. I mean, I type the basic information in, and then this information is populated through vital records.
And so the only thing I see on here is June 6th. So you change, no, not change, you finalize the the cause and manner of death on June 6th. Is that a fair statement of what's going on there?
That's what I'm seeing.
Thank you. So, as of June 6, 2022, did you have any of the text evidence from Kouri Richins' phone at your disposal to make your determination?
No.
How about phone calls from Kouri Richins?
Anything further would have been what was documented in the call log.
But you didn't have recordings of phone calls or Verizon or T-Mobile or whatever things, correct?
No.
Okay. And you didn't have access to any financial documents at this point?
No.
June 6th. Okay. Let's talk about what's going on there. That's you have those categories, and that's required by statute. You need to call it at some point in one of those homicide, suicide, accident, natural death, or undetermined, correct?
Yes.
So homicide, that isn't a legal criminal determination.
No, it's simply a term that we use indicating that the death was caused by another person.
As opposed to suicide, for example.
Yes.
Okay. When you're, this is, I would guess at its core, a scientific endeavor. Is that fair to say?
Yes.
What you do, or did do?
Yes.
So, in pursuit of science, you don't start from a presumption, I would assume, that you look at all the evidence before you make, and you go off of the evidence that you receive before you proceed in any direction.
Correct. You might have a working hypothesis, so you have a direction to start in. But yeah, you have to be receptive to all of the additional information.
Okay. And by June 6th, in your possession, did you have anything that would help you to determine whether this was a homicide, poisoning, or accidental, or
No,
suicide? Okay. And that's why you came up with the decision you came up with.
that's correct.
Do you consider motive evidence when you're making a determination of homicide, suicide?
Not typically.
I think I just missed it, but you said there were some things that you are unaware of whether they can be determined, or the things that can be determined. Is one of them whether the alcohol found in the gastric fluid ingested or decomposition, to sort those two out?
There's no way to sort those out because the chemical makeup is the same either way.
I see. Lyme disease, is it fatal?
It can be.
I see. Did you see any evidence that Lyme disease was fatal in this case?
No.
Okay. Finally, is there anything, any change in your opinion that the cause of death in this case was fentanyl intoxication?
No, I don't have any additional information to provide otherwise.
Thank you.
Mr. Ramos, anything within the scope of redirect?
Yes.
Of course.
No post-it notes. You know it's going to be quick. From June, when that change was made, until you retired in January 2023, you had the opportunity to change anything if you felt it warranted changing, correct?
It was discussed with law enforcement that if they had additional information that they would let me know. I was busy signing out hundreds of other cases. I was still cutting cases, and this was not the only case that I was working on.
And during that time, you weren't provided with any additional information from the law enforcement that did cause you to change anything?
No, because my understanding was the investigation was still active.
Okay. And from that point on, obviously you have nothing else to do with it, correct?
Correct.
Perfect. Thank you for your time.
Sure.
I have nothing else, Your Honor. for this
Dr.
witness.
Ulmer, thank you for being here. You can step down.
Okay.
Excellent. Christian Sanders.
Folks, let's take a restroom break, please. Please rise for the jury. Have a seat, please. Mr. Bloodworth, anything on the record before we take a recess?
No, Your Honor.
Ms. Nestor,
Do we need to deal with the altered
Yes, that's-
document?
I want to talk about that now.
You know,
Let's one
Yes,
step at a
I'd be happy
time.
to.
So,
All right, so medical examiner is done. So let us go then to, all right. Let's see. Wizard of Ezi, I'm here. Trying to shove some food in my mouth while I'm handling the stream. So I'm here. Let's see here. I'm always here. Trust me, if I'm not sitting in my chair, I'm watching. So don't worry, I'm always here. All right, so next up was going to be, oh, we just had pizza delivery because it's Pizza Friday. So let's see. Next up was Todd Gabler. That's what you guys chose. 28% wanted to watch Todd Gabler. So let's watch, and we have until, we have an hour and a half. So this will pretty much get us to live court. Kimber is very interesting. Glad that is how the vote went. Yeah, 1.5 hours to live court. Yeah, no, it's going to be. And I have a video from Selena K too, so I'll play that. Maybe I'll play that now. Let me play that now. To be quite honest, let's play that now. Let me see if I can sort this out. All right. I mean, hold on a sec. No, it's not a feed. Hold on. Let's see. This is going to be a video. All right. Selena sent us a video of her being interviewed. So let me see if I can. Yeah, no. That's not the right thing. Hold on. All right, it's a QuickTime movie. Just give me a second. Capture card device, media source. Maybe it's media source. That's what it is. Okay, hold on. I think it's this. All right. Okay. All right, so this is from Selena. Now hold on. I think she just held her phone up. Here, all right. Oh yeah, this is, all right, I should find this. I should find the original. All right, I'll find the original and I'll show you the interview. So anyway, all right, I'll work on that and let's go back to this. Let's go back to Mr. Gabler. Mr. Gabler, come on down. All right, so live court will begin in a little bit. Here comes Mr. Gabler. And if you guys didn't watch this, well, if you missed it the first time, when Mr. Gabler comes in, right? So he's coming in, and we're like, wow, what's going on with this guy, right? You guys remember this, right? Now, so we're like, oh my gosh, what happened to him? So look at, and there's his lawyer, there's his attorney, I'm assuming. So look at Miss Nestor's face and Miss Lewis. Look at Nestor. Look at Lewis. Look at Lewis and Nestor. Look at them. They're like, what? Watch their faces, you guys. Just watch them. I'll be quiet after this. Just watch. Look at Miss Lewis. She's like, what? And Miss Nestor, watch her face. This is hilarious.
I solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury.
I do.
Thank you. Please have a seat.
Sir, take your time and please watch your step.
Thank you. All right, how's this?
Sound great.
Great.
Mr. Bloodworth, please proceed.
Sir, what is your name?
My name is Todd Gabler, Gabler.
You appear to be recovering from something.
Yes.
Would you mind just at a high level explaining?
On January 13th, I underwent a 5-level PCLF. That's a posterior cervical laminectomy and fusion. My neck has been fused together with titanium rods.
Sir, are you taking any medication today that would affect your testimony?
I purposely did not take any pain medication today for the purpose of the clarity of my mind and my testimony to you today. I took Tylenol this morning.
What, sir, is your occupation?
I'm a licensed private investigator in the state of Utah.
How long have you been a private investigator?
34 years.
What, sir, is your investigative experience that is relevant to this case?
Well, over the course of 34 years, I have worked on approximately 100 homicide cases. I have been active in the trials of perhaps a dozen or maybe more homicide cases over the course of my career. I have extensive experience in a specialty in digital forensics, which allows me to examine digital devices, phones, computers, other things of a digital nature to uncover information that may have been deleted, destroyed, or altered. I can't really think of anything else that is sort of a 30,000-foot view of what would be important to the jurors in this case regarding my experience.
Well, sir, of those 100 or so homicide cases, how many have you worked for the defense?
All of them. I have always sat on that side of the room, standing in between the state and a defendant.
And you mentioned, sir, that you testified about 12 times. Have you ever testified for the state?
Never.
Did there come a time shortly after Eric Richens' death when the estate of Eric Richens hired you as an investigator?
Yes.
Do you recall about when?
I was first contacted by Crystal Bowman Carter, an attorney. I believe that would have been early to mid-March of 2022. She asked that I contact her client, Kouri Richens Benson, regarding the death of her brother, Eric. She gave me a broad sketch of what she knew about what had occurred regarding Eric's death. And it was a very short conversation, very professional, very to the point. And then it was a few more weeks, before I first spoke with Katie and Clint. That's Kouri Richins Benson and Clint Benson at their home in Summit County. That was April the 1st, 2022.
And was that engagement to investigate the death of Eric Richins?
Well, that was part of the investigation. I was under the impression that I had been hired at the instance of the filing of a lawsuit by the defendant in this case against Katie for the trust money and the control over the trust that Eric Richins had created.
And to be clear, the lawsuit involved Kouri Richins as trustee.
Correct.
And when you're interacting with Kouri Richins, it is in her capacity as trustee.
Correct.
Or personal representative of Eric Richins' estate.
Correct.
What, if anything, sir, did you inform at that meeting with Clint and Katie? What, if anything, did you inform them of how you conduct investigations?
Right. So I talked with them about some of the various facets of an investigation, how it would proceed. I've already talked to you about the qualifications that I have in digital forensics, and so I talked a little bit about that, about the need to get a hold of phones and computers and other things that would have evidence of either a wrongful death or some mismanagement of finances that was being alleged in the case. So for all my clients, it's basically the same speech. You're hiring me to find the truth. The truth is sometimes very difficult for us to accept. I've often said that the truth is half what you most fear that it is, and half what you most desire it to be. And you cannot separate those two from the truth. I told them that they would have to accept the truth about what happened to their brother, no matter what that truth was. If he took his own life, they would have to accept that. If someone was responsible for his death, they would also have to respect my investigation and accept that truth. They agreed.
Sir, from that point forward, did you conduct an independent investigation?
I did.
Sir, who paid for that investigation?
I was paid by Clint Benson, but my understanding is that the legal sort of line of authority for which I was engaged was for the estate and Kouri Richins Benson as the personal representative.
Did you bill them at your customary rate?
I did. I continued to bill them at the rate that was established at the time of my engagement, even though my hourly rate increased during the course of my investigation. They enjoyed a lower rate essentially because of the time that they engaged me.
Did anyone else pay you for your investigation?
No.
Did anyone from the Summit County Sheriff's Office direct your investigation in any fashion?
No.
Did you conduct your investigation entirely independent of the Sheriff's Office?
Yes.
Did you provide information from your investigation to the Sheriff's Office?
Yes, on many occasions.
And before providing it, did you receive approval from your client?
Yes, that is part of the standard operating procedure. It would be a crime for me to, under the Utah Private Investigators Regulation Act, to have any file materials go to anyone else but my client without my client's permission. So The standard course would be that I would discuss my findings with my client, and we would discuss handing that over to the sheriff's office. In every case, information that we thought important to the investigation was handed over, and there was no event, no occasion upon which we decided not to turn over something to the sheriff's office. Full disclosure. That was the rule.
Sir, was that flow of information one way from you to the sheriff's office?
Oh, yes, very much so. I initially tried to get the 911 audio call that the defendant in this case had made, and the sheriff's office denied my request under the Grandma law. I appealed to the county administrator for Summit County. She also denied my request. It's common for police agencies to be one-way streets.
So it was not uncommon for your request for information to be denied?
Correct. My investigation proceeded regardless of whether they were providing me any information or not.
Did you have contact with the Summit County Attorney's Office before Kouri Richins' arrest?
No.
Did anyone from the Summit County Attorney's Office direct your investigation in any fashion?
Never.
Did you conduct your investigation independent of the County Attorney's Office?
Yes.
On June the 15th, 2023, after Kouri Richins' arrest, did you receive a subpoena from the County Attorney's Office for your investigative file and any forensic data that you had collected?
I did.
Did you provide that material to the County Attorney's Office in response to that subpoena?
I did. I produced 2 hard drives. One contained what I call the logical and physical investigation file. That would be interviews, audio recordings, photographs, videos. That was a fairly large file. And then the second hard drive that I provided a few weeks later was all the computer forensics, the digital forensics, the examinations of the C&E computer, a clone of Eric's iPhone, and some other digital data.
Did you begin your investigation with a hypothesis?
Yes. A number of hypotheses appeared clear to me in this case. My investigations are hypothesis testing exercises. That's just a fancy way of talking about something that we all do every day. We look at a situation and we evaluate what that is. Is there evidence that supports our hypothesis that that is what it is? Well, if we're looking at a red light, our hypothesis may be that traffic should be stopped, and we look around for data to verify that hypothesis, that indeed there are cars that are stopped at that red light. In this case, it was clear to me that 2 hypotheses needed to be looked at. Number 1, Eric took his own life as a matter of accidental overdose. Number 2, Kouri Richins surreptitiously had Eric ingest a massive amount of fentanyl and killed him. So, as the case proceeds, and I see new data, I see phone data, I see computer data, I interview people, I look at documents or things or other devices. All of that data gets fed into one of those 2 hypotheses, both of those hypotheses. Does this confirm it? Does it deny it? Does this evidence make it more likely that this hypothesis is true or less likely that this hypothesis is true? Does this evidence preclude the possibility of one of the hypotheses being true? So that hypothesis testing continues throughout the investigation, and sometimes a permutation of the hypothesis comes along. We have to change the hypothesis just a little bit to allow some of the data to fit that hypothesis. Not large permutations in this case. Pretty straightforward. Two competing hypotheses.
Sir, you just mentioned that in testing your hypotheses, you conducted some interviews.
Yes.
What, sir, is your process for conducting interviews?
So my process is to always have a recording device active for any of my interviews whenever possible. This eliminates any possibility for me to be biased or unclear in my reporting of what was said during that interview. It also protects me in a liability scenario if someone were to allege that I had done something improper or had offered them material for their cooperation, anything like that. That would all be protection for me by recording that contact. So that is the primary objective of documenting an interview. Later on, when I report it, when I summarize that interview and in writing, because it's hard to get a lawyer to listen to an entire interview. There's some difficulty that they have with that. So they need a summary sheet about what the interview was about. And I type those up based upon the recording that I made. And I typed up those later, or I may have an agent type those for me from the recording. And then I'll review the report and sign off on it, and then it'll go into the file. So that would be my process with respect to an interview, all interviews.
Approximately how many interviews did you conduct in this investigation?
It depends upon your definition of an interview, I guess, but 45, probably, somewhere in that department. 40, I guess I could say 40 to 50 to be safe.
And in those interviews, did you identify yourself?
Oh, yes, always. There was no occasion in this case where I did not identify, give people my true identity and who I represented.
And did you record those interviews?
Yes. I think there were a couple of occasions where I could not get a recorder fast enough, but other than those couple of occasions, they were all recorded.
Who, for example, are some of the people that you interviewed?
I interviewed friends and associates of Eric's. I interviewed friends and associates of Kouri's. I interviewed a number of people involved in Eric's business and personal life. I interviewed family members, both the Richens family, and I attempted to interview family members of Kouri's family, but was not successful in gaining their cooperation for an interview. So that was generally who I interviewed.
And was the purpose to test your hypotheses?
Well, yes. I'm interested in getting those interviews done from as many people as I possibly can from both sides of the camp so that I can get the largest possible data set to feed into that hypothesis testing scenario.
Did you pass your interview recordings and written reports along to the sheriff's office?
I did.
Sir, as part of your hypothesis testing, did you analyze Kouri and Eric Richens' cell phone billing records?
I did.
How did you obtain the records?
Eric and Kouri's cell phones were being paid by C&E Stonemasonry. They were Verizon accounts. And I obtained the the billing records from C&E, from Allie Wright, with the authorization of Kouri Wright. There were 2 productions of telephone records from C&E. The first one was for the period of January 2022 through May of 2022. The second production was May of 2022 through February of 2023.
In that January of 2022 onward time period, what types of information were you looking for in the billing records?
So because the billing records don't really offer content, that is to say it's not a, you don't get to see text messages or what the text message was, you do get to see the numbers that were connected to Kouri and Eric's phones. So we first of all decode that number to a name. We try and figure out who that is. And we fill in every instance where that number occurs with that name. And then we begin to count the total number of contacts with that phone number. So for example, we would see the highest number of contacts for Kouri's phone to her mother. Not an unusual circumstance that someone would be close to their mother, and that would be the highest number of contacts on your phone. So that was the procedure that I was initially interested in, was the weight. We call that the weight. So what is the weight of that person on the other end of the line? Kouri's mom was a high weight because there was a high number of contacts. And so I'm interested in how many times you contact that person. Occasionally, I'm interested in what time of day you typically contact that person, and the type of contact, whether that contact is by text message only or by voice and text. That changes the character of the person on the other end of the line.
Sir, did you pass your analysis of contact weight along to the sheriff's office?
I did.
Was there any particular contact weight that caught your attention?
Yes.
What contact did that involve?
It involved the contact with Carmen Lauber. I noted immediately that there were many hundreds of text messages between the two from the initial data set. That was January of 22 through May of 22. There was a very heavy weight. I don't recall if she was the second or third weight, but it was very close. The only two people that I recall that were ahead of Carmen on that weight was Kouri's mom and Eric. So that was the one that stood out to me. There were others that I investigated, but that one was of particular interest to me.
And to be clear, that involved the weight of contacts between Kouri Richins and Carmen Lauber.
That is correct.
Did that contact weight cause you to investigate Carmen Lauber?
It did.
What did you determine?
Well, it was immediately apparent to me that Carmen had a very extensive criminal record involving drug use and potentially drug sales. I noted that Carmen had a dirty urinalysis, meaning that she tested positive for prohibited drugs in her drug court around the time of Eric's death. I was very concerned about the high number of contacts and the criminal history for Carmen, and I alerted the sheriff's office about that.
As part of your investigation, did you search the Richins home?
Yes.
When did you first search it?
I believe it was May the 8th of 2023. That was the day that it was released by the sheriff's office. It was an estate asset. Kouri's lawyer, two of her lawyers from Ray Quinney Nebaker, had showed up as soon as the sheriff's office had departed. And I had arranged for security to stand watch at the house after the sheriff's office released that. So I engaged in a conversation with counsel who wanted access to the home, and it was eventually agreed that one of the lawyers would accompany me on an inventory of the property, all of the assets in the house, all of the items in the house and the detached garage. And so that lawyer stayed for a couple of hours and then left. I never saw them during my search of the property again. I continued to search the property for 4 or 5 days, and then that was the end of my contact with the house initially.
And what was your process for searching and documenting your search of the Richens home? Right.
So GoPro video, chest mounted typically, sometimes mounted on the head, and a backup audio recorder just in case something happens to the camera. At least I've got an audio recording of what I'm talking about, where I'm at, what I'm looking at. So that is the procedure for documenting those. There's also photographs that are taken. There are also, with respect to documents, I scanned with a scanner many thousands of pages of documents in this case from the detached garage office. So that was the general procedure for being at the house. There was at least one occasion that I can think of where I was called over to the house and I didn't have my camera with me, so my video camera. So I used the audio recorder and my camera on my cell phone to document things. I think that was in 2024. So with that being the only exception, that would be my process.
And was Clint Benson present at the home whenever you searched the home? And I guess by present, I mean in the home, not necessarily leaning over your shoulder.
That is not an easy question to answer because my focus was not on Clint Benson. My focus is on the things in front of me. I was never in that house without Clinton Benson's authorization. I was never in that house without Clint Benson being on his way. So if he wasn't there when I got there, he was on his way there, and so he would join up later. It is possible during the May searches that Clint had left the house while I was documenting things in the house. I think that was particularly true of the detached garage office, where I was spending maybe 8 hours in a day just scanning documents, just feeding documents into a scanning device. So I think Clint was likely not there during that.
He was generally there?
He was generally there, I would say so, yes.
And you were recording with your GoPro the whole time?
Yes, with the exception I noted, yes.
Did you ever remove, well, other than your recording equipment, cameras, audio, GoPro, all of that?
Yeah.
Did you ever bring anything into the home?
No, I did not.
Did you ever remove anything from the home?
Yes, I did.
What did you remove from the home?
So during my May searches of the house, and in particular in the detached garage office, I encountered a number of documents that had Ray Quinion Nebeker letterhead on the top, and they were either communications between Kouri and her lawyers, or they were billing records from her lawyers. That would be improper for me to read or possess. It would be unethical. I placed these documents into a manila envelope, and as I encountered more of them, I would simply grab a hold of them and put them into the manila envelope. And at the end of my May search, I took that envelope to the office of Ray Quinion Nebeker, and handed it over. There were other things that I removed from the house. Sort of the general category of the kids, the boys' things. The boys had requested a few things. I believe Child Protective Services or someone at DCFS had requested that we get documents that pertain to the boys. And I believe there were some other documents that I removed that were personal documents that were now the property of Kouri Richens Benson. These documents involved vital records, birth records for Eric, other vital documents that, we would generally safekeep for ourselves, and I turned those over to my client. I'm trying to think if anything else was removed. Any item that I considered to be evidence was removed by the sheriff's office, not me.
So, if you came upon something that you considered to be evidence, how did you handle it with the sheriff's office?
I don't think there was a standard approach. I only recall a few occasions. I think the first couple of occasions I may have contacted the sheriff's office directly, either Lieutenant Hemingway or I can't recall any others. And then on one occasion I contacted Travis, the investigator with your office, and then subsequently spoke to the sheriff's office about removing an item.
And is it your understanding that the sheriff's office would then get a warrant and come to the house to seize whatever item you thought might have evidentiary value?
Yes, I was there for one of those occasions.
Thank you, sir. I don't have any further questions.
Thank you.
Are we going to take a break or do you want me to go forward?
You tell me. Would you like a break?
Could we have
It's
just
up
a
to
few
the jury.
minutes?
No
Whatever they
problem. You
want.
know what? Let's let you stretch your legs. We'll take a restroom break. The witness asks for a break. We provide a break. All right, the jury. Mr. Gabler, watch your step there.
Hold on, Judge.
There you go. Mr. Gabler, one during the break. All right. If is 10 minutes enough time, sir?
5 is plenty.
All right, we'll say 10.
So just a programming note, we
Please
have
have a seat.
about
Thank you.
50 minutes before live trial will kick in at the top of the hour, 3
All right,
o'clock
folks, have a
Eastern.
seat. Thank you. All right, Mr. Gabler, you're still under oath, sir.
Yes, sir.
Ms.
Please,
Nestor,
the court.
please proceed.
Good afternoon, sir.
Good afternoon, Ms. Nestor.
I don't believe you and I have ever met, but I am Kathy, and I'm Kathy Nestor, and I'm one of Ms. Richens' attorneys. So it's nice to meet you. So I want to just kind of start with a basic observation, but just to make it crystal clear. You are not law enforcement, correct?
Correct.
And you've never been law enforcement in your whole life, right?
Correct.
Okay. And the rules and ethics and expected practices of private investigators are significantly different, would you agree with me, than those that apply to licensed law enforcement?
don't know that I would agree with that in every circumstance. A private investigator, when he is hired by a lawyer, is bound to all the ethics that that lawyer is bound to.
Okay.
So,
But for example, you don't have to go get a warrant to go look at a house.
well, right, that's the state action distinction.
Right.
Yeah.
Right.
I'm not a state actor.
Right.
I've never been a state actor.
Right.
I will never be a state actor.
Right.
Yeah.
So if you want to go search a house for 6 straight days and look at thousands of documents, you don't need to get a judge to give you permission to do that, right?
No, I got the permission of Kouri's lawyers who represented her to do that.
And you also got the permission of Clint Benson, right?
Yes.
And in fact, Clint gave you a key,
Yes.
and you had that key to use at your discretion.
Yes.
And there were times when you would go to the house and Clint was not there and you would let yourself in, right?
I believe that my testimony covered that, and that was that Clint was aware that I was there, and he was either on his way or there with me.
But you agree with me, and you have videos, I believe, that back this up. That there were occasions where you would go to the house, Clint was not there, you'd use your key, and you'd go in.
Yes.
And there were occasions where you would be spending hours and hours and hours in the office, because I've
Yes.
watched all the videos,
Yes.
and you would be there alone without Clint anywhere around you.
Yeah, I don't need supervision, counselor.
Perfect.
I was conducting an investigation, independent investigation, and he had given me the key, trusted me with that, and I was authorized to enter the premises at will.
Right. So if he got on the stand and said you were never doing anything outside his eye, that would be false.
Well, from his perspective, he had knowledge of my presence there, as I have testified every time I was there.
Fair.
So from his perspective, it may look different.
But you agree with me, sir, that there's hours and hours and hours of video of you alone in that office going through things.
I think that I've already testified to that.
Okay. Now, you were not permitted access to the house until after Kouri had been arrested, right?
No, that's not correct.
You got in the house before she was arrested?
No, that is not correct.
Okay, help me out.
The house was released by the Summit County Sheriffs on the 8th.
Okay.
That's what gave us, that was the trigger, not Kouri's arrest. It was the end of their search that triggered our access to the house.
Okay.
The police were executing a warrant.
Do you know when Kouri was arrested, sir?
I don't recall the exact date or time.
Would it surprise you to be the day before May 7th?
Okay.
All right. So,
Objection, Your Honor, foundation on that.
Was it
Would you
May?
re-ask the question, Ms.
May?
It
Nestor?
was May 8th.
sorry, was it May? Would it surprise you if it was the same day, May 8th, that you got access to the house?
It would not surprise me since I do not recall.
Okay. And during the time after Eric's death, but before Kouri's arrest on May 8th, did you ever go inside the house for that entire year?
I'm sorry, could you ask that again?
Sure. During the time between when Eric Richins died on March the 4th,
Yep.
in the early morning hours
Yep.
of 2022,
Yep.
and May 8th of 2023, were you
Yep.
ever inside the house at any point in between those times?
No, never.
Perfect. So the first time you ever got into that house, over a year had expired since Eric had passed.
Yes.
Okay. And you mentioned the police had executed a search that day before they released it to you, right?
Yes.
And do you know how many times prior to that the police had searched that house?
No.
Okay. And then you've also testified here, I think very honestly, that on repeated occasions you notified the police, hey, there's something you missed. You might want to go back to the house and find it again.
I mean, I'm not going to adopt your characterization, but it is true that I called them back to that house when I discovered something that I thought was evidentiary.
How many times?
Oh, I don't know. 4, 5.
So on at least 4 to 5 occasions,
Yeah.
you found things the police had missed.
Yeah, oh, that's been my experience throughout my career.
And you
The
told
police
them-
never
sorry.
get everything. Ever.
Right. Well,
It's
not going to
true
argue.
in every case I've ever handled.
Sure, not going to argue with you on that one.
Yeah, it's true.
So they come back because you call them and say, hey, I found something, come back, here's where it is.
Yep.
And they know you're doing that. They know that you have full access to this house, right?
I don't know what they know. I
They-
can't answer that.
Well, you're calling them every time you find something.
Well, what opinion they formed in their mind is not within my knowledge.
Okay, fair. True, you called them every time you found something.
That I thought was of evidentiary value in their investigation.
And did
True.
any of them ever say, you know what, we're good, stop calling us?
No, I don't recall that at all.
So then the converse of that is they encourage you to keep doing that.
Well, no. That is not the converse of your hypothetical,
Okay.
and I do not agree with your assessment.
Okay? Did you feel like you were helping them?
I was following the instructions of my client to turn over anything I thought was relevant to the criminal investigation. This is not my case. My case is in the civil court. Anything that we thought was of value to the criminal case, we turned it over.
And the police were happy with that.
I don't know if they were happy or sad or distraught. I have no idea as to their emotional condition.
They sure never told you to stop.
The police never directed me to do anything, and if they had told me to stop, I would have ignored them.
Okay. So you could go in without a warrant, find something, call them, tell them to get a warrant, and they'd come get it.
I think that's an oversimplification and a vilification. I had permission to enter those premises. I had every right to be there. I didn't need a warrant. I'm not a state actor. I have the permission of the property owner. So I don't agree with your characterization.
When the cops would show up, did you point out what you were showing them? Were you usually there?
No, I was there on one occasion when the police showed up. They executed warrants when I was not there.
Okay.
Yeah. So I only remember one occasion where I found an audio recorder in a dresser drawer that they then recovered by warrant.
And you waited around and pointed it out to them?
I did.
Okay.
Yeah, I never touched the device. So, yeah, I would have. I don't know if I pointed it out. I think what I did was, on that date, when I saw the recorder and recognized it for what it was, which is not easy, I just immediately withdrew. I left my audio recorder going until the police arrived. I don't recall pointing it out. I recall describing to them where it was.
Okay. Thank you for that clarification. So then, there was one occasion where you found something that was a letter purportedly written by Eric called the My Princess letter. Do you remember that?
I remember a baby cakes letter. I don't know if I remember
That's it.
My Princess. Is that the same one?
That's the one.
Yes.
You remember finding that letter?
August the 9th of 2024 is when I took a photograph of that, but I found it on May the 10th of 2023 during my search of the residence.
So, when you found this letter, at some point, did you move the location that you found it from?
I don't recall ever moving the location. On the video, you will see me find the letter on May the 10th of 2023 when I'm in the bedroom, and it is located in the bottom drawer of Eric's side of the bed, the bottom drawer of the vanity. And I looked at it. I didn't think it was relevant. I put it back down on the drawer. On August the 9th of 2024, when I photographed it on the bed, I do not recall if that letter was on the bed or whether I went and retrieved it from the vanity. But there is video. The August 9th, 2024 was the episode that I described, that I was called over and I didn't have a video recorder. So I was recording by audio, and and this is the same date that I recovered the audio recorder. So the letter was also photographed, and then later, I think it was taken by the police. I don't know, but
Let me stop you for just a minute.
okay.
You left the letter on the master bed, correct? For the police to find.
I left the letter on the master bed. I didn't know that the police were going to come for it.
Okay. And they ultimately did, correct?
Well, ultimately, I don't know because I wasn't present, so that's beyond my knowledge.
Isn't it true that you moved other things around in that house often?
No, that is not true.
Did you move a computer that you located in the office?
I don't recall moving a computer in the office, but I did not move it out of the office.
Did you put it in your Tesla?
If you are talking about the C&E computer, I did not find it in the office. That is not how that worked.
Okay. So you found it where, sir?
I found it in possession of my client who had taken it, who had been given it or taken it from Becky Lloyd. So my understanding of the pathway of the C&E computer that I examined was that it was picked up by Becky, who lives nearby and works for C&E. The C&E computer, she then went to get business files off of it. I talked with her about this. I filed an extensive report regarding my interview about the computer. And then before I could get up to Francis to get that computer, I lived at the time 250 miles south of Francis in Washington County, so it takes me a while to get up to Francis. Before I could get up to get that computer, I believed that my client had already secured it, and so I went and got it from her.
So Becky got the computer from the house after Eric died,
Yep.
right?
Correct.
Then Becky gave it to Katie,
Correct.
and Katie gave it to you.
Correct.
And then all of that, no law enforcement ever put hands on it.
Correct.
And at some point, you took it back up to the office to go through it?
No.
Right. Well, there's video of you going through that computer in the office.
Well, I suppose that I may not have remembered that I went through a computer in that office, but the C&E computer was processed at a location in Midway, and I recall that there was a what I want to say is an obvious missing hard drive location. I could see the outlines of a hard drive that had been in place in that computer. I became suspicious that the hard drive had been removed prior to me getting to that computer. I later sourced that missing hard drive to an upgrade that was performed by a computer company at the request of C&E. The hard drive contents were transferred to a solid state drive, and I did locate that inside the computer.
Okay. So can we play for the witness only clip TG10?
We're going to play without sound, right?
Yes, sir. No sounds necessary.
Okay.
I'm going to kind of wait till we get to the computer part. I'm sorry, that's the wrong one. Can we bring that one down? That's the next one. We want to go to the one right before that, which is 173. It's GXO 10073. Do you have that one? Okay.
Excuse me, I'm having difficulty keeping my head up.
Oh, no worries. Whatever you need, sir, to be comfortable. Take a minute. Yep, I'll go back to that. It's going to take her a minute to upload that, Your Honor, so we'll get to that. You don't recall putting electronics, documents in your Tesla and driving away from the house?
Oh, I remember that, yes. But that was not the C&E computer.
Okay, what computer was that?
I don't recall. I'd have to see the video.
So
That's why I make them.
You removed a laptop from the office and put it in your Tesla and drove away with it?
I don't recall that, no. I do not. That would have been my, if there was a laptop in that office, it was mine.
Okay, well, we're going to pull it up in just a minute. I'll help refresh your memory.
Yeah.
Also, you mentioned earlier that you didn't take, other than the vital records and the attorney-client privileged records, that you didn't take anything else out of the home. That's not entirely true. You also took a safe out of the house?
Yeah, I described that by report, but that house, that safe was returned.
Okay, so you went into the house with your own key, correct?
Yes.
You went into the family, I believe is in the master closet, is that right? Where was it?
Yes.
You picked it up, took it out of the house, and put it in your Tesla.
Yes, I believe I did that at the request of Clint Benson.
Okay.
Yeah.
And then you drove it to a locksmith,
I did.
and you busted into the safe.
I did not bust into the safe.
Well, he did.
He bumped. He used a technique called bumping. It's the movement of the door and the frame of the safe that allows it to come open.
Okay, but you didn't have a combination.
I didn't, I don't know if that was a combination. I thought there was a key to that one.
It was forced open with a hammer, right?
I think it was a rubber mallet, and it was dropped onto the ground.
Okay.
I think that's what eventually got it opened, was that it was dropped onto a flat surface.
And when you were doing that, there's no law enforcement there, correct?
I don't need law enforcement to babysit me.
Okay. And you open it up, and there's clips from guns in there, right?
I would have to go back to my report to recall exactly what was in there.
But you handled it with your bare hands, no gloves.
I did.
All right. And, I'm sorry. You also found an unusual residue in the safe. Do you recall that? That you touched with your fingers?
I don't recall that.
All right. We'll play that in a second.
Fantastic.
I do think we found the video of the laptop, so can we queue up for the witness only GXO 10073?
Yeah, that's my laptop. I am scanning into my laptop the documents that I am going through at the office. That is my laptop.
The black one?
Yes.
Okay. So you're scanning all the documents you're finding in the office and then loading them into your laptop?
Yes.
Okay. All right. And again, Clint Benson was not present when you were doing any of this?
Yes, that is my testimony on direct.
Okay. Now let's go to the one of the safe. Can you pull up the clip 100055? Hold on just a moment. 1055. See if you can find that one. Sorry. I think it might be under the impeachment documents. Nope. Okay. All right, we'll get the safe one up to refresh your memory about that residue. You don't remember touching some residue and filming it and asking the safe breaker if that was unusual to find residue in a safe?
I don't recall that. I would have to refer back to the video that I made of that for just this purpose.
Okay. No worries. So my understanding is you were at the house. There were some times before you got access to the house while Ms. Richins was still living there that you would sit outside her house and observe the house while she was in it. Is that fair?
It is not fair. That is false.
You never did that?
I never sat outside her house and watched her. False.
Not on March 9th of 2023?
Correct.
Not on April 12th of 2023?
Correct.
But you did put trackers on their cars, is that right?
I did.
And that's a secret device that you put on someone's car so you can follow where they're going without their knowledge?
So GPS tracking devices are generally covert, and there's good reason for that. I put GPS devices on Kouri's vehicle and two of Lisa's vehicles, one of which was being used by Kouri's brother, Ronnie.
So her mother's cars and her car.
That is correct.
And how long did you track these individuals?
I think there were different times for different vehicles. I don't recall the exact amount of time, but that'll be in the file that you have.
And did you turn over your reports on every single place they went for months to law enforcement?
Yes.
And you know that law enforcement is required to have a warrant to do that.
Well, they have to get a warrant, and I have to go through a different procedure that's prescribed by Utah law to appropriately place those devices.
Did you track anybody else's car in this case?
I want to say yes. Yes, I did.
Who else's?
There were some vehicles that I suspected that Carmen Lauber may be utilizing. But I discovered that, in fact, the vehicle that was parked at her house overnight on many occasions was being driven by someone else.
So you never gave that report to law enforcement?
I believe I did.
You gave the Carmen Lauber tracking report to law enforcement?
Yes, it wouldn't be named Carmen Lauber, though.
What would it be named?
Oh. I want to say there were a number of people that were associated with her residence.
That's all right. If it's
There was
someone.
Nick Bon Savage. There was another young man who were frequenting that residence, and I believe that vehicle that I tracked from that residence was seen there overnight on multiple occasions.
Okay.
I really don't remember, because the point of that was to track Carmen Lauber. And when I discovered that it wasn't Carmen driving the car, I removed the device.
Okay. Law enforcement was also providing you, I believe you said that Mr. Bloodworth asked you if you got information from law enforcement, and you said no. Is that right?
No, that is not right.
Okay, please correct me.
Well, I would have discussions with law enforcement. I could garner an understanding. I could read between the lines, if you want.
In fact, you went to meetings with law enforcement about this case, didn't you?
Oh, yes.
How many times did you have meetings with them?
I don't recall. I don't count them.
Okay.
The number is not relevant to me.
Well, you appreciate it might be relevant to me? Can you try to remember?
Half a dozen.
Okay. Can you pull up TG 11 for the witness only? Can you make it bigger? All right, sir, do you recognize that? Oh, can you see it?
I can see it.
Do you recognize it?
I do.
All right, and is that an email that you sent to Detective Woody on July 13th of 2022?
I'm going to have difficulty talking about this exhibit, because if it becomes an exhibit, it contains a confidential client communication. I did send it to Detective Woody.
Okay.
Your Honor, I would object to Mr. Gabler being required to testify regarding any claim.
With respect, I'm not sure you have standing to make any objections, and he seems fully attuned to the issue. Ms. Nestor, I'm not sure where we're headed, so just take it one question at a time.
I shall. Thank you, Your Honor. Is it fair to say that this is an example of you suggesting to Detective Woody that now would be a really good time for law enforcement to interview Carmen Lauber?
Yes.
And why would that be, sir?
She's on the ropes in drug court is what it says.
Right.
She was on the ropes.
And in fact, what you argued was she would be very likely to be compliant at this point with law enforcement. Is that your words?
Yes.
All right. Also in here, you accuse Kouri of lying about the name of her house cleaner.
Yes.
And the lie that you said Kouri told was that her house cleaner was her cute cleaner, Norma?
Yes.
In fact, didn't you, sir, finally confirm that Norma Garcia was her house cleaner?
I did later confirm that. Yes.
So when you sent this to police and said Kouri was lying, you were wrong.
I was wrong.
Okay.
But prior to Norma.
Your Honor.
Gabler, you need to pause for the next question, sir. Thank you.
Very good.
Did law enforcement give you access to I'm going to try to use the right word, to folders where you could access their information on like a subfolder, where you had a link to their folder?
No.
Did you provide them with links to your folder?
Yes.
And one of the links you provided them involved a download of Eric's phone. Is that right?
No.
Okay. Did it involve the decoded call logs that you talked about earlier where you figured out everybody's number and name?
I'm confused. You're talking about two separate things. You were just talking about Eric's phone.
You said no, right?
I had an identical copy of Eric's phone that I created from the backup on his Apple iCloud. I may have turned that over to them, but they already had Eric's phone. I didn't need to give them what I had done, which was to trick the Apple server into repopulating a blank iPhone so that I could then forensically examine that iPhone and come up with contacts from Eric's phone. So I may have given them that information that I created from a clone of Eric's phone.
So you had in your possession a clone or an exact copy of Eric Richens' phone?
It would not be an exact copy. Only the items that were unencrypted or decryptable from the Apple backup would be on the cloned phone. For example, encrypted data would not be present for biometrics, for his Apple Watch. If he was wearing a biometric watch, that is all encrypted. That would not come back to a new cloned phone. But all of the text messaging, the web histories, the call histories, all of that stuff will be present on that clone.
So you had access to all his texts?
I don't believe I did.
Why not? And this is maybe a stupid old lady question, but explain to me why you didn't have access to his texts if you downloaded everything off the cloud.
You said all of his texts.
Okay.
I don't believe I ever got all of his texts.
How far back did they go?
I don't recall the date at this time. I would have to refer to the file material to know the exact date of the first event on the phone.
So how much time did you spend reading through his texts?
Well, I don't recall exactly. I could refer back to some records to come up with an answer for you. It would have been a number of hours.
Hundreds of hours?
No.
Okay.
I mean, in this case?
Right.
936.3 hours.
Is how many hours you billed total for the case?
Yep.
And what were you paid for that?
I don't know.
How much do you charge an hour?
$125 an hour. However, that is not the only billing rate in this case. When I used computer forensic software and my expertise in that regard, the rate would be higher. $200 an hour, I think, was the discounted rate that I gave them.
So I'm really bad at math. Please forgive me if I get this wrong.
Yeah, well, we're both in the same place.
We're talking about over $100,000 you made on this case.
I would say so, yes.
Okay. Now I want to go back to that phone and you reading his text.
Yes.
As you were culling through your hypotheses,
Yeah.
obviously one of the things you want to look at is the state of their marriage. Is that fair?
I mean, it's significant, but it's not dispositive.
I agree.
It's important context, but it's not evidence of anything, really. I see a lot of bad marriages out there. In my career, I've handled many hundreds of divorce cases. So, people have problems.
Did you review text messages between Eric and some of his friends?
Yes.
Did you review text messages between Eric and Bryce?
Bryce Knudsen?
Yes.
I don't recall specifically, but if they were there, I probably looked at them.
Okay. Your Honor, can I have just a moment?
This was sitting here.
When you reviewed Eric's texts, did you find evidence of him sexting with people other than Kouri?
I don't recall that. I did investigate allegations of an affair with Eric.
Okay, but that's not my question. My question is, do you recall seeing sexting, as the kids say, on Eric's phone with people other than Kouri?
I don't really know what you mean by sexting. I don't know what the parameters of that are. And so my answer is no.
Okay. Did you find any texts where Eric talked about having an open marriage with Kouri?
I don't recall that.
At some point, were you investigating cases that were being prosecuted in the Summit County area around the time that Eric died, where people were caught distributing fentanyl?
Yes.
Did you gather affidavits from cases where fentanyl was being sold in the Summit County area?
Yes.
And did you ever follow up on any of those investigations, or did you just stop by gathering the affidavits?
Well, they were plugged into the hypothesis testing matrix. I considered them for their proximity, being in Summit County, and for them involving fentanyl. In each of those cases, I found no relationship to this case.
Okay. I want to pull up TG2, Katie, just for this witness only. Sorry, I lied about the time. I'm going a little bit longer, Your Honor. I'm close to done.
No problem.
Sir, do you recognize that?
I do.
Is that what you were talking about with Mr. Bloodworth, which is the decoding where you looked at his call records and tried to figure out who he was calling?
It is the record that I referred to when I was talking about it on direct. I agree with that.
And Katie, could we go to the page for the date 2/14/2022 at 12:23 p.m.? It's a ways down. Just a moment, Your Honor.
Of course.
All right, sir, we've blown up a section. Does that refresh your memory about what you determined a call that was made on December 14th at,
Give me the date one more time.
I'm sorry, February 14th, thank you, Your Honor, at 12:25 p.m.?
Well, this is not a record that I created, but I recognize the format, and it appears to be that Eric Richens' phone had an incoming call at 12:25.
Can you look at the call right above that one?
This is an outgoing call from Eric Richens' phone on March the 9th of 2022. I'm sorry, February the 14th of 2022 at 12:23, 2 minutes before the first record that we talked about, and that is to a different number, 801-473-5058.
So as part of your investigation that you were doing on the mirror phone, you could at least identify a call that was made by Eric at 12:23 p.m. on February 14th, right?
I'm confused. We're looking at an invoice record from a carrier, and you're asking me about his phone. Those are two different things.
Did this invoice come from his phone?
No.
Billing records?
From his carrier, from Verizon.
Right.
That's not a record from his phone. That's a record from his carrier.
Understand.
Two different things.
So according to the bill from his carrier,
Yeah.
he made a call at 12:23 p.m. on February 14th.
Correct.
Okay.
Objection. There's a 901 problem here.
I'm done with it, Your Honor.
Hold on. You got to approach for a moment, if you would.
There's a
No.
Make any calls or any trips to Mexico as part of your investigation in this case?
No.
You mentioned you interviewed 45 to 50 people, somewhere around there, 40 to 50.
Yeah, it's an approximate number. I have no method of calculating that number. It's approximate, based upon my memory.
Did you ever interview Kouri?
I did. I spoke to Kouri. She called me on January the 19th of 2023.
All right. And she voluntarily spoke to you
She called me.
and talked to you voluntarily?
She did, and I stopped her. I told her it would be inappropriate and unethical for me to continue the conversation outside the presence of her lawyer. I then texted her lawyer and had a phone call with her lawyer about the propriety of her client speaking without her presence.
Okay.
I then
So
requested that Kouri submit to an interview. multiple times.
All right, stop.
Okay.
Don't reveal what anyone else said to you.
Okay.
The point is, Kouri called you to talk to you and tell you her side, right?
I don't know what her intentions were. She seemed very angry that I had contacted one of her business associates. I believe that was the reason she called me on that date.
Okay. And so you never, to this day, have sat down with Kouri and heard her version of what happened?
No, despite my repeated requests.
Okay. But she called you.
And I was bound by the ethics not to talk to her outside the presence of her lawyer. She was a litigant. She sued my client.
Okay. And ultimately, as you were working with the trust, did you become aware that the trust filed a wrongful death suit against Kouri?
I am.
And are you aware they're seeking over $10 million in damages against Kouri Richins?
I didn't know that. It's irrelevant to me.
Okay. Okay, court's indulgence for just a moment, Your Honor.
Of course.
So while Miss Nestor does a quick little powwow with her group there, live court's going to be starting at the top of the hour, about another 8 minutes or so. So we will be picking up on that once they go live. They're going to be doing jury instructions. The two parties are getting together today with the judge. So the jury is not there today. So what we're doing is we're just doing a rewatch until live court starts. So about another 10 minutes or so. Yeah, they're going to be going over jury instructions, probably the verdict form, so basically the charging conference. So we're going to pick that up in just a little bit.
You found it? I asked you whether you recalled seeing any texts with Eric about him and Kouri having an open relationship, and you said you could not recall. Is that right?
Correct.
Can you put that up on the screen, Katie? Do you recall looking at that text?
I do.
You've seen this one?
I believe I have. It's a joke.
It's a joke?
It is. It appears to me to be a joke.
Did you see the text around this text?
I did.
So you have reviewed the text between Eric and Bryce?
I don't know. I don't know that this is a text from Bryce. I have no idea. This does not identify Bryce.
So
it doesn't
now
identify anybody.
Now that you have your memory refreshed, do you remember seeing this text between Eric and another individual saying that Kouri and I are starting an open relationship tonight? Right?
It says, Kouri and I are starting an open relationship tonight, so I told her I'm taking you home.
Right.
Yeah.
Okay. And you left that out of your report.
No. This would be part of my report.
Did you see sexting between Bryce and Eric when you looked at their texts?
I don't recall that, no.
Katie?
And is this sexting? I don't know what you mean.
No, I'm not talking about this one. I'm
Okay.
talking about other ones.
All right. I don't recall. I'm talking about many hundreds of thousands of messages in this case. I can't recall them all.
Let's see. Just a moment. Court's indulgence for just a moment. Between Eric and Bryce. Do you remember seeing a whole bunch of emails like this or texts like this between Eric and Bryce?
Honestly, no, I don't remember. Like I say, there were hundreds of thousands of messages in this case. I don't remember even 1% of them. As I look at this, I mean, it just makes me laugh. It doesn't appear to be serious.
So how many of these joke sextings did you review that Eric did?
I don't understand this to be sexting. I think you're wrong about that. I resist your characterization. These are two friends joking with each other. That's what I'm reading here.
And they did that all the time?
I don't know.
Hundreds of times?
If I had the records, and then I could answer your question, but I don't remember all of these messages, and yeah, this is a joke.
Did you review all of the texts between Bryce and Eric?
I think at one time I would have gone through every single text message that was available to me on Eric's cloned phone. So, do I recall it? Well, I mean, I recall that it was a bit mind-numbing. There was a lot there. Nothing particularly stuck out in my mind or memory about those messages.
Did they repeatedly talk about having sex acts together?
I don't recall.
Did they repeatedly talk about oral sex together?
I don't recall.
Did they talk about anal sex together?
Also don't recall.
But you read them all,
I'm sure that I did.
and it's all joking.
Knowing what I know about Bryce and Eric, yeah, that's how I interpret it.
So you do remember reading things of this nature, and you interpreted it all as joking?
No, as I sit here today, I interpret it that way. I would have interpreted it that way back at my original reading of it. That doesn't mean I recall it. It means I have an opinion about what I thought then. That's different.
And what did you think then? They were joking?
No. What I think now is that this was a joke. I do not have a recollection of this at the time that I first read it, but if I had a recollection of that time, I'm sure it would be the same as it is today.
And if there were these tens of 20s of 50s of these types of emails, all of them would be jokes?
Sustained.
Yeah.
That's it. That's all I have, Your Honor.
Mr. Bloodworth, anything further from Mr. Gabler?
Yes, Your Honor, thank you. The text, they're a bunch of to-dos locker room talk from August of 2018.
That was my read of it, yes.
There wasn't any serious read that Eric Richins and Bryce Knudsen were engaged in some homosexual affair?
Zero.
In all of the text messages you reviewed, did you see any evidence of Eric using illicit street drugs?
No, I looked and I could not find.
You mentioned legal requirements for a licensed private investigator to place a GPS tracker on a car. What are those legal requirements?
So the statute governing that was adopted a few years ago. It requires that before placing the device, a licensed private investigator must identify the person or persons that are driving that vehicle and potentially the owner of that vehicle, and that they submit a request to query the protected persons database in the state of Utah for any record of those persons that are subject to the GPS tracking. That is designed to keep us from tracking people who have protective orders or temporary restraining orders or other lawful processes that define them as a protected person. We cannot track you in that circumstance. We do not have independent access to that database. So we must ask an agency of the state for a yay or nay. Is this person in the protected persons database? We have to do that before we place a device. We have to be certain that we are not tracking a protected person. So I submitted those requests to the appropriate counties of the jurisdictions where I placed these devices. The Summit County Sheriff's Office initially declined my request under the statute. I insisted. I finally got them to comply. I did the same with the Wasatch County Sheriff's Office, and they complied with my request.
Did you conduct your investigation entirely within the bounds of the law?
I believe I did.
Did you conduct your investigation entirely within the ethical bounds of private investigators and the attorneys you were working for in this case?
I believe that I did.
Thank you, sir.
Ms. Nestor, anything further for Mr. Gabler?
No, Your Honor.
May we release this witness?
Yes, sir.
Yes, sir.
Thank you for your time. Please step safely. You are free to go, sir.
Thank you.
All right, and just like that, we have live court. So we're just waiting for Judge Mrazek to show up. So welcome in, everybody. And 3 o'clock Eastern, 3:01 Eastern, 1:01 Utah Mountain local time. So I hope you guys enjoyed that the rewatch. That was perfect timing, right? Perfect timing. What would have been better if Judge Mrazek was walking right in just now. Any minute. I did hear some people in the courtroom, so they are there. I did hear some folks making noise there, so we'll see. We'll see when they start. But anyway, yeah, thanks, guys. Hey, hit the like button. We have 665 likes. Who's going to be 666? Who's going to be the 666th like? Oh, 666. There we go. Thank you so much, you guys. Really appreciate it. It shows YouTube that you are a human and that we are, we're not buying likes, that we are here and authentic and genuine, and it really helps. It helps share our channel to all you new folks that are coming in, so really appreciate that. I am the Squeegee of Justice, in case you guys don't know who I am. Trial TV Live is also in the wings. That's Erin. She does a lot of work on the back end. She creates the shorts. She creates the playlists, a lot of the graphics, description. So I just want to let you guys know for those of you that are new to our channel. So let's see. Today we're going to be expecting. They're going to. Both parties are there. Jury's not there, right? Jury is off until Monday. So today is going to be all about the charging conference, which is basically they're going to go through the charges, go through the jury instructions, go through the verdict form. Just want to make sure. Hold on a sec. Let me just get. Okay. Just checking in. Nothing yet. So it's called the charging conference, which basically, again, is just they go through the charges, they go through the jury instructions, what they're going to tell the jury on Monday, the verdict form. And then on Monday, when the jury comes back, we will have closings. I'm not sure how they do it in Utah, if they do state, defense, state, or if they do defense and then state, but state always goes last. So however it works out. Sometimes they do jury instructions before they do closing. Sometimes they do some before, some after. Sometimes they do it all after. Again, I'm not sure how they do it in Utah or in this court. I'm not sure how Judge Mrazek handles that. But so that's going to be Monday. And then I fully expect the jury to start deliberating on Monday, I especially if they start at 8:30 their time. I have no doubt that they will start deliberating on Monday. Let me see, how long were the openings? I thought I had a oh, thank you. Appreciate that, Alice. Thank you so much. Thank you so much for your $10. Really appreciate that. Thank you, you guys. And thank you, Alice. And welcome in new members. I know we've been dropping, a lot of folks have been dropping memberships. So welcome in, you guys. Enjoy the perks. All right. I thought I had a system down. I was trying to get this system for whatever the openings are, just double it. But that went out the window with Colin Gray. I said, oh, well, the state only talked for like 45 minutes and the defense talked for a half hour. So the defense only talked for an hour. But, well, he talked for an hour and a half. Mr. Berry talked for an hour and a half. What was the one? I think it was Paul Canero. Was it Paul Canero that they just went on and on and on? All right, hold on. Let me see. All right, so the state's opening was only 27 minutes. So I thought I was being all cool and slick and saying, oh, well, that means I'll go, maybe they'll go for an hour. I think Mr. Bloodworth is going to talk longer than an hour. Oh, I hear some noise. All right, so Mr. Bloodworth, state's opening was 27 minutes. Defense, Miss Nestor, was 45 minutes. So she may be an hour and a half. I'm going to go with maybe she's an hour and a half. So we'll get there. Awesome Potamus. Hey, good to see you. Welcome in. Green-Eyed Cat. Welcome back in. Ken, how are you? The defense is going to talk and talk. Well, we'll see. We will see. They're going to talk for weeks. I'm going to go, okay, so the openings were 45 minutes. So if by my calculations, double it, I'm going to go even longer than that. I'm going to go an hour and, well, it would be about 2 hours. You think defense is going to talk for 2 hours? Because there's always so much. Well, they didn't have any witnesses. Not that matters, but they're going to attack the credibility of the state's witnesses for sure, right? They're going to attack Carmen. They're going to attack Robert. Even though Robert Crozier seemed more like he was a defense, he seemed more friendly with the defense, I thought. But Carmen, they will hammer her credibility for sure. But now that's all going to be Monday. And the state is just going to, let's see, what would the state be? The state's going to go through all the evidence they presented. Trying to think what more can they do other than just go through what they presented. Yeah, I think they'll just go through what they presented. You know, Kouri's, I'm really solid. I'll have to say I'm really solid right now. I'm really solid on the fraud and forgery. I think the fraud was very, very 100% proven. I do get hung up on the Valentine's Day attempt. I do get hung up on that. And then the main event, if you will. Sorry, Eric, I don't mean to say that. March 4th, the day Eric passed. I don't have doubt because I think there's enough evidence that Kouri did it, but for me it's more process of elimination. That's just the way I'm landing right now. And I'll explain that in a second. Cross-examnesia, 7 months. Thank you. Thank you so much. Best trial coverage. Thank you. Really appreciate that. And I appreciate you being with us for 7 months. That means a lot. Very cool. Let's see. So for me, and I've been talking about this pretty much this past week, right? Occam's razor, process of elimination, the simplest explanation is the right one. So you've got 3 possibilities, and Mr. Gabler brought it up. You've got 3 scenarios. Eric did it himself, Kouri did it, or it was accidental. Or you could throw a 4th one in, somebody else did it, right? So there's 4 possibilities. Eric did it himself purposely. Let me add that. Eric did it himself purposely. Kouri did it. It was an accident, whether it was Kouri or Eric, or somebody else did it. So those are your 4 options, right? So really just think about that. Nobody else did it because there wasn't a party. It was just the 2 of them. Kids certainly didn't do it. There's no evidence that there was a party or Kouri's paramour came in and slipped Eric the substance. So we can toss that out. So then we go to accidental. So what evidence do we have that this was an accident? Eric went to Mexico. That's the defense's main thing. Eric went to Mexico and he purchased this. I'm not seeing much evidence on that. Then the other thing is Eric did it purposely. There's definitely no evidence on that. Eric loved his kids. He was healthy. There was no talk of self-deletion on any level, right? He wasn't morose. He was happy. He was an upbeat guy. So that can be thrown out. So then you really only have it. Then it just falls on Kouri. It falls on Kouri. So and there's more evidence that Kouri did it based on Carmen and Robert, right? So that's where I would fall. So not that I have doubt. It's that I guess my only doubt would be how she did it, because some of you in chat were saying, fent is so toxic. If you crush it up, even just breathing some smoke, some dust particles, you'll have a reaction to it. So that would be, I think, my only question is that how did she do it? But I think I have seen personally, I've seen enough evidence. I have seen enough evidence, and it goes to Carmen. It goes to Carmen. She contacted Carmen 3 times. Carmen's GPS, shows that. Her text messages show that. So that's where I'm landing. I have no doubt that Kouri's guilty on the fraud and the forgery. The Valentine's Day, I'm still a little bit up in the air. So Murgatroyd, you agree with that one? Yeah. Where do you guys land? Where do you guys land? Heavens to Murgatroyd. He went hunting in Mexico. Sherry, yep. We know that, but that was like a month before, right? Didn't he go a month before? When did he go hunting in Mexico again? When was that date? Do we have that specific date? A few weeks before. That was defense opening. I want to know. Josh says he went on hunting trips. I want to know. Eric, okay. We don't have evidence. We don't have actual evidence. Now, Chelsea says that Eric was on a phone call about hunting with friends in Mexico when Kouri went to bed. So that's hearsay or whatever. Like, there's no direct evidence that he went. Like, nobody took the stand that said, okay, hold on. Eric's hunting trip to Mexico. Google search on Eric's phone about directions from Utah to Mexico. So that came in through Detective O'Driscoll. So do we know when that was? Do we know? I don't see any in my notes. I don't see any specific dates that Eric searched for directions on, February 2nd or something like that. So I'm just trying to find really specific evidence, and I don't see any. So you guys tell me what you think. We did take a poll. We took a poll at the top of the stream. 22% of you thought Kouri's guilty on aggravated and attempted M. 7% of you thought guilty on the forgery and fraud. 8% thought not guilty. 63% of you thought guilty on all of them. So where do you guys land? The Valentine's sandwich, Miss Bree, yeah, that one. That's the one. I don't think they proved that. Other than Eric got sick. See, why didn't they call in a doctor? To confirm that Eric? No, he said if he didn't feel better, he would go to the hospital. He never did go to the hospital. Okay, that's why. Polyphonic says DHS would have records of him crossing into Mexico, and I didn't see anything. Yeah, see, that's what I'm kind of frustrated with the defense. They could have very easily pulled up some of that. Said yes, here are records of Eric going to Mexico. They talk a big game, and I was waiting for them to give us evidence, but they just didn't. There was no. They didn't put on a case. They didn't put on a case. All right, you guys are guilty on all. I get it. I get frustrated with the defense because I was hoping that they would counter some of their openings. Right? They said a lot in their openings, as most people do. Right? But they talked about. Eric was hunting exotic animals in Mexico a few weeks before. Where was that evidence? Where was that evidence that Eric was hunting exotic animals in Mexico a few weeks before? Who brought that in? I don't remember that. Nobody said, "Yep, here it is. Here's him saying, yes, nobody brought that in." So to me, that's not evidence. It's just an opening statements. I'm just looking through more. There was an empty pill bottle next to him on the nightstand. I guess that was the hydrocodone or whatever. Yeah. Oh, I don't know. I'm frustrated with the defense. I just wish that they had brought more. I wish they had brought more to the table. All right, let's see here. Wizard says, I believe it's guilty on all, but a possible hung jury on attempted because that is the slimmest evidence. I think that's where they're going to have problems as well. I would agree because I didn't see it other than Eric was sick, and he called his friend. Was it Josh or Kouri? He called either Josh or Kouri, and I think maybe it was Kouri from C&E, Kouri and Eric, his business partner. I think he called him and he said he was really worried. He was scared. His voice was very worried and scared. See, Terry says, I think Kouri was the one who said Eric in Mexico and walk the dog ladder, but consider the source. Yeah, that's not, and the state brought that in. That didn't even come in from the defense. So, right, I think we can toss that. I would agree with that. Right, Mellow Yellow, that was from 2016, and this happened in 2022, so you're talking 6 years, right? Michael, no, the intoxicology reports, so not a bad gummy. Well, there's no THC. Yeah, there was no THC found, so we can toss that out the window, right? So why would Eric be taking random pills that he got in Mexico? That makes no sense, right? That makes no sense. Golden Dog Lover, you are allowed to use circumstantial evidence, and I believe that will convict her. Seashell, I think the defense was too busy keeping stuff from the jury. Was too busy keeping stuff from the jury. Polyphonic says, if you went to Mexico, 1, GPS of the car, 2, flight receipts, 3, receipts for big game hunting license, 4, passport stamp, 5, international calling on his phone. All of the above, for sure. Brad, trust me, if he was an addict, the hydro bottle from 2016 would be long gone. Hey, Maud. Hello. Welcome in. Thank you for joining us. Butterfly Wings, you slept in, didn't get to sleep until midnight. What did you miss? Nothing. We've only been doing rewatch of previous testimony, so you didn't miss a thing. Terry, yes, the dealer did. That's Robert Crozier. He admitted that. So on the stand, he said he never sold Fent, but then the police interview, he said he did. I'm sure Kouri said Eric was in Mexico. Yeah, but we didn't really hear anything on the stand, right? That's my issue. Jane, weren't the substances found in the mudroom cabinet? There was something found in the mudroom cabinet. Yes, that's what O'Driscoll said yesterday. Hold on a sec. I found a bag of loose hydrocodone pills in the mudroom walkway, but it didn't contain fent. Yep. So that's what O'Driscoll said yesterday. That is correct. That was yesterday's testimony. Yeah, Kuda, no gummies were involved. No THC was found. So then the next question is, how then does Kouri, if you're going to go down that path, and let's go down that path because we have time here, how did Kouri get the fent into Eric's body without herself becoming having a reaction? Did she grind him up and stick him in his Moscow Mule? Did she grind him up and take a... Well, no, there was no gummies. Unless she got just a regular kid's gummy and said, "Hey, here's a THC gummy. Let's celebrate." Then that's the next question, right? Gina, can't wait for your T-shirt and mug to get there. Thank you. Yeah, you guys, we have merchandise. This is just one little thing. We got a mug here. We have T-shirts. We have koozies. We got all kinds of good, cool stuff for you. So check out our store if you're interested. We got some really cool stuff for you. We've got Sarah Boone stuff. We've got T-shirts, hoodies, sweatshirts, all kinds of stuff. So thank you for that, Gina. Betsy, she wore gloves. That's what I thought, mask and gloves, and then she had time to dispose of that as well. So, Kuda, they probably dissolved in his drink. We had somebody in chat that said they tried that and it didn't work. It didn't work. I forget who that was. I'm sorry. I forgot who said that earlier. JPC tweezers. But would an entire pill dissolve though? I don't know. Would it, the lemon drop shots? But she still would have had to crush it, right? You can't just, plop a pill in somebody's drink, right? Bama says hunters from the U.S. often go to Mexico during off-season. Downey Lynn says, I think the drink would be so cloudy if she ground it up. But if the drink is already dark, then you're not going to see it, right? You're not going to see it. She used the tweezers that were found. But so that's my question, would the pill dissolve? That's my question. That's my question. Thank you, Sparkling Princess. Appreciate that. Defense is not required to put on a case, play on crime says, but prosecution didn't give sufficient evidence for what they brought in opening. Jad Ziadak says, could she have dissolved the fent in something and added it to the drink? I suppose. What my Google searches are gonna get me in trouble, but I'm gonna look that up. Hold on a sec. She could have bought a grinder for pills. You can get them at pharmacies, and if the pill is soft enough. All right. Can I grind up fent pills? Oh, Lord help me if the police ever get my Google searches. Can you grind up, not fennel seeds, fentanyl pills? Oh, God. Yeah, National Helpline for Mental Health, Drug, Alcohol Issues. Gulp. I guess it's just basically it's just a pill, just a regular pill. So I guess it's just like a regular, right? It's just a regular pill. Yep. Okay. Can fentanyl pills dissolve? Can fentanyl pills dissolve? Okay, dissolve in water. Okay, here we go. Yes, you can dissolve in water. Both pharmaceutical and illicitly manufactured pills are commonly dissolved in water for various purposes, including administrative, drug testing, or safe disposal. Okay, so there you go. So they can dissolve. Oh, they can dissolve. Hey, tulips. All right, here we go, you guys. So you can dissolve them. All right, upon further reading, while fent is a solid powder at room temperature, poses an inhalation or incidental ingestion exposure threat if sufficient powder becomes airborne. Fent can also be dissolved in solvents, and it is soluble in water, which allows exposure in aerosol form. Doesn't say for how long. If there's any bits of tablet left after 30 minutes, you can swallow them with a glass of water. It's a common misconception that fent can be absorbed through the skin, but it is not true for casual exposure. So then there's that. So she couldn't get it through her. She couldn't get it through. That's from the that's from UC Davis. So you can't. So if you're just touching it, you can't absorb it. So she would have had to either just drop it in water and let it dissolve. The tablet should dissolve in 14 to 25 minutes. So 14 to 25 minutes. There you go. All right, I'm going to drop that. This is from the Mayo Clinic. All right, this is from the Mayo Clinic. So the Mayo Clinic, let me go here. So allergy, pediatric, geriatric, other interactions and medical problems. All right, proper use. Place the tablet under your tongue until it dissolves. So that's Abstral tablets. So this is pharmaceutical stuff. This isn't like street.
1500139, State of Utah versus Kouri Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant, Kouri Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos. Let me just provide a little context for where we are at the moment. I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all, yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing
Okay.
generally.
Ms. Nestor?
No, Your Honor.
All right. So may we go by page number, working off of the draft that the court just provided to counsel. Pages 1 through 14 are the opening instructions that the court gave prior to opening statements.
Right.
Yes.
Any objection to including those in the closing instructions, Mr. Burmester?
No.
Okay. Ms. Nestor?
You want to reread them?
No.
Oh, good.
I'll start reading at page 15.
Oh, great. Then
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay. Pages 15 through 23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial beginning. Take a moment.
No objection from the state?
No
Okay.
objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in-custody informants. It would require maybe a little editing to remove some unneeded syntax. So first, I need to hear from the state about whether they have a general objection, and second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence regarding those periods, because she's not in custody during the time she's on the stand.
Right.
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction.
From the 10th Circuit?
Right.
Yes.
State, yeah.
That Garcia
Right.
instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer, rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or the testimony about immunity, as well as foreclosure. So that all is great for argument, but I don't know that we need any special instruction, given that neither person was in custody at the time they testified.
Ms. Nestor.
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lauber, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in-custody informant, I think the importance of this is she was she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but I mean, it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this, because the immunity agreement also covers federal immunity, state immunity.
Yeah.
I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
Mr. Burmester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Carmen Lauber. It should be Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in custody, correct?
Yes.
Okay.
In fact, we saw an interview with him in custody, in Stripes.
Same with Carmen Lauber, right?
Mm-hmm. Yes.
Yeah. Okay.
And once again, this instruction is designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And that's what this was designed for. That is not this case. Both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction or something along the lines of Garcia mentioned before.
All right. Let me think about this for a moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction as well.
I understand. And Ms. Nestor, I understand defendant's position to be the state should give both instructions properly edited.
Right. It is occurring to me, if the concern is there is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flipped on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but that one may be closer to the facts of this case. Than this one is. And I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Yeah. Okay. We'll come back to that. Okay. I've made some notes. We'll return to this issue at some point. Okay. Pages 26, 27, 28. Standard Muji second closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry. Which pages, Your Honor?
26, 27, and 28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep, I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right, and then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that if that evidence that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that I'm not, but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
Okay, I understand, and the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection in argument is based on State versus Wall, 566 P. 3rd 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah appellate court authority, defendant's objection is respectfully overruled. Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Well, then we go to page 29,
Right.
which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Ms. Nestor?
Yes, thank you for doing that.
Mr. Burmester, any objection?
No.
Okay. Bear with me, folks. Let me just make sure my notes reflect what we've talked about so far. Okay. That brings us to page 30.
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester?
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction, inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
do you have any other non-character purposes for that evidence?
Yes, Your Honor. Like all but one or two of them, I think, can apply.
Well, but as I understood, the only reason, and when I instructed the jury in real time, the reason I gave them was motive. Was you weren't? Was it also go to
can
preparation?
It go to identity, preparation, intent?
I know it can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that one. The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice. We, argued for the admission based on motive, intent, plan, and preparation, and identity. Those words are always lumped together in our briefing.
I know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive. The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity. Or determining things such as motive, plan, preparation, or identity.
For the limited purpose of determining things such as the defendant's motive, plan. Okay.
Yeah.
Yes, sir.
Okay. Ms. Nestor.
Well, I think the court was right initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct, so I would object.
Certainly the first bullet point would go to preparation or plan. Plan, not so much preparation.
I just would like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it. Okay, 32, 33, 34, 35, 32 through 36 are Muji second standard instructions.
No objection from the state.
Your Honor, on 33, the law enforcement officers, I think that should be plural. Many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it.
And then the rest I don't have any objection to.
Got it. Will do. Okay. 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives, plural, which is a little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the the court proposed the version on page 38.
Can I clarify? I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just want to look at that together as an example. So go to page, for example, page 41.
Right.
You could have 8 jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A, and without ever agreeing about a motive at all, just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of...
Yeah, the difficulty here is the pecuniary gain is a why, not a how, and why is motive.
Right, that's right.
Well, if you... Motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A, and so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that...
Because then we don't have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
I mean, I do believe the motive is there in the elements instruction. Whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean.
Right.
Without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
Yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction.
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted. Okay. Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
Your Honor, I know we didn't pull it as... I guess we pulled it by agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to conviction.
But don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Yeah, I think that was part of the stipulation, is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and then I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
At sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court for determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary. On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Mercer, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay, is this, Fred, Mr. Burmester, is this definition of attempt the same as yours?
Yeah, that was added by the court before I ever got a chance to ask him to include it. It appears to be the same thing. So.
Okay. Just one moment, Your Honor. Can I just compare something just very quickly on the attempt?
We'll need to take a break, so put a pin in it if you want.
It just will take me 1 second. Okay. All right, so we can just toss this, right, Mr. Burmester? We can throw this out.
Absolutely.
Okay.
That is.
All right. No objection to the rest of the definitions instruction, Your Honor.
Okay.
Or to number 40, which comes after it.
Thank you. Mr. Bremer, is there any objection to page 40?
No.
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. But I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's my reading of this statute and the information that in order to convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone, and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that I think you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, that the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
Right.
I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included, or I mean, you could certainly argue to the jury some factual inference that, listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
That line of reasoning or doubt.
So.
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't assisted suicide manslaughter.
So I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say, I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
Well, here, I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark. So.
Imagine a healthcare provider says to a patient, would you like some morphine to help with your pain? They say yes, and then pushes the plunger way too far intentionally. I think that's still aggravated.
That's an intent to cause death, though.
The death, yeah.
Right. But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they put that testimony
Yeah, but that's a different element, right? You're down on 4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B. Let me pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes.
Okay.
Yeah.
And Your Honor, this, from reading the tea leaves on how the facts came into evidence in this argument, the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that the defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder?
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together. Yeah. You know, we split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together, sure, that is fine. But intent is not an element of 4B. Like
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to cause a death. Intent to cause a result, that's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't in Utah because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Mucci typically work.
Yeah.
It's confusing.
You can send a strongly worded letter to the Mucci committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike. Let's just go down the page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins because the court rules as a matter of law that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language, of which I've provided two versions, one more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
That's 100% the law. That is correct.
Yes.
You're right, because I was going to say I thought we did this, but you're right. We put it in a separate instruction. This is much better to put it in the element instruction, I think. I like it better.
Let's be clear. This was Melanie's idea.
Yay, Melanie.
Yeah.
Yeah.
So we're talking about the top.
So you've got
A and B,
you got
right?
2 options here, right? You have the more wordy option before the or the more elegant version after the or.
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch. So, Ms. Nestor, if we were to see in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means. As we do this, though, I'm kind of leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think in the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Or just put a S in a parentheses, so it could be either.
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1. Okay, pause there for a minute. With I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven. If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that sentence. Got it, thank you. And we'll just we'll mark your decisions on the verdict form. Okay. Ms. Nestor, anything else there?
Just a moment. I'm getting a text. I just want to make sure I'm listening to my co-counsel here. Okay, no, that's fine, Your Honor.
Okay. I will make similar changes to the elements of count 2. So we'll get rid of the italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
Okay. With respect to the definitions of mental state, murder is homicide's one of the rare crimes where it is a result-based crime, not a intent or action-based crime, right? Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
It's certainly with regards to 1 and 2. One would think this is a super easy thing to figure out if something is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But I have no objection to proceeding with the way the court has laid out
Okay.
Right.
the mental state's definition on page 46.
Right. I think initially the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate. I don't know. I always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state to find counts 3, 4, and 5 to after
you give the elements instructions. I think that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay. Ms. Nestor.
So you're going to move what's on page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is the same language we had. Yeah, no other objections to that.
Okay. All right. I have lots of questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So I got to pull the information. We got to look at the statute. Bear with me for 1 moment. Melanie, I'm not ignoring you. All right, so let's focus on count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76.
Here's your charging.
6, 521. 2D, right?
Yes.
All right, so let's start with couple my mental state. Because the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
Well, it says it specifically in Part D.
Oh, with the intent to deceive or defraud.
It's a specific intent.
Oh, there we go. So this is where it gets confusing, because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So, 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's fine.
So we'll take that out. And then, Ms. Nestor, in your submission this morning, you make reference to 2D's
Right. Let me pull that.
phrase, fees for professional services.
Right. So I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection 521(2)D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute. Okay. There's something going on with my computer. All right.
Excuse me.
Okay. There we go. All right, just a minute, Your Honor. 76 6 Here it is. Okay, I'm with you. Please continue.
All right, so 521(2), an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain 2 categories of things in the alternative: fees for professional services or anything of value, and then by certain means. Why doesn't it apply equally to 2 alternative categories of things?
I read that differently.
Okay.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not what anything to do with Ms. Richins. I think they liked the second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that go, I've represented them. They go around and they sell junk. They sell a policy that doesn't cover anything, and they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product, and it's fraud. And that's what I think they're talking about in this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime. They got to prove it as it's written. And they just deleted that word.
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or. And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2, so I understand. I'm looking at the definitions, though, for the part and the definitions in 101.5, and they don't define insurance. I mean, the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications and the communications fraud isn't doing much besides requiring that somebody communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular, because I just kept reading it over and over, and I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they've proved this, and I actually think they charge the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well, depends how you read it. I mean, if you take out the words or anything of value, or
no,
it doesn't make sense.
I wouldn't take those out.
No. I'm saying for purposes of trying to understand it in context, right? So, like, the initial part of this says, intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that or anything of value goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's going to just have to figure it out. But
okay, but even in your world, in your view,
yes.
I hear you saying it would be 1, Kouri Richins; 2, with intent to deceive or defraud; 3, intentionally and knowingly or recklessly devised a scheme or artifice to obtain
fees for professional services.
3A, fees for professional services, comma, or 3B, anything of value.
That's not how it's written, though, Your Honor.
It's exactly how it's written. I just put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected. I don't think it's written that way.
Oh, okay. Well, then we should take the 1, 2, and 3 out as well.
Take the which one?
Never mind. I understand your point.
Yes.
Okay. Mr. Burmester, go ahead, sir.
If we're going to add the theory that we're not proceeding under, then it should be A and B to make it clear, because it is an alternative. It's a list of two.
Yeah. I don't know how to read it any other way.
If that's wrong, it comes back though, because that's not. These go straight to elements.
Okay. So, Mr. Burmester, any objection to including the language in the alternative form as it exists in the statute?
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay. Let me give that some thought.
Your Honor.
Mr. Ramos, go ahead.
Just as you're giving it some thought, and I'm looking at 76.6521, just straight from the code. An actor commits a fraudulent insurance act. I had missed it on, Your Honor probably miss it. I missed it on the first one, but going back to the Insurance Act, that isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay, thank you, sir.
Thank you.
All right. Very good. I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester.
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh, thank you. You're right. I went too fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3 on
count 3.
47.
I'm sorry, I got to go back. Just 1 minute. I thought we were on 4. Okay, element. Oh, took a substantial step. That came from case law. That's case law.
Have the citation?
I did on the one that I filed. Let me pull that up, Your Honor. Just a moment. It's document 1584 on the docket. And wait a minute. Count 3. This is a different one. Let me see. I might have written it in my notes to the state. Just a moment, Your Honor. Oh no, I don't think that came from me. I don't think that came from me.
It did not come from the state.
I think it did. I can go back to what you emailed, or from the parties, and was represented as. But it's not in the statute. Neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted.
Oh,
those.
I know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521-2D would be the devising the scheme, which I think is Ms. Nestor's point.
Right.
Well, if you devise it,
I could think of one right
never
now.
say anything,
Right.
do anything, have you violated the statute?
Right.
So what is the actus reus? What's the conduct?
By means of, and then those.
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't beyond a reasonable doubt.
That would be fine with me.
I mean, forgive me, count 3 is I get confused between count 3
It's
and
the
4.
scheme one with the $100,000 two-stage policy.
Yeah.
Filing of the application.
Yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
Just signing
filing
it.
the claim as well. But yeah.
Okay, sure. Yeah. We could instruct the jury that the state's theory is that Kouri Richins committed this crime by A, B, and C. I give it. Yeah, right. Yeah. We'll take a break. You can all give that some thought, maybe talk to each other. I understand your concern. But it seems that we don't need to be coy. We can just tell the jury what the state thinks and either the state proves it or they didn't.
Yep.
Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
This I don't have an objection to, Your Honor. I think this tracks the statute and it also tracks the case.
Okay. Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection. Sorry.
That's okay. So then let's look at elements of forgery, count 5, 76-6-501. 2B1. An actor commits forgery if, with purpose to defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent. This is the signing of the true stage life insurance application, signing of Eric Richens' name, allegedly, to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
Okay.
Oh, there it is. Got it.
So we've got to keep with purpose to defraud anyone in there, right?
Yes.
Out of paragraph 2.
Yes.
Okay. But then I think, if I understand what you submitted correctly, you're asking for without the authority to do so.
Right. That's right.
Okay.
And that's based, I cited the case law on that. State versus Gonzalez, state versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor. That's an element that
Very good. So
supported by those cases.
2 and 3 stay in, correct?
Yes, sir.
Yes.
And then do we need to, can we skinny down 4 in any way to match the state's theory? Or
I don't know.
it's
that we
just the
have
way it goes?
Authentication. You may.
I mean, execute and authenticate don't really match the facts of the case.
Isn't execute just sign?
Yeah, because I thought execute meant make it effective. Like, I don't know. And authenticate usually means notarize or something like that. I still don't know what utter means.
Well, we can go back to page, any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing. Or just make a writing.
Make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean, we're dealing with an existent person, so
At the
it
time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay. Got it. Thank you. Okay. Pages 50, 51, 52, 53 are Muji second standard instructions.
Yeah. I agree with that it is 50. But, it certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its closing can start with count 1 and then pivot to saying you can consider the strength of the evidence regarding count 1 as part of your consideration of count 2.
Okay. I just wanted to make sure we're
What
not...
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I was kind of concerned.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just 2.
Okay.
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say, several sections.
To several sections?
Yeah.
Okay.
One section for each count charged. Any objection, Mr. Burmester?
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says 2. I'll edit it to say several sections.
Okay. No objection.
Ms. Nestor?
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Well, I just don't see the harm in doing. I mean, I think I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I agree, and that's why you should look at paragraph 3 on page 51.
Oh, okay. Did you stick it in there? I didn't see it.
No, it's just part of the standard overarching unanimity instruction.
Oh, that's fine.
Recently had a hung jury. I need a place to start to apply gentle pressure to keep working. And this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo on it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you. Got it.
That's kind of an important section.
Yep. Okay. All right. May we please, and Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
Let's go to the verdict form next.
Okay.
In fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one time as if we were jurors answering it to make sure that it flows correctly.
Okay, give me just 1 second, Anna. I'm sorry.
Your Honor, I don't, well, unless it's at the beginning, I don't think I got a copy of the verdict.
I think it was in the email that I sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now.
That is entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
let me forward
Kathy, maybe just resend it.
Yeah, I'll send it right now.
Thank you.
Okay. I just sent it. Okay.
I should say skip to count 2.
Oh, we're going to take out 1B. And so this has to change to right there. Count 2. So I'm going to take out 2B. Okay.
Concerned that. Go ahead.
Oh, if we include it. Yeah. Okay. So let's see. Let's start with you, Ms. Nestor. So we'll take out the plural of inquiries and we'll say skip to count 2. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right.
Same for count 2. Similar changes?
Right.
Any other changes?
Yes, so I have some worries about it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but you could be saying you unanimously agree.
Oh, I'm sorry. Are you under 1A?
Yes, sir.
Okay.
So let's say they checked both.
So rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would solve it.
Okay.
That takes care of my concern. Because my worry would be they would mark them both and we would never know that they were unanimous on each.
Okay.
Or if they split it half and half. Does that make sense?
Yep.
Okay.
Any objection, Mr. Burmester?
No.
Mr. Ramos, my apologies. Go ahead.
No, I apologize, Judge. I jumped the gun a little. Just for flow's sake, right under guilty of aggravated murder, the in parentheses, I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count 2, and then
sure.
After that.
That's fine.
Actually, that does make more sense.
No objection from the state.
Got it.
Same on.
Remains consistent with the.
And same under
earlier
count
question.
2 as well.
Got it. Okay. Then, before we take a break, Ms. Nestor, may I go through just what you've submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment. Okay, I'm ready.
All right, we handled the quote without the knowledge or consent of Eric Richins language on the record. Changing her to there, I didn't see a spot where that would be a problem in these instructions, but
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think it's a problem anymore.
All right. 3, insurance fraud. I understand your position, and I'll take a break and make a ruling on it.
Okay.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Number 5. Why don't you have sufficient foundation pursuant to the witness credibility instruction on page 22 to make exactly this argument? I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the stand, that gives them an edge. And I think a jury can consider that, and I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction, because O'Driscoll was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
Mr. Burmester, I certainly understand why defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuondo didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. There's no basis for the court to give its imprimatur on O'Driscoll's veracity.
And can I just, before you rule, Your Honor, I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So if that makes you feel more comfortable, I would do that as well.
I will, with the benefit of counsel's argument, take a fresh look at Portuondo versus Agard, and after the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further?
No, Your Honor.
Mr. Burmester.
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's handled. We took out the children testifying and the age of witness instructions. I've given the request for a re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. I'll come back on that. And then we've already discussed the in-custody informant instruction. I'll give you a ruling on that in a few moments. Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before we take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
Spoliation is a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes. I understand that.
Okay.
Do you need a break, or do you want to just do it?
Let's
knock
take
it
a
out?
break while you get that lined up.
Okay.
But I, like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So, all right, Mr. Burmester, anything before a break?
No, Your Honor.
Okay. 3:15, folks, please. Thank you.
All right, judge is going to take a break for, he said 3:15, which would be 15 plus another 8 minutes or so. So roughly, let's see, 15, 20, yeah, about 25 minutes. So, all right, so we have time to go over what has just transpired. All right, so they went through jury instructions, right? And then judge is going to come back and give some rulings on things that they were talking about. So basically, pages 1 through 14, just standard opening instructions, nothing major there. Pages 15 through 23, again, more standard instructions. Page 24, 25. This was standard instructions regarding Carmen being in custody. Now, this is where they kind of started to go back and forth a little bit. The state says this language is for a witness that is a snitch, to which Carmen was not. And they say the defense has the state said that, let me turn this down a little. All right, the state said that, all right, how's that? Is that a little bit better? All right, the state said that the defense has given them, hold on a sec, let me go back to here. All right, so the state said that the defense has provided an alternative, and that they would like to use that. But then the defense says, well, Carmen does fall in this category, but it needs some editing because she was making some statements knowing her freedom was contingent on that fact. So let's see. All right. So Judge added some of those dates that Carmen was in custody, and she certainly wasn't in custody when she testified. They also want to add immunity needs to be added to that. Let's see what else. Then we come into the state says, well, if you're gonna do that for Carmen, you have to include Robert Crozier as well. So they agreed on that. Then we go to pages 26 through 28, some more standard closing instructions. Defense is objecting to the definition beyond reasonable doubt. Judge respectfully overruled on that. Page 30, nothing. Page 31, court's efforts, 404B instruction, which is basically past crimes, bad actor, that kind of stuff. So this had to do specifically with motive, plan, preparation, or identity. They were kind of talking about that, hammering that out. The defense objected. They thought it was fine the way it was written. Then we get to pages 32 through 36. The defense says their only objection is the multiple law enforcement officers instead of singular, so not a big deal there. Page 37, if the jury found the means, not the motive, they could still convict her. So the state proposed an alternate version on page 38. So this had to do with, pecuniary gain is one of the motives, right? The state alleges, so it's a trick for the jury to kind of try to figure that out. So the judge says, well, the best option is to not give a motive, right? Don't give a motive. So the defense wants to take that out. So the state agreed with that. So page 37, 38, out it goes. Then page 39 just was a bunch of definitions. They went over a bunch of definitions. And then they were talking about cohabitation, and Kouri kind of snickered, I guess, at this. They all know, I guess there was some DV, or there's something about DV in here. So the defense didn't want that to be considered by the jury. We're not going to challenge cohabitation, but it should come in at sentencing. So I guess this does fall under DV. If they do find her guilty and then it goes into sentencing, this would be considered, DV. You took out your husband, your spouse. So judge had Kouri. She waives her rights. She's going to let the court decide at sentencing if it comes to that. Then they got into page 40, italicized language. There's inference that Kouri got the fent because Eric wanted it. Then he goes into this. He says, I think the state has proven this is not an assisted self-deletion, right? So he says, well, I have a morbid and dark scenario, to which Miss Nestor says this whole thing is morbid and dark. So his scenario was, what if a healthcare provider asks a cancer patient, do you want more pain meds? And then pushes that plunger way too deep. So they kind of bantered that about. State, can we put 2 and 3 into one sentence? That would be counts 2 and 3. Judge says, yeah, we can, but in Utah we don't do that. We want to make sure the jury separately, unanimously finds beyond a reasonable doubt the culpable mental state. There are multiple ways to find this was committed beyond a reasonable doubt, but you've got to agree about which one of those aggravated circumstances you believe the state has brought. Then he gets into intent and mental state definition. Just because someone doesn't pass away doesn't mean you didn't intend for that to happen. It's like we're flying blind a little bit because I wish we could have the instructions in front of us so we could see what they're talking about. So forgive me if I miss a lot of things in here, but I'm just trying to pull out some highlights. Judge says, I have lots of questions regarding elements of 3, 4, and 5. And Ms. Nestor says, I do as well. So counts 1 and 2 is the aggravated and then attempted, and then counts 3, 4, and 5 are about the fraud and forgery. All right, so this has to do with the fraud and forgery. So defense says count 3, which is the insurance fraud claim charge. Defense is like, that's not the proper crime. They wanted to charge, but now they have to do it as written. So a judge has to sort that out. Defense had no objections on count 4. The state had no objections as well. Count 5 is the forgery. So 3 and 4 were fraud. Count 5 was forgery, which had to do with the signing of Eric's name to the True Stage application. And then then we jump down to page 54, and this is where they get into the instructions about the verdict form. So interesting, page 56, judge says he's had a hung jury before. He's like, I have to have this ready in the wings to apply slight pressure for them to keep working. So that's interesting. Those words may come back. Those words may come back to not haunt anybody or Judge Mrazek, but he has had experience with a hung jury. So he wants to be ready that he has specific language that both parties agree on. Then they talk about the verdict form, and Miss Lewis did not receive a copy of that. Then the defense says, oh, this is interesting. Yeah, so this has to do with Detective O'Driscoll. If you have a witness, so you guys have brought this up a lot, like why can't a witness be sitting there, or why can't somebody be sitting in the gallery and then come up and testify? Well, here's specifically why. We've been talking about this all trial. If you have a witness that has sat through the trial and then takes the stand, that gives them an edge, right? You can't have somebody sitting there watching the entire trial and then they get up and they take the stand and they kind of hedge their testimony to fit one way or the other. So that was specific to Detective O'Driscoll, but we've seen that in countless trials where you have the lead detective, lead investigator sits there, or if you're a victim, Elisa Mathewson with Trevor Summers, he kidnapped her and was horrible things to her for like 3 or 4 days, I think. So if you're a victim, you can sit in the gallery and then take the stand. If you're law enforcement, if you're the lead detective, you can sit at the state table and then get up and take the stand. And then we saw Katie, Eric's sister. They called her straight away for that very specific reason so that she could then sit in the gallery. So she testified second. It was Eric's father, and then Katie testified. So then they talked about the spoliation instruction, which is basically the jury missing evidence. So they want to, defense wants to bring that in. Judge is like, well, you're going to have to give me a showing. You're basically going to have to give me something in writing, right? Give me something in writing. We've talked about it. You've talked about it, but now give me something in writing. So, all right. So that brings us to the break. Judge is going to be back in about 10 minutes or so. All right, what are you guys talking about? Miss Justice, if Kouri gives hydrocodone laced with fent, both would show on the tox screen. Nestor is trying to be sneaky, facts not in evidence, and accidentally gives him laced pain medication. And just a reminder, misspelled that drugs. Just put an asterisk in there or call it rugs or something else. YouTube does not like that word, so just remember that. Yeah, Shirley, thank you. Yeah, definitely hit the like button, you guys. 837 likes. Really appreciate that. Thank you for your support. And we have 651 people watching, so awesome job, guys. Awesome job. Thank you for watching today. Really appreciate it. Shirley, thank you for that. And yeah, Kimbers, thank you for reminding. Yeah, call them frogs. Just be clever. Just be clever. Let's be clever. Let's show our intelligence, all right? Let's show our intelligence and be clever out there. Be clever and use different ways to. We'll talk in code, all right? It'll be our way to talk in code. Super Ball's right here. What do you say, Super Ball? As she cruises by. Yeah, just be clever. Let's be clever. What's up, dude? Hi. You gonna say hello to everybody? Yeah, hi. Well, hi. Hi. She's giving the silent meows. What's up, kiddo? Yeah, I know. That's a good girl. Life's tough, I know. Life is tough. That's a good girl. Yeah, that's a good girl. I know. Meh. She's giving silent meows. Meh. What's up, kiddo? Yeah, it's a good girl. All right. I got the little vampires over here are stirring. Ow! Serious? She just bit me. Hi. Hi, hi, hi. Yeah, it's a good girl. I love her silent meows. That's a good girl. All right, everybody loves you, Super Ball. All right, I'm going to go grab some water because I can hear it in my throat. I'll be back in a second. I need some water. All right. Hydrate and stretch. Yes, lazy boys. She's a killer kitty. Cue. Let's see. We could cue the Super Ball was in the house. Cue the Queen song. She's a killer. Instead of killer queen, she's a killer kitty. What's that? Gunfire and laser beam. Dynamite with a no wait. Gunfire, dynamite with a laser beam, guaranteed to blow your mind anytime. She's a killer queen. What is that line? She's a killer. God, I haven't heard that. I haven't thought about that song in a long time. What is that? She's a killer queen. Caviar and cigarettes, well versed in etiquette. She's a killer queen. Oh, gunpowder gelatine. That's right. Dynamite with a laser beam, guaranteed to blow your mind anytime. I'm gonna listen to that song tonight. That's a good album. I think that was one of the first albums I bought. No, I think, yeah, Bohemian Rhapsody was I think that was one of the first albums I bought, was Bohemian Rhapsody. All right, let's see. What are you guys talking about? Exactly, rock and roll. Guaranteed to blow your mind anytime. It's a great song. Well, yeah, we have 7 kitties. We have 7 kitties, as Aaron is saying. Super Ball is the oldest. She came when we were living in South Florida. We found her. She found us. She's a feral. And then when we moved a little bit north of South Florida, Rafa, well, first Polly found us, but she was in the back. And then Rafa found us, and he kind of brought them forward. And then, and then Polly got pregnant last year, and she had four kittens, Riker, Houdini, Sid, and Roger. Your first album was Def Leppard? Rock and roll, love me some Queen. Nestor needs a cat. Love that thing they play in? Yeah, it's a little cat treehouse. They're not, they haven't really been up there recently, though. They kind of come and go with them, with toys and things that we have scattered around the house. They find their little spots. They were, yeah, hey, Downey, we, if you go to our playlist, if you go to our channel, we did Kitty Cam. Well, during lunch we have Kitty Cam now, but we had them when they were kittens, like a week old, days old. So if you really want your moment of cuteness, go to our channel, and we have it under Kitty Cam. I think there's 2, 3, 4 maybe. Yeah, we were doing it like every weekend. So it was, yeah, if you want your moment of cuteness, definitely go check that out. Pammy, I think Rafa experimented and finally figured out. You keep saying that, Pammy. You keep saying that. I don't know for sure. All I know is she left and she came back, like Aaron said. She left. Polly left for a day and a half. She came back and she was pregnant. We don't think Rafa is, but I know Pammy. Pammy, we're not gonna convince you. We're not gonna convince you otherwise. I know it. Your first albums were 78s of Elvis. Very cool. Polly. Well, Polly had a lost weekend. Joanne Jedi Platypus popping in to lend your support for Bohemian Rhapsody. My first love was Freddie Mercury. Yeah, he's fantastic. He's just fantastic. I mean, that whole band is just fantastic. Brian May, as a guitar player, Brian May is like, ranks right up there for sure. Grampy, I can't stay, but I just heard you say Super Ball's name, so in honor of her, she is gifting. Oh, Grampy. I'm sure Super Ball appreciates that. Yep, Cat's in the Cradle, Silver Spoon. Little Boy Blue and the Man in the Moon. When you coming home, son, I don't know when, but we'll get together then, Dad. That's a great song, too. Brian May rocks, no doubt. I never saw Queen. That was one band I never saw. I mean, there was a lot of bands I didn't see. Don't get me wrong. I saw a lot of bands, but there's a lot of bands I did not see. And Queen was one of them. I never did see Queen. Man, I think there's a great chance that Rafa is the daddy. I know you don't agree, but you're only the family. You never know. It'd be fun. It's fun to think about. Deep Purple. That's like the obligatory song every guitarist learns to play. Like that's like one of the first songs because it's so easy, but it's so hard, but it's so easy. It's easy when you don't know how to play it. When you actually figure out how to play it, you're like, oh, that song's a lot harder than I thought. But that's like the obligatory first song. Guitarists in chat, back me up. Is that like the first song you guys learned how to play? I think that was probably my first song. That and Iron Man. Just because it's so easy to play. Oh, you got to see Clapton play. Nice. Wizard. Cool. Besides Elvis with your mom, Queen was your first concert. Nice. Pamby says. Yeah, rock and roll. I grew up with, my parents had tons of 45s, like tons, and albums, right? And then I have all my siblings are older, so we just had hundreds and hundreds of 45s. And then my dad passed away, and I'm pretty sure my mom gave those to somebody. I know I didn't get them, but I hope she gave them to somebody. Anyway, I have to research that. Hell Rider, 8th grade football championship song was "We Are the Champions." That Hell Rider, that, and probably 1,000 other bands as well, or teams as well. Grampy, all mods, I love you all and appreciate you. We love you as well. Gordon Lightfoot, he's a great artist. Chicago's fantastic. I have a couple of their first couple albums. Chicago's fantastic. 25 or 624. Terry Kath is a fantastic guitarist. Jimi Hendrix said Terry Kath was a better guitarist than him. And I'm not 100% sure I would agree with that statement, but if Jimmy's saying that Terry is a better guitarist than him, I'm not going to argue. But Terry Kath is a fantastic guitar player, no question about it. Joe By, yeah, Mick Taylor, he's definitely up there. Had some tears when I saw him on Stone's 50th tour. Yeah, the when they unveiled Mick, what was that? Hyde Park, 1969. That's some amazing amazing concert footage there. Kimbers, you adore Chicago. You could see Queen with Adam Lambert. Okay, he makes fantastic alternate. All right. Richard has seen America, Chicago, Boston, and Taylor Swift for your daughter, not me. Oh, come on, Richard. You're a closet Swiftie. Your truth is out. Richard, your truth is out. You are a closet Swiftie. That's funny. Seashell loves Chicago. Hellrider, Chicago is a great band. Sharon, Jethro Tull was your first concert. Nice. AC/DC used to play at your local dance hall. Oh, that's so awesome. Joanne, my brother and his wife had a chance to go to Australia this past year. Last year. And they sent photos of like the murals of AC/DC. I think that's really cool. Downey Lynn, Chicago was at the Iowa State Fair in '74. Nice. Uh-oh. Grampy, you did something wrong? I don't see the gifts. I don't know, Grampy. I'm not on that end. I'm sorry. I don't know what to tell you. I don't know. I'm sorry. Green Eyed Cat, you saw Santana. Yeah, Santana, absolutely. He's fantastic. Fantastic guitar player. I came upon Santana at Woodstock, of course. I wasn't there because I was born, 10 years ago. But that performance at Woodstock is just phenomenal. So this floofy tail belongs to Houdini. That was Houdini. Oh, Paul Revere and the Raiders. That's a good one. That's a good first concert. That's a good one. All you Swifties stand up, right? Nan just screams the Doors. The Doors. I went through a huge Doors phase, and I still love the Doors. I'm still a big Doors fan. But when I was like 15, 16, 17, 18, I could not get enough of the Doors for sure. Lulu says your brother's favorite guitarist was Steve Howe. Downey says Chicago came to Des Moines right before COVID. Joanne, freaking awesome. Yeah, I'll find some pictures that he sent, and I'll pull those up for you. Ruth Ann, welcome back in. Paula, you are a 70-year-old Swiftie. Pammy, bucket list concerts are all the OGs before we all die off. I saw Buddy. I've seen Buddy Guy like 5 times, right? And I've seen him in all different scenarios. I've seen him like up close and personal. I've seen him in big concerts. I've seen him, midway, mid shows. And he did a tiny desk, right? NPR does these tiny desks, and I watched that the other day, and I was like, he still has it, and I saw B.B. King before, and he was in like a wheelchair, and it's like, I love seeing these guys play until the day they die. It's if you get a chance, go see them. It's not like they were in their heyday, of course, even 20 years ago, but if you get a chance, definitely go see them. Go see whoever you can, whenever you can, because we're not going to be around. They're not going to be around forever. That's for sure. Stand for the Truth, you were a ZZ Top groupie. Did you travel with them? Jadzia Dax, now which version of Fleetwood Mac? Peter Green version? Peter Green version? I would have liked to have seen Peter Green version personally. That's my own personal opinion. I would have loved to have seen Fleetwood Mac. Nothing against, Rumors and Christy McVie but Peter Green, I would have loved to have seen Peter Green version. Seashell, best concert, Fleetwood Mac, Moody Blues, and you just saw Def Leppard? Yeah, I saw the Moody Blues. I saw them well past their I don't want to say prime because they were still great, but it was well past their heyday, I should say. I saw them. It was the Monkees. The Monkees did a reunion tour or something like that, and the Moody Blues either opened for them. I think the Moody Blues opened for the Monkees. This would have been like, God, it was with my brother. I think it was like 83 or 4 or something like that, 85. I was glad that I saw the Moody Blues. I was really glad that I saw them. You saw Ted Nugent? Yeah, I am sure. I'm sure. Did he come in on his motorcycle? Was that when he was doing it? He would come in on his motorcycle or something? Was that then? Stevie Nicks is still touring. Doesn't surprise me. ELO, yeah, that's some good music too. Oh, Grampy, you're going to go see The Lion King? Very cool. I saw that in New York. I saw that in New York City on Broadway. That was a really, really fun, very immersive. Very immersive. I won't give any spoilers, but very immersive. That's all I'll say. Very, very fun. Justin Hayward is still touring. He still has chops. He still has the voice. I find that a lot of singers, their voices go as they get older, so it's always hard to hit those high notes. So if he can still hit those high notes, then yeah. Hey, we're the Monkees. Oh, you saw the Police with the Specials. That's cool. That would have been a fun show. Leonard Skinner, I'm sure that was a good one too. Green Eye Cat. Best one you ever saw was Elvis Costello. Nice. He played at least an extra hour in the encore. Very cool. Lulu, you saw the Moody Blues in the 70s, 80s, 90s, and 2000s. Nice. Yeah, I would have loved to have seen them in like 68, 69. I think that would have been fun. Wizard said best concert ever was David Bowie. I never saw Bowie, but I saw Iggy Pop 3 times. I saw Iggy Pop once in a small venue, and it was unannounced, which was phenomenal. Then I saw him at a somewhat smaller venue, maybe 1,000 people, and I was like, three rows back from the stage. And then I saw him. That was in Cleveland. Then I saw him in New York. That was the largest venue I saw him. Was in New York City. It was outdoor. It was an outdoor venue, and that was from what I remember, that was a great show. Jennifer, what are we waiting for? Judge is coming back with some rulings. Judge is coming back with some rulings. You always want to see Joplin and Dylan, yeah. Oh, for sure. I would have seen. Oh, I did see Bob. Yeah, I saw Bob again in New York, Jones Theater, which is out on the island. I saw the Alarm opened up for Bob Dylan, and the guys I was with, they were really into the Alarm, and the Alarm was great. I love the Alarm, but they didn't want to stick around for Bob Dylan. I'm like, I'm sticking around for Bob Dylan, so I hung out for Bob Dylan, and we jumped the we had seats way in the back, and so we jumped the railing to get up closer, and 2 of my buddies got caught, and I just kept running, so I made it up to the stage. So I just stayed there, and I was like literally like looking up, and G.E. Smith, that's when G.E. Smith was his guitar player. If you guys remember G.E. Smith, he played on Saturday Night Live. He was the house band. He was the music director, blonde hair guy, phenomenal guitar player. If you guys don't know who G.E. Smith is, do yourself a favor and check him out. So anyway, yeah, so I saw Dylan with G.E. Smith and the Alarm. All right, what else? C. Gilmer, The Cars. Never saw The Cars, but I have a, hold on a sec. I have a, hold on. Is Pauline coming in? I have a Rick Ocasek, Paulina story. I was walking home one night, and they were sitting at this local restaurant, and I locked eyes with Paulina. And I was like, I don't know, 25, 26. And I locked eyes with her, and then I looked over, and Rick was sitting there next to her. I'm like, oh, dang it. She's with somebody. Kinks would be good. That would be a good show. Never saw them. Neil Diamond. nothing wrong with Neil Diamond. Neil Diamond had some great songs. Neil Diamond had some great songs. Dreamhorse, you saw the Beatles in Indianapolis? All right. I am officially jealous. I would have loved to sing the Beatles. So you saw Ringo Starr and then Paul McCartney. I did. It was like my little moment of fame. Walking around New York City, you guys just have to, it's like probably walking around London or, Paris. I don't know. Certain cities obviously attract certain celebrities. I walked past Joey Ramone. I nearly passed out when I walked past him. David Byrne. I'd see David Byrne riding his bicycle around the city. And it wasn't a big deal. You're just like, oh, okay, whatever. And then if you told your friends that, they're like, yeah, so I just saw, blah. So it wasn't a big deal. But looking back on it, I'm glad that I had those experiences. Lily Wayne, you saw the Beatles in Toronto? Nice. Pam, you saw the Stones with the Fabulous Thunderbirds? I saw the Stones in, it was Jersey, it was the Meadowlands, whatever Giant Stadium is, where the Jets used to play. I forget what it's called right now. It's a big, 80,000 seat football stadium. And Hootie and the Blowfish opened up for them. And they got booed. They didn't get booed off stage, but Hootie and the Blowfish opened up for them, and it was the Steel Wheels tour. What was that? 88, 89, I think 89 maybe, 89, something like that. And Hootie and the Blowfish opened up for them, and they got booed. Oops. And the only other band I saw get booed off stage was the Cult. They opened up for Metallica. And Metallica fans did not want to hear the Cult. I was there to see the Cult, but I hung out for Metallica, and I'm glad I did because that was a great show. But the Cult literally got booed off stage. They played like 2 songs, and people were like booing them, and they're like, all right, they're like, F you guys, and they took off. And they took off. They literally played like 2 or 3 songs, and that was it. Jenny, you saw Bob Seger at Jones Beach? Yeah, I've seen The Cure there. I saw Dylan and The Alarm. Who else have I seen there? Well, you're making me think now. Those are The Cure, Dylan, and The Alarm. I know maybe that's it. Maybe I've only yeah. Wizard, you love the Cult and Metallica, but not together. Hey, Metallica asked them to be on tour, and the Cult said yes. So that would have been 88, I think, right? Yeah, that would have been 87. No, it would have been 88. It was in 88 when I saw that. Yeah, I was a huge Cult fan. Downey, you collected some ticket stubs. I wish I had my ticket stubs. Man, I so wish I had my ticket. I kept every ticket stub I had for this very reason, because I wanted to look back when I was in my and be like, oh yeah, remember that. I wish they got lost. A lot of things got lost in the move, so. Cross Amnesia, Cinderella, yep, and Faster Pussycat, yep. Cinderella, I think, had, who was that guitarist, the blonde guitarist who would throw his guitar around and it would spin around? I think that was Cinderella. I don't remember that guitarist's name. Yeah, I'm pretty sure that was the guitarist had white hair or whatever, and he would take his guitar and throw it, and it would spin around his body. Nana, your first concert was Elvis, but your favorites were Chicago with REO Speedwagon, Leonard Skinner, Seeger, 38 Special, wow, Nugent, and Frampton. Frampton was a party pooper. He was threatening to walk off. Huh. That's a huge lineup. That's a huge lineup. Lulu, you have Genesis tickets for the Lamb Tour. Wow, $5.50. Yeah, can you imagine seeing Genesis? Peter Gabriel for $5.50. That's crazy. You see Faster Pussycat in clubs? Nice. You saw Dylan in 75? That's a good one. Yeah, I saw him, I think it was 88. It's 88 or 89. I think it was 88. I'm going to go with 88. Cross examnesia. Your son loves Oasis. We don't agree. You remember the Monkeys and the Cowsills, Richard? Nothing wrong with that. Grampy, being from Motown, our parents took us to our first concert. We were teenagers. We saw Diana Ross. Nice. Was that with Supremes or was that on her own? Had she broken off from the Supremes yet? That would have been a great show. I would love to see the Supremes. Are you kidding? Would love to see the Supremes. Hellrider, you want to see the Stones? Well, they're still out there, right? Aren't they still touring? Such as it is, without Bill Wyman and Charlie. Didn't Mick say that he would stop? He said if he, Keith, or Charlie died, that was it, that they would stop touring. But they're still touring. Or are they still touring? I don't know. Joe, the most energy at a concert was Volbeat in Chicago at the Riviera, but Daddy Yankee at Allstate was amazing too. Completely different venues and genres. I don't know either of them. Joe, you got me on those two bands. I don't know any of those guys. I don't know those names. John Mellencamp used to play your radio station when he was John Cougar. Interesting. CSNY, Crosby, Stills, Nash and Young, Linda Wint. Richard loves everything Motown. Yeah, I mean, Berry Gordy, that's some great stuff. Same with Stax. Don't forget Stax. Stax was, So Stones did tour, so they're still touring even after Charlie passed. So, Mick, you lied. You said that you would stop touring after Charlie, Keith, or you died, but you're still touring. Downey, yeah, I saw you two. I saw them at college, and it was like maybe, it was like 50. There's about 15,000 people. It was good. That was in. When would that have been? 85, 6, somewhere in there. Yeah, that was a good show. I saw Roger Waters too around that time. He was doing the pros and cons of hitchhiking. That's as close as I've gotten to seeing Pink Floyd. Was Roger Waters. Hellrider, I forgot I saw YouTube when they first came out. He pulled a dude from the crowd to play guitar. Nice. Nice. You saw Devo. Did you see him in? Did you see them in Akron area, which is where they're from, or did you see them elsewhere? Grampy. Oh, it was when she went solo. All right, cool. Rock and roll. You've seen the Stones 4 times. Pink Floyd 4 times. Now, have you seen the full lineup of Floyd, or was it were they splintered? Was it after Roger left? Grampy, thank you for the 10 Trial TV Live gifted memberships. Awesome. Come on down, you guys. Please join the fun. We're talking music right now. You saw Floyd twice. Now, again, is that with Roger Waters? Was that with the full lineup? My brother saw them on the Animals tour, so that was 77. So he saw them on the Animals tour. He said a giant pig goes flying over. It was a stadium concert, and he said a giant pig comes flying over, and that kind of started the show. It was all before Roger left. Okay, all right, very good. Skrubnik, we're just waiting for the judge to come back. He was supposed to come back at quarter after, but here we are. It's 5:30. He's making rulings on jury instructions, so that's what we're waiting for. You saw Aerosmith in Hawaii. Wow, I try not to have regrets when it comes to music, but I have one regret. I missed Guns N' Roses opening up for Aerosmith in '88, and I regret that. I really wish I had seen that. I think that would have been I know that was a fantastic show. So yeah, that was just as Guns N' Roses were hitting, and Aerosmith was going through their revival. JMS, the second time you saw Ringo Starr, Todd Rundgren, and John Entwistle with him, that would have been good. Yeah, that would have been fun. Trial TV Live has seen the Black Crowes 3 times. Muddy Waters would be a good, yeah, he would have been a fantastic one. I never saw Muddy Waters. I've seen John Lee Hooker, I've seen B.B. King, I've seen Coco Taylor, I've seen John Mayall, if you want to put him in that category, which I would like to. Seen Buddy Guy. I've seen Albert Collins. Yeah, I've seen Albert Collins, not Albert King. I would have loved to have seen Albert King. I missed Albert King. Yeah, Billy Idol, I saw him on his 84 tour, 83 tour, the Rebel Yell tour. I saw that. And who was that? Prince's guitar player opened for him. That was a great, great show. What was his name? I always forget this guy's name. And Jesse, I think, was his name. What was his name? Is it Jesse Johnson? Was that his name? I guess that was his name, Jesse Johnson. Yeah. So I guess that was his name. He co-wrote Jungle Love. So yeah, so he opened up for Billy Idol on his Rebel Yell tour. Elvis's last concert was in Des Moines. Richard says there's a new movie coming out in April about Michael Jackson. Interesting. All right. Yes, Aaron loves the Maiden, loves Iron Maiden. All right, so you saw Cross-Examnesia saw an Eddie malfunction. He wouldn't stop headbanging. That's funny. C. Gilmore, the Guess Who and the Who. So you saw both Guess Who and the Who. Nana saw Elvis in Chicago. Mrs. Baba Yaga, you and your Blackberry Brandy saw Zeppelin at the Fabulous Forum in the mid-'70s. Nice. Skrubnik, you're a punk rock girl yourself. Well, what bands have you seen? Tell us who you've seen. I've seen Black Flag. I've seen Flipper. Let's see, who else? Jeffrey Lee Pierce. Let's see, who else? Who have you seen? I saw Black Flag in 83, 82, I think, 82 or 83. Rock and roll, you saw the Who in San Diego. I saw Patti Smith. That was a good show. If you want it, well, would we consider Patti Smith punk rock? I have seen Joey Ramone. DOA. If somebody tells me they saw the Sex Pistols, I'll and be truthful about it. I'll give you a high five. Laura, you used to tour with Motley Crue, Poison, Dokken, and Skid Row. In what capacity? Please tell us. What capacity? Please tell us what capacity. Andy says, I listened to Iron Maiden yesterday. Son got in the car as needed a ride to get his from repair. Started the car, volume scared both of us, but didn't know 62-year-old mom listened to them. I know, right? It's funny. That's funny. Lily Wayne, you saw Lion King, Phantom of the Opera, and The Sound of Music in Toronto. Yes, of course, we can get into the debate, Skrubnik. Of course. Yes, we can get into that debate. What is punk rock versus post-punk? Yep. But yes, Black Flag. Didn't see Front 242. Seen The Cure. Have not seen The Furs. Have seen Echo and the Bunnymen. I saw Echo and the Bunnymen, and Ray Manzarek came out and played, because he produced one of their albums, that album that I saw them on that tour, and Ray Manzarek came out. That was a highlight. I thought that was pretty cool. Hellrider, you were security for the Amigos. That's pretty cool. That must have been interesting. That must have been interesting. Ola loves The Cure. Tower of Power, absolutely. Oh, I love Tower of Power, for sure. Absolutely. Joe By, palest group of guys on one stage. 1, 2, 3, 4. That would be Dee Dee. Dee Dee was the king of 1, 2, 3, 4. C. Gilmore, you saw Echo as well? It's Edgar, yeah, Edgar Winter. Yeah, Frankenstein, right? His big hit was Frankenstein. Hellrider, you met Kenny Rogers. Nice. Colleen, welcome in. Listening like usual. Say a prayer for one of the wild turkeys that lives here. It's trying to get... okay. Oh, well, I'm sorry to hear that. I hope that that works out. I hope that works out. Lazy Boys, you saw Lion King on Broadway, right? It was, do you remember the opening? I don't want to give spoilers or anything, but that opening I thought was pretty cool. And just the whole show actually I thought was very immersive. Okay, so Grandpa, you did see it on Broadway. Okay, I gotcha, yeah. So now you're going to go, you're going to see the touring. I gotcha. Hey, Irene, hello, welcome. Austin, Texas. Speaking of good music, speaking of music, you have some good music there. Do you ever go to South by Southwest? Have you ever had a chance to go to South by Southwest? Donna, Black Oak, Arkansas. Skrubnik, okay, then you've seen Stevie Nicks, Fleetwood Mac, John Fogerty, but your first concert was Grace Slick in 1981. B-52s, that would be a fun. I never saw the 52s. Oh, Judge is coming back. All right, time to get serious. I see Judge coming back. Here we go.
Okay. Mr. Burmester, do we need to wait for Mr. Bloodworth?
No, Your Honor.
All right. Let's, Ms. Nestor, go back to your submission this morning. We'll use that as a list here. First, with respect to defendant's request for an instruction or addition of an additional section to the witness credibility instruction regarding Detective O'Driscoll having had an opportunity to listen to all the prior testimony, and that instructing the jury that they may consider whether that opportunity to hear prior testimony enabled him to tailor his account when determining his credibility. The court has re-reviewed Portuondo versus Agard, 529 U.S. 61, U.S. Supreme Court from 2000. That case stands for the proposition that it is not improper for defense counsel to make that exact argument during its closing. But it does not stand for the proposition that it's appropriate for the court to give that instruction as if it is a precept of law. So the defendant's request for a jury instruction to that effect is respectfully denied, notwithstanding the fact that you'll be free to make that argument. Anything further?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. Then let's look at the first 2 pages of the additional instructions that I sent out. Page 1 is a proposed instruction called informant. It comes from the 10th Circuit pattern instructions. page 2 is a instruction titled immunity. It comes from the 10th Circuit pattern instructions. I propose that we use these 2 pages in this form, which are not specific to any individual, and use the pronoun they.
No objection.
In place of Muji's second CR 415, which is the custody informant. Mr. Burmester.
The state objects to number 1, informant, because there were no informants in this case.
Well, tell me why Carmen Lauber doesn't fit squarely within the first sentence of this instruction.
The reason she is providing evidence, arguably, for a defense might argue, is because she was given immunity, which is why I don't object to number 2.
Didn't she also indicate in her interviews, though, that she was doing it based upon her sense of personal accountability for having been involved in this situation?
Yes, but that doesn't make her an informant. She testified, both she and Crozier testified to the events they saw. Frequently, in many prosecutions, the government has to make a choice of who to charge and what to charge. And sometimes in order to proceed on one prosecution, you got to give up another one. And that's what we have here, is in order to bring to bear what the government saw as the more serious crime, that is what the state believes is a murder, we had to have those eyewitnesses be able to testify. In order to do that, we had to provide them immunity. I don't think that makes them a fortiori an informant.
Draw the distinction for me. What would you see the informant as being?
I believe an informant is someone who is privy to some statements or some other source that's not directly involved in the crime. So, a cellie who overhears something that a witness or the suspect say. They don't know anything about the case other than what they've heard somebody say in the jail or at a drug deal or whatever. So and I think that recent experience over the last decade or so, I think the courts were very concerned with that type of testimony for obvious reasons.
Let me spin a hypothetical here related to the facts of this case, but not from the facts of this case, to make sure I understand your position. So it sounds like if somebody heard Kouri, or somebody came to law enforcement and said, I have information that might be relevant to the Kouri Richins case, but if I give it to you, I need a break on my probation. And they work out some kind of deal. And then they relate that Kouri Richins, once upon a time in January 2022, asked me for fentanyl. And I'm willing to testify to that effect. But if I do that, is that the kind of situation you're referring to?
If we alter that just a little bit, the defendant, whoever it is, told me something, that they killed somebody or they shot the gun or whatever. That, I think, is different. That's not a witness to the crime. I think if the witness had said the defendant said they bought drugs, fine. But if the witness is witnessing the event, I think that makes them, that's the distinction that I would draw.
Okay. I understand your position. Ms. Nestor.
We have no objection to the new informant instruction.
or to the making the immunity instruction just general, we're fine with both of them.
Tell me why you believe an informant instruction is necessary, though. There's no dispute regarding page 2, so we don't need to talk more about that. Mr. Burmester is taking the position that as a matter of law, it's inappropriate to give an informant instruction because, if I understand him correctly, Ms. Lauber and Ms. Crozier, in his estimation, simply do not qualify as informants. Tell me why you believe they do.
The reason, well, I think they're clearly informants. I don't understand the distinction he's making at all. There are people that gave information and got a deal out of it, whether... I just have never seen that distinction made in the past, so I'm not sure I understand his distinction. But the reason I think you need both is because the immunity instruction only deals with the motivation of the grant of immunity. The informant instruction deals with other motivations, such as to get out of drug court, to be able to send texts to Mr. Maynard instead of having to get, urine tests, to make herself feel better because she feels guilty. All of that is not covered by. Those are all benefits to her from providing information that can cause a reason to be suspicious. So I think they're both necessary. That's all.
I understand your position. May I ask a different question? I don't understand the relationship between the first sentence and the last sentence of these two instructions. They seem internally inconsistent. Now, mind you, they are the pattern instructions, and so presumably some committee of 10th Circuit lawyers has come to grips with this, but
that is the last sentence is dealing with the scenario where they find no other reason to find guilt other than this person's testimony.
But isn't that exactly what the second sentence in the first paragraph is talking about?
Yes.
It can be. Oh, I see what you're saying. The second sentence. I was looking at the last sentence. I'm sorry. The testimony of an informant alone. Well, if you believe it beyond a reasonable doubt. That's what they're saying. They're saying that you can't, if there's no other reason for you to find her guilty other than this person's testimony, you need to believe it beyond a reasonable doubt.
Okay.
And that's why that's there.
So you'd acknowledge that you wouldn't be able to say, well, you can't convict based upon Carmen Lauber's testimony alone.
No, they certainly can.
You'd have to add some language to that statement.
Correct. Absolutely.
Okay. All right.
Absolutely.
Anything further, Ms. Nestor?
No, sir.
Okay. All right. Counsel, with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled informant that comes from the 10th Circuit pattern jury instructions that is indicated on page 1. In addition to the pattern jury instruction from the 10th Circuit titled immunity, which is on page 2 here, based on that ruling, the court will not be giving any version of model Utah jury instruction CR 415. Mr. Burmester, any further record there?
No, Your Honor.
Okay. Then, if you would please turn to page 3. This is a revised other acts instruction. 2 questions. First, in the bulleted list, do we want to add any mention of the defendant may have been involved in civil litigation that she referred to as charges? Or do you want to just leave it alone? Ms. Nestor.
No, I think you cured that when it happened, and I think bringing it up now would just bring unnecessary attention to it.
Okay. Any objection to that, Mr. Burmester?
No.
All right. And then, Mr. Burmester, if you'd look at the 1 to 3rd paragraph, I've added some, though not all, of the alternative purposes from Rule 404B. I've added the ones that I think have at least minimal factual foundation in this evidentiary record. Any objections, sir?
No, that was our request.
Okay. Ms. Nestor, any further record there?
No, Your Honor.
Okay. Very good. Okay, turn to page 4. This is the aggravated murder instruction. I collapsed. Oh, I got to change the numbering. I'm sorry. This is why we go through these things together. All right. Bear with me for a moment. The elements are 1, Kouri Richins. 2, intentionally or knowingly cause the death of Eric Richins. I collapsed that for a reason you'll see in a moment when we get to the attempted instruction.
Okay.
3, under one or more of the following circumstances. And then in the second to last paragraph, instead of element 4, it'll say element 3. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
Nothing additional, Your Honor.
Okay. Then if you turn the page, I needed to put the modifier attempted to before intentionally or knowingly cause the death of Eric Richins to make it clear, Ms. Nestor, that you don't have to intentionally or knowingly attempt. You have to attempt to cause.
Yes.
Okay.
I believe that's right.
And so that's why we switched those around.
That's better.
Any objection, Mr. Burmester?
No, Your Honor.
Okay.
There's italics on the last couple paragraphs. Is that for a purpose or?
It was supposed to be beyond. No, that is something I just need to edit to match the original. I know what you're going to say. Say circumstance or circumstance is on page 5.
Also, I just caught by looking at that on page 4, the one before, it should say listed in element 3.
Correct. I made that.
Did you catch that?
I did.
Okay, perfect.
Thank you.
Yep.
All right. If you would turn to page 6.
Okay.
Elements of insurance fraud, count 3. Ms. Nestor, I understand defendant's argument. Based upon the plain language of the statute under which count 3 is charged, I think elements 1, 2, 3, and 4 are correct as a matter of law as applied to the evidentiary record in this case. Defendant's request for additional elements language is respectfully denied. Any further record there?
No.
But I think it is important to instruct the jury explicitly about what act the state alleges or believes Kouri Richins performed or committed to commit this crime. This is a starting point, a proposal. I'm not the state's lawyer. I just put something in there to get the conversation started.
So I'll let them talk first because I'm interested to hear what they say.
Other than Richens
got it.
spelling, I think that's what we're going to argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit who's listening in because she'll be doing the closing, but I am unclear why submitting the application or making the claim or receiving the money is fraudulent.
Because in the state's theory, and what I understand they are intending to prove beyond a reasonable doubt, is that the application was fraudulent and therefore was void ab initio.
Because of the forged name?
Because of the forged signature from Eric Richins.
So in other words, the crime is getting someone some life insurance they didn't want because they both applied. She applied for herself and him.
Well, I think what the state's going to show is that she submitted an application that she forged the decedent's signature, listed herself as the beneficiary after he died, as submitted for the took the claim. Now, count 5 is the signing, right?
Right.
Count 3 is the devising of the scheme to get the money by signing, submitting, making the claim.
So my concern...
Do I have that right, Mr. Permister?
Yeah, sure. It's just like frequently there is when you have a forgery, there's a corresponding count, like a theft or theft by deception, whatever.
So the only issue I have, I have some issues with that, but the testimony of the True Stage lady, I'm so sorry I cannot remember her name. I don't mean to be disrespectful. I just cannot remember her name at the moment. Maybe Coates. It might have been Ms. Coates. I'm not positive.
It's Ann Coates.
Okay, good. Ms. Coates. Was that they did not ever investigate or follow up. When they would get an application, they didn't call the person and say, is this your signature? Is this okay with you? That was not something that mattered to them. So we know that Kouri had a right to apply for the policy for herself, clearly, which she did on that policy. She applied for both of them. It was in both their name, like each other is the beneficiary. So they each were getting a policy.
Right.
So
I'm saying right. When I say right, I'm saying I understand what you're saying.
Yeah,
I'm not making a finding.
Correct. So I don't understand how, if the claim on the death is based on a death that actually happened, and it's a policy they agreed to approve. Once they approved the policy, they approved it. So whether or not...
But I think the state's theory is there was a threshold intentional misrepresentation in the beginning. That is that Eric Richens signed this with the intent that Kouri Richins would be a beneficiary on this policy. And the state's theory is that simply just never happened.
You can purchase insurance and put yourself as a beneficiary on behalf of someone. Like, I could right now get life insurance on my husband where I'm the beneficiary.
Yeah, but you can't forge his signature on it.
Well, if she had authority to sign his signature.
But that's a big if. That's in factual dispute in this case. We're just talking about legal elements here. Sounds like this will figure prominently in defendant's closing argument.
Yeah, I guess so. Okay.
Mr. Burmester, besides the spelling error,
Wait, before we go on, can I just get a clarification? So I can argue. I'm just concerned that if this language is in this instruction, that I'm not going to be able to get up there and argue. This may be their theory, but we don't think any of this is a crime.
You can say exactly that.
Okay, just making sure.
You can say the state had this theory and didn't prove any of it.
Okay. And it does start with the state's theory.
Right.
I just feel like you're telling them in an instruction that that's a crime. That's what's bothering me, right? It's like it sounds like the judge is telling them this is a crime.
No, well, I think this is, in my mind, and you tell me if there's a more artful way to do it in your view. There are times in sexual assault cases, for example, where multiple touchings happen of different body parts, and you've got to be real specific in the counts. The state's theory regarding count 2 is touching of this body part on this day. The state's theory regarding count 3 is touching of this body part on that day to prevent any ambiguity regarding unanimity. Here, we're doing it for a different purpose, but we're providing specificity regarding the state's theory so that it's clear the state is asserting that she did something other than think.
Well, can we put what our theory is? I mean, I just don't...
But you don't have any burden.
No, but we are entitled to theory of defense instructions. I mean, if you're going to put their theory in, I just think adding that part on the bottom is problematic for a lot of reasons. I think just like with all the other instructions, they can stand up and say what they think meets these 4 elements any way they want. But if it comes from you, it's like you're saying this is sufficient.
I can take it out if you want.
That's what I would like.
Okay.
Okay, perfect.
Mr. Burmester, any objection?
No.
Okay. I imagine they're going to hear the same thing or something similar in closing, so we'll end up in the same place.
Except now we're back in the position where they could convict her for just a thought.
Well, we were probably in that position by virtue of the Utah legislature when we walked in here today, so I don't know that we're going to fix that in this case.
I mean, there's evidence that whether they believe it or not is another question, but there's evidence that Kouri Richins filled out an application for insurance, submitted it to the insurance company, and they eventually paid it out.
I don't disagree.
So
whether it rises to the level of a showing beyond a reasonable doubt of the elements of this crime, the jury will determine.
Absolutely. And I think the only thing that did to help, I mean, because we're not arguing that a bad thought came into her head. That won't be argued. But it does help us distinguish unanimity between 3 and 4. That's the one.
Well, I think also the dates.
The dates are different. Yeah. Absolutely.
But what if we did this?
Yeah.
Just to create an actus reus, because I don't think one exists in this instruction. What if it says intentionally, knowingly, or recklessly devised and enacted a scheme or artifice?
You got to talk to Mr. Burmester about that. I can't unilaterally add an element that doesn't exist in the statute.
Oh, I see what you're saying.
Now, you can stipulate to that if you want to create some appellate insurance, but I also take Mr. Burmester's point seriously, and I'm not a appellate or constitutional litigator, but given the evidentiary foundation and the arguments that would be made at closing, I'm not sure we actually have a constitutional problem here.
Okay, well, I guess I would just have a general objection that there's no actus reus in this instruction, but I think the bottom paragraph adds more problems than it creates, and I would ask that be stricken, but I understand. I guess what he's saying is, don't worry, I'm going to argue it correctly, even though it's not written correctly on this instruction.
Or I think what he's saying is, even if the statute is somehow defective for not having an actus reus defined,
right,
the evidentiary foundation in the state's closing argument will make it clear that they are alleging that there were multiple acts committed here.
Okay.
Is that fairly stated, Mr.
Yes. We are definitely not making the argument that somehow the instruction is improper or unlawful.
Okay. Okay. And then, anything else on count 3, Ms. Nestor?
No, sir.
Mr. Burmester?
No.
All right. And then count 5 is just the skinny down version of element 4.
Did we skip? Because on count 4,
I didn't make any changes.
You left it the same. Got it.
There were no objections to count 4.
Wait. I thought count 4 was the one.
Did I miss some? I apologize.
Yeah.
Let me take a look.
Let me check.
I don't have any handwriting on count 4.
Just a moment. Okay, let's see. There's 1. Just a sec. 2.
Mine is clean as well.
1 and 2. Just a moment, Your Honor. I'm so sorry. Count 4 was the one about the fees. Wasn't that count 4? Or was that count 3?
Count 3 was the language from the statute regarding fees for services.
You're right, then no, there was nothing on 4. I apologize, Your Honor.
Okay. Take a look at count 5 for me. Let me know if you have any concerns.
Not from the defense.
Yep, no objections.
Okay, great. All right. I think that before we get to spoliation, Ms. Nestor, my apologies. Did I hand out the special verdict forms? Did I bring them with me?
The amended ones? I don't think we have amended ones.
My apologies. I'll be right back.
No worries.
All right.
Judge forgot to bring something in, so he's running back to his chambers to get something real quick. So no changes to count 4. They are going to get. He's going to give an appropriate. Oh, excuse me. He's going to give an appropriate title informant to Carmen and Robert Crozier. Let's see. He's going to. Let's see. They're just going through the counts right now. So there's 5 counts. 1 for aggravated, 1 for attempted, 2 counts for insurance fraud, and then 1 for forgery. So there were no changes to count 4, which I would assume is one of the insurance frauds. I'm not 100% sure how it's breaking down. I'm sorry, count 5 is the forgery. 1, 2, 3, 4, 5. Okay, yeah, count 5 is the forgery. So counts 1 is aggravated, count 2 is attempted aggravated, counts 3 and 4 would be the insurance fraud, and then count 5 is going to be the true stage forgery application, true stage application forgery. So, and again, we'll hear all of this on Monday. They're going to go through, they're going to break it down. Well, they're going to go through and they're going to read the entire thing on Monday. So, hello, Super Bowl. So there's only 5 counts. Jury instructions should not be that long, right? Jury instructions should not be that long. Maybe half an hour, tops. I can see them definitely deliberating by Monday after lunch, especially if they get started on time. If they get started at 8:30. Here he's back. No, he's not. Anyway, I could see them 8:30 to 9:30, 10. Take a break, 10:30, come back in. Yeah, I can see them starting to deliberate after lunch.
Bridget, can we go back on the record, please? Counsel, we're back on the record. I've just handed you a revised version of the verdict form. Yeah. If you would just read through it and make sure I didn't miss anything.
No objections.
No objections.
Very good. Okay. Ms. Nestor, I have a list of practical things I need to talk about, but did you want to talk any more about spoliation sitting here today?
Yes.
Go ahead.
Thank you. Your Honor, may I remain seated?
Yes.
Thank you. So The court has heard in the trial that the night or the early morning that Eric Richins was discovered deceased in the bed, there was a long expired pill bottle directly next to him on the nightstand. The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1,000% positive of that, but I think that's what the exhibit number is. If you look at the picture, you can see there is detritus, or whatever the word is, residue. I'll use an easier word. Residue, dust at the bottom of the pill bottle. There was video or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand, and then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1,000% sure about that either, but one of the officers with gloves on holding the pill bottle took a photograph of it. That pill bottle, there was testimony, was sent with the body to the...
In the body bag, right?
I believe so.
To the office of the medical examiner?
I believe that is correct. And that it was delivered to the medical examiner's office. The final witness of the trial, Officer O'Driscoll, was asked if they were able to, or still had the pill bottle, and his answer was that they no longer had the pill bottle.
I don't think that
Detective O'Driscoll say that?
No, it was objected to because it was hearsay.
I don't know whether he knows whether they still have the bottle.
No, he doesn't know.
Right.
But he said that he doesn't have. They don't. Like the Summit County sheriffs don't have it.
Correct.
Right.
Yeah.
So I don't know if he knows what happened to it at the medical examiner's office or not.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No.
Not that bottle, no.
Okay.
No.
Meaning no affirmative evidence, or they don't have that bottle?
No affirmative evidence of this bottle being present or not present.
That's my recollection. I have not rewatched every day of that testimony from the medical examiner.
Well, I do know that the young woman, and I apologize, I cannot remember her name either. I'm just blanking right now.
Dr. Ulmer?
No. The lady
Gibson?
who checked in the body that had the tag, the red tag on it.
Right.
She testified that what happens is when they open the body bag, that there are their personal effects and the prescriptions that were on scene for purposes of their giving them ideas what to test for, I guess, when they do the toxicology. I assume that's why that's done. I don't know for sure. So I know that she did. My recollection is that she testified it arrived at their office with his personal items. I don't know that we've ever had any testimony to why it was lost or destroyed or what happened to it. But it's gone because it would have been here if it wasn't. So,
let's come back to spoliation, right? Okay. You have to first show a violation or that a duty to preserve existed.
Exactly.
Then you have to show a violation.
Right.
Then you have to show prejudice.
Right.
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body. So who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is in the record.
Well, we can do affidavits as to that.
The evidentiary record for trial is closed.
No, for your evaluation purpose, it's not, I don't think your finding is based on what happened in trial.
No, but
because all the time on
the evidence is closed. Closings are happening Monday. To the extent you were a party, wanted to make an additional evidentiary showing and have the court make findings sufficient to support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional,
Right.
and what the prejudice is. That time was months and months ago.
No, I disagree with that. So, I mean, we could, like, even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing that.
This is not bad.
No, we're not doing that. But I'm saying that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing. It was gone. So we've never had the opportunity to test it, submit it to a expert, or have it or use it at all, right? So it's missing. There's no question there's a duty to preserve it. I mean, they thought it was important enough to take a picture of it. It was next to the body. There's clearly a duty to preserve. We do not have, and I will concede it up front, we certainly don't have any evidence that suggests they intentionally destroyed it. I mean, we've just not come across that in any way. But there's definitely going to be some gross negligence here if the main container of potentially illicit drugs, of someone who was found dead of illicit drugs, is lost and made not able for us to recover under Rule 16.
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but keep going.
Not right next to the body, there weren't. And, you know, there was an unknown dust on the nightstand right where the pill bottle was. Could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy in how to handle that, right? Like, one option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved, and because of that, you know, you should assume that it would have been helpful to the defendant. That's the adverse inference instruction under Cronish versus U.S. So, I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office kept it long enough for the investigators to get custody of it. It may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever. I need more here.
Right.
I understand that this is a good faith argument, but spoliation requires findings, and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and prejudice.
Right.
And we don't have that evidentiary showing.
Well, we definitely have duty. We definitely have that it's material. I think the only thing that's in question is the breach, right? Like, to what level of culpability was the breach? And
or was it breached at all? I mean, there are things such as rule-based preservation schedules that absent, for example, your client certainly knew that the body was taken. Right. She had an opportunity to ask, what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying. You know, it puts us in a position where we might have to have, like,
And to be clear, you are not limited from making the arguments you just made to me to the jury.
Oh, we will.
Where's the bottle?
Right. No, we'll definitely do that. But what I want is the inference that you got to assume it helped us.
That is, I sit here today, I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay. If we're able to obtain that for you prior to Monday, can we submit that in writing?
I'm certainly not going to be closed-minded.
Okay. Thank you, Your Honor. Understood.
I'm not making any predictions one way or the other.
Okay.
Mr. Burmester, anything else on the record today?
Yes, I just wanted to add a requirement that there be a showing of reasonable probability the lost evidence would have been exculpatory.
Right.
I don't know why fentanyl would have to be stored in another opioid package. I mean, the testimony was that it came in envelopes, for example. So I would just add that to the argument.
I understand. That is among the reasons I am proceeding with appropriate caution here, given the findings that the court would need to make in any spoliation situation, alleged spoliation situation.
Right.
Ms. Nestel, you've, by proximity, asserted yourself a little bit. Maybe, do you want to talk to Fred for a minute? And I don't know that you have standing to weigh in.
After you've resolved all of this, I just had a request.
No problem. I'm happy to hear you out in just a second.
Thank you.
Okay. Anything further on that issue, Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. All right. Counsel, on my list, any objection to exchanging slide decks related to your closing arguments by sometime on Sunday afternoon or evening?
We actually talked to Mr. Bloodworth about this already, and both sides decided we didn't want to exchange them.
Okay.
So
fine.
we're good.
Is that your understanding, Mr. Burmester?
I have no understanding of that.
Okay. I'm going to take you at your word on that, Ms. Nestor. All right.
I'll confirm it again and make sure he hasn't changed his mind. But if he does, what is the time you want us to?
Whatever you all agree to.
Okay. We'll do it.
I'm inclined to order it if you folks want it, but if you've agreed to proceed in a different fashion, that's fine.
We kind of had a conversation about it when we called on 4 o'clock yesterday, and I mean, opening is different because opening, nothing's come into evidence yet, and both sides are very concerned about what's showed to a jury before anything's come in, and we were all very concerned about swapping. We fleshed that out about closing, and we all just are taking the position, we know what's in now, you can put what's in, and if you want to use some creative little thing that is just for demonstrative purposes, the other side's not going to be able to object to that anyway, so we're fine.
Okay. With respect to exhibits, defense exhibits, Brittany has a handle on. She thinks she has all of them.
Great.
The state's exhibits, she's going to need to interact with the state's team to make sure she gets a bunch. And because the number of state's exhibit is so much larger and they're of varying kinds, there may be some back and forth about that while you're all doing your reading instructions and closing arguments. And so if Mr. Burmester, if you can just make sure the state's, whoever's in charge of that for the state
Ms. Steele was here trying to talk to...
She's back there.
So Brittany's not here this afternoon, but if you can keep your eyes on your email and be present on Monday morning, she'll need your help.
I can wait till Monday.
If you want me to leave it on her desk for her, I'm happy to do it. Okay.
Also, we've been trying really hard to keep track of what we believe has been admitted, just to have a backup. So if we could just, before the exhibits go back, give us a few minutes to make sure we're all in agreement that that's what should go back. And we have a list, we're ready to go. It shouldn't take long, but I would ask the chance to review it before it goes back.
It's my expectation that will take longer than a few minutes and will involve somebody from both sides of the beat, Brittany, after closing is complete.
Perfect, thank you.
Some of the exhibits are audiovisual files.
They are.
They need to be on a single thumb drive if possible, or as few thumb drives as possible. The court has an air-gapped laptop that the jury can use to view them. We'll just want to make sure that it works.
And we're fine, Ms. Steele, if you want to provide to us on box what the video ones are, so you don't have to do a thumb drive, that's fine. Just let us know where you put it on box, okay?
I think they need the thumb drive for...
The jury does.
The jury, but I don't want you to waste money on us. You can just put it on box.
And then, notwithstanding our conversation regarding the 900 pages of Carmen Lauber's interviews, turns out there are a lot more transcripts that were admitted than I recalled. Several that are companions to the audiovisual files. As I understand it, there's no objection to those going back to the jury, correct? Because they're not in court testimony. They were admitted as exhibits. They're going back, correct, Mr. Burmester?
Yes.
I believe so, but I will check with that. I mean, we were. There weren't too many transcripts. Most of them were redacted transcripts that we had all agreed on, like the.
Understood. They're all portions.
Right.
For example,
good. I was like, just
there were
panicky.
several recorded phone calls.
Right.
All of them have a companion transcript.
We did agree to those.
Okay.
The parties did, but now I'm panicking if there was accidentally some big transcript that slid back past us that we didn't see.
I don't think so. Brittany just wanted to confirm, based upon the conversation we had on the record, where I expressed some concern about a particularly lengthy or complete transcript getting undue influence.
Right.
She just wanted to make sure that she understood the state of affairs.
No,
if it's been admitted as an exhibit, it goes
back.
to the jury.
Right.
Yeah.
I agree.
Okay. All right. Anything else today, Mr. Burmester?
No.
Ms. Nestor?
I assume, since we're doing so good and we're so far ahead of schedule, that you're not putting a timer on our closings?
No.
Okay.
Not putting a timer on the jury either.
Okay.
All right. I'm going to have to do some breathing exercises before I dismiss the alternates, but it'll be all right.
I know. It's pretty amazing we haven't lost a juror in
They are
a 3-week
a hardy
trial.
group. And I'll make clear to them that they're not released.
Yeah.
They need to abide by all the rules in case somebody falls ill, suffers a tragedy during deliberations.
Right.
All right. I appreciate your time and effort this morning, Ms. afternoon, Ms. Nestel. Sure. Happy to listen.
As you know, I represent the victims in this case who are here today. They've been here every day filling the row. We have a special request for Monday. I don't know if it'll deviate from the court's decorum order, but if it does, we think it warrants a special decision or order from the court. And that is, we're asking for the victim's family to be able to take that second and even third row during the closing arguments. Of course, nobody can anticipate when the case was going to close or when closing arguments would be, but that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum order. This is really important for them. There were a lot of witnesses who were subpoenaed and weren't able to come in, maybe didn't even end up testifying, but they want to come as well. So during the pretrial proceedings, the victim's family had 2 rows that they filled regularly, and there are a lot of people who loved Eric and supported him and who would like to be here that day. And to prevent people from having to camp out all night at the court's doorstep just to make sure that they get in, our request would be that they get the second and third row designated.
Chris, have we handed out wristbands for Monday yet?
No, sir. Our plan is to hand them out for the decorum order back before 0800.
So I'm just going to sound this out in real time. What I can't do is change the rules regarding odd and even midstream based upon genuine empathy for one side or the other. But I can steal some rows back from people that do not have a familiar connection to the case. And so, Chris, it sounds like I could say rows 2 and 3 are going to be for whoever would have gotten row 2 in on whatever odd or even day Monday is, and rows 4 and 5 can be for whomever was going to get it on that day. So I can double the amount of space. I just can't switch the order.
Okay, and I think possibly the defendant's family would have been on Monday. Of course, again, we didn't know the trial was going to end, or that important day would be
certainly
on Monday.
Yeah.
If those rows are not filled, can those seats be filled.
No, it makes it very hard for court staff to manage who's sitting where and to make sure that everybody is behaving. So I got to have clear rules, but I can double the space. I mean, let's be clear. What I'd be doing is excluding the rest of the public.
Right.
But let's put it blank. Instead of 1 row for Miss Kouri Richins' family, 2 rows for the public, 1 row for Eric Richins' family, it would be 1 row for the media, 2 rows for Kouri Richins' family, and guests, and 2 rows for Eric Richins' family and guests.
Okay, thank you.
Chris, now that I've said that out loud, that's an idea. I got to make sure I did not create any trouble.
I have to deal with the public.
Well, we can send something out, right?
Yeah.
I imagine that I could ask our media partners to help me spread the word. So we'll get to that. Okay.
So I'm happy to talk to Ms. Richens' family and see if they need that second row. And if they don't, I can communicate with Mr. Palmer and tell him there will be 1 row for the public.
I'm probably just going to make this decision now so there's no ambiguity so we can get ahead of it.
Okay.
So that people aren't coming to the courthouse 2 days from now with an expectation.
Okay.
Will you give me 5 minutes to talk to Chris to make sure I'm not working at cross purposes with the security plan?
Yes.
All right, let me take a 5-minute break, folks. Thank you.
All right.
Yes, Judge, come talk to me. What's the story? Judge wants to come talk to me. Chris has to deal with the public. Well, oh my goodness. All right, so now they're haggling over. Well, that was the victim advocate, if you will, and remember the pitch? Yes. Ola, oh my gosh, what was the pitch? Oh yes, Judge Mrazek. Ola would like to hear you out in the wild, to use one of your terms. You on an airplane, not being able to get a seat, you having road rage. We want to hear you out in the wild. How do you sound out in the wild? Like if you order a salad and there's a bug in your salad, how do you send your salad back to the chef and say, you know what? Sorry, there's a bug in my salad. How would you do that? Sorry, there's a bug in my salad. Like, how would you do that? And if somebody cuts you off, you're driving along, right? You're doing your thing, you're driving along. Somebody cuts you off. Do you yell at them? Do you curse at them? Ordering a pizza. Judge, we'd like to hear you order a pizza. Okay. I put our request in, Ola. We'd like to hear you order a pizza. Iowa backyard. Yep, I'm PR now. Joe, what was that? What was your IO? What was it? No, information officer. Joe, what was your character? What was your IO at Lori's trial? Help me out, Joe. I forgot. What was his name? Let's see. Yes, Pammy, for sure. Yeah, no. I will definitely let Selena know. I will definitely. I'll text her. I'll let her know for sure. Yeah, because Judge says he doesn't want the public to show up on Sunday night and be like, "Yep, nope, there's no seats for you." Yes, Aaron comes through. Vincent Fenori. Vincent Fenori. Waiter, there's a fly in my soup. But he'd be like, waiter, there's a fly in my soup. Oh my gosh, that's really funny. All right. Yes, we definitely. Selena, are you still with us? If not, I will. Is she still in our chat? No, she's not in our chat. All right, I'll definitely shoot her a text. Kathy, how long will defense close? You're guessing 5 hours? Oof. Gosh, I hope not. Their opening was 45 minutes. Maybe 2 hours? I'll go with 2 hours. Oh, and he's back. All right, he's back from talking with me. All right, Judge, what's the word?
Counsel, this is going to be the plan for closings on Monday and the period of jury deliberations. First row, as usual, will be for members of the media with authorization to have a seat in those rows. Whichever family, whether it's Eric Richens' family and guests or Kouri Richins' family and guests, is entitled under the current odd-even switching scheme to the first or to the second row will get the second and third. Whichever family and set of guests is entitled to the fifth will get the fifth and fourth. Keep in mind they're going to switch each day. So if the jury keeps deliberating into Tuesday, it'll be 2 and 3 versus 4 and 5 switches. Mr. Palmer, Court Security Director, will give counsel, defendant's counsel for defendant's family and guests, state's counsel for, unless you want to be the point person, Ms. Nestel, it's up to you.
I can do that just to take the burden off of that.
All right.
Yeah.
Ms. Nestel, on behalf of Eric Richens' family and guests, is going to give you 24 wristbands. And it's up to you who gets them. That'll be per day.
Thank you.
Okay? It means you got to be here, somebody from your team, and somebody, Ms. Nestel, you got to be here no later than 8 a.m. each day.
Yeah.
All right?
I'll do it.
Very good. We're all going to buy Chris Palmer chocolates and flowers because he's going to take some flack about this. I will issue an amended decorum order to make it clear this is the way we're doing things. It's the fair way to do it. To the extent you can include this in your reporting about what's coming on Monday, I'd appreciate it, just so people aren't showing up unnecessarily. Okay. All right. Anything else, Ms. Nestel?
No.
Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Folks, I appreciate your patience. Please travel safe. Ms. Richens, I'll see you Monday morning. Take care. Court's in recess. Thank you. Grace, I think you wanted to talk.
All right. That seems to be it. All right, so the upshot of all of that was that the media is going to get the first row, so they're going to keep it as is. So this is Monday going forward, and he's pretty much going to keep it the way it has been. So media is going to get row 1 with appropriate accreditation. So and then rows 2 and 3 are going to switch with rows 4 and 5. So one family gets 2 and 3, the other family gets 4 and 5, and then they switch. So they'll switch. So one, whoever is up next, I don't know. I guess they've been going with Kouri gets 2 and 3 one day, and then she gets 4 and 5 the next day, and then vice versa. So I don't know which day they're on. I'm not sure if it's going to be Kouri's family gets 2 and 3 on Monday, or if Eric's family. Well, we'll find out when we watch. When we watch on Monday, we'll see who is sitting in rows 2 and 3. So, yeah, all right, that's pretty much it. So the big takeaways are going to be no timer on closings. That's the huge thing. The 900 pages of Carmen's interview is going back with the jury. They went over instructions. There was really nothing spectacular there that I can really think of, other than they kind of haggled over the use of informant with Carmen and Crozier. And 8:30. They start at 8:30. So yeah, I think that's about it, you guys. I think that's about it. Really, really appreciate you spending your day with us. What did you lose? We lost what? Watch for a towing cost? What did we lose? We lost what? Oh, here. Grampy, if you're still around, here's Super Ball for you. Here's my notes. Got my notes right there. Hey, you. Yeah, it's a good girl. Oh, it's a good girl. Yeah. Come say goodnight. Say goodbye to Grampy. Oh. Come say goodbye to Grampy. Hey. Nope. All right, she's floating off over there. All right. Thank you guys for spending your day with us. This was a fantastic day. We are at 19,303. We are at 19,303. I think we hit 19,000 last night at 11. So within 24 hours, we gained 300 subscribers. So thank you guys. Really appreciate it. Thank you for spending your day with us. Thank you for the great chat. I had a great time talking with you about music. Had a great time sharing Super Bowl with you guys. And just had a lot of fun hanging out with you guys. So really appreciate it. Thank you to our mods for keeping this our chat, respectful, courteous, kind, and all you new people coming in. You guys were great. Really appreciate that. And thank you to Erin for doing shorts, for doing graphics, for doing descriptions, for running her business over there, this business over here. Erin does so much work, you guys have no idea. So much love to her. And I'm going to go enjoy a weekend of relaxation and rest. I'm going to get ready for next week. It promises to be probably fairly long. I hope that they start to deliberate on Monday, but if they can talk for as long as they want to, they may not start to deliberate on Monday. Who knows? I know a lot of you think it's going to be a quick deliberation. I don't know. We'll see. I'm going with 2 days. I'm gonna go with 2 days. I'm gonna go with 2 days. I may change. That may change over the weekend, but it may change. All right, you guys. Hellrider, Kathy, JMS, Linda, Downey, Colleen. Thank you guys so much. Mike, Crazy Mary Joe, Seashell. Have a great one, Pammy. Thank you. Cross Examnesia. Hola. Rock and Roll, Jenny G, Wyatt, Amanda. Thank you guys. Jadzia love you guys so much. Anthony, have a great evening. We'll see you Monday, 10:15 Eastern. So it's going to be, they start at 8:30 Mountain Time, which is 10:30 our time. So we come on at 15 minutes before. So Nana, Ambi, Skrubnik, have a good one, you guys. All right, yeah, definitely a poll. We'll definitely do a poll, Hellrider, for sure. All right, you guys, have a great evening. Enjoy yourselves. Go and look up at the stars. Take a walk on the beach. Walk in the grass. Have a snowball fight. Do something, to rebalance yourself, recalibrate yourself. And we'll see you guys on Monday. All right, take care, guys. Bye.